Section 1 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Susan B. Anthony for voting at a congressional election, New York, 1873, Part 1. The narrative. At the election of President and Vice President of the United States and members of Congress in November 1872, Susan B. Anthony and several other women offered their votes to the inspectors of election at the city of Rochester, New York, claiming the right to vote as among the privileges and immunities secured to them as citizens by the 14th Amendment to the Constitution of the United States. Two of the three inspectors of election decided in favor of receiving the offered votes, and they were received and deposited in the ballot box. For this act, the women, 14 in number, were arrested and held to bail, and indictments were found against them severally, under the Act of Congress of 1870, charging them with the offense of knowingly voting without having a lawful right to vote. Of the women voters, the case of Miss Anthony alone was brought to trial, a nolle prosequi, having been entered upon the other indictments. Upon her trial, it was proved that before offering her vote she was advised by her counsel that she had a right to vote, and that she entertained no doubt at the time of voting that she was entitled to vote. It was claimed in her behalf, 1, that she was legally entitled to vote, 2, that if she was not so entitled, but voted in good faith in the belief that it was her right, she was guilty of no crime. 3, that she did vote in such good faith and with such belief. But the court held that the defendant had no right to vote, that good faith constituted no defense, that there was nothing in the case for the jury to decide, and directed them to find a verdict of guilty, refusing to submit at the request of the defendant's counsel any question to the jury, or to allow the clerk to ask the jurors severally whether they assented to the verdict which the court had directed to be entered. The verdict of guilty was entered by the clerk, as directed by the court, without any express assent or dissent on the part of the jury, and a fine of $100 in costs was imposed upon Miss Anthony. The trial. Footnote. Account of the proceedings on the trial of Susan B. Anthony on the charge of illegal voting at the presidential election of November 1872, and on the trial of Beverly W. Jones, Edwin T. Marsh, and William B. Hall, the inspectors of election by whom her vote was received. Rochester, New York Daily Democrat and Chronicle book print, 3 West Main Street. An appendix contains 2 addresses of 25 pages each, by Miss Anthony and Matilda Jocelyn Gage, delivered at about 50 public meetings held before the trial, and a criticism by John Hooker of Hartford, Connecticut, of the conduct of the trial. End of footnote. In the United States Circuit Court, Northern District of New York, Canandaigua, New York, June 1873. Honorable Ward Hunt, Judge. Footnote. Hunt Samuel Ward, 1810 to 1886, born Utica, New York, graduated Union College 1828, studied law at Litchfield, Connecticut, practiced law at Utica, New York, member of New York Legislature 1839, mayor of Utica, New York 1844, judge of New York Court of Appeals 1855, Associate Justice Supreme Court of the United States 1872 to 1882, LLD, Union and Rutledge Colleges. End of footnote. June 17th. In the previous month of January, the grand jury for the Northern District of New York, United States Circuit Court, had returned an indictment against Susan B. Anthony. Footnote. Anthony, Susan Brownell, 1820 to 1906. Born South Adams, Massachusetts, the daughter of a Quaker cotton manufacturer. Her father removed to Rochester, New York in 1846, and she taught school there from 1835 to 1850. In 1852, she began the agitation for female suffrage, and in 1857 became a leader. She was influential in procuring legislation giving rights to married women, and in 1865 founded The Revolutionist, a journal devoted to the emancipation of women. She was delegate to the International Council of Women in 1899. In 1900, her birthday was celebrated at Washington, and she retired from the presidency of the National American Women's Suffrage Association, which she had held for many years. See History of Women's Suffrage, edited by Elizabeth Cady Stanton, Susan B. Anthony, and Matilda Jocelyn Gage, 3 volumes, Rochester, New York, 1887. End of footnote. For voting illegally at an election held for members of the Congress of the United States in the city of Rochester on November 5, 1872. Footnote. The jurors of the said district then and there sworn and charged to inquire for the said United States of America, and for the body of said district, do upon their oaths present, that Susan B. Anthony now or late of Rochester, in the county of Monroe, with force and arms, etc., to wit, at and in the first election district of the 8th Ward of the city of Rochester, in the county of Monroe, in said Northern District of New York, and within the jurisdiction of this court, heretofore to wit, on the 5th day of November in the year of our Lord 1872, at an election duly held at and in the first election district of the said 8th Ward of the city of Rochester, in said county, and in said Northern District of New York, which said election was for representatives in the Congress of the United States, to wit, a representative in the Congress of the United States for the state of New York at large, and a representative in the Congress of the United States for the 29th Congressional District of the state of New York, said first election district of said 8th Ward of said city of Rochester, being then and there a part of said 29th Congressional District of the state of New York, did knowingly, wrongfully, and unlawfully vote for a representative in the Congress of the United States for the state of New York at large, and for a representative in the Congress of the United States for said 29th Congressional District, without having a lawful right to vote in said election district. The said Susan B. Anthony, being then and there a person of the female sex, as she, the said Susan B. Anthony, then and there well knew, contrary to the form of the statute of the United States of America, in such case made and provided, and against the peace of the United States of America and their dignity. And the juries aforesaid, upon their oaths aforesaid, do further present that said Susan B. Anthony, now or late of Rochester, in the county of Monroe, with force and arms, etc., to wit, at and in the first election district of the 8th Ward of the city of Rochester, in the county of Monroe, in said Northern District of New York, and within the jurisdiction of this court, heretofore, to wit, on the 5th day of November in the year of our Lord 1872, and an election duly held at and in the first election district of the said 8th Ward of said city of Rochester in said county, and in said Northern District of New York, which said election was for representatives in the Congress of the United States, to wit, a representative in the Congress of the United States of the state of New York at large, and a representative in the Congress of the United States of the 29th Congressional District of the state of New York, said first election district of said 8th Ward of said city of Rochester, being then and there a part of said 29th Congressional District of the state of New York, did knowingly, wrongfully, and unlawfully vote for a candidate for representative in the Congress of the United States for the state of New York at large, and for a candidate for representative in the Congress of the United States for said 29th Congressional District, without having a lawful right to vote in said first election district, the said Susan B. Anthony, being then and there a person of the female sex, as she, the said Susan B. Anthony, then and there well knew, contrary to the form of the statute of the United States of America, in such case made and provided, and against the peace of the United States of America and their dignity. End of footnote. The defendant had pleaded not guilty, and a jury having been impaneled, the trial was begun today. Richard Crowley, United States District Attorney for the government. Footnote. Crowley Richard, born 1836, Lockport, New York, admitted to bar 1860. City Attorney, Lockport, 1865. Member New York Senate, 1865 to 1870. United States District Attorney, 1871 to 1879. Member United States Congress, 1880. End of footnote. Henry R. Selden and John Van Voorhis for the defendant. Footnote. Selden Henry Rogers, 1805 to 1885. Born Lynn, Connecticut. Admitted to bar of New York, 1825. Judge Common Pleas, Rochester. Judge Supreme Court, 1847. Reporter New York Court of Appeals, 1851 to 1854. Judge Court of Appeals of New York, 1856 to 1864. Van Voorhis, John, born Decatur, New York, 1828. Practiced law first at Elmira and then at Rochester. City Attorney, Rochester, 1859. Collector of Inland Revenue, 1862. Member of Congress, 1878 to 1884. End of footnote. Mr. Crowley. Gentlemen of the jury, on the 5th of November, 1872, there was held in this state, as well as in other states of the Union, a general election for different officers, and among those, the candidates to represent several districts of this state in the Congress of the United States. The defendant, Miss Susan B. Anthony, at that time resided in the city of Rochester, in the county of Monroe, Northern District of New York, and upon the 5th day of November, 1872, she voted for a representative in the Congress of the United States to represent the 29th Congressional District of this state, and also for a representative at large for the state of New York, to represent the state in the Congress of the United States. At that time, she was a woman. I suppose there was no question about that. The question in this case, if there be a question of fact about it at all, will, in my judgment, be rather a question of law than one of fact. I suppose that there will be no question of fact, substantially, in the case when all of the evidence is out, and it will be for you to decide under the charge of His Honor, the judge, whether or not the defendant committed the offense of voting for a representative in Congress upon that occasion. We think, on the part of the government, that there is no question about it either one way or the other, neither a question of fact nor a question of law, and that whatever Miss Anthony's intentions may have been, whether they were good or otherwise, she did not have a right to vote upon that question. And if she did vote without having a lawful right to vote, then there is no question but what she is guilty of violating a law of the United States in that behalf, enacted by the Congress of the United States. We don't claim in this case, gentlemen, that Miss Anthony is of that class of people who go about repeating. We don't claim that she went from place to place for the purpose of offering her vote. But we do claim that upon the 5th of November, 1872, she voted, and whether she believed that she had a right to vote or not, it being a question of law, that she is within the statute. Congress in 1870 passed the statute under which this case is brought. Footnote. See post, page 9, opening of Mr. Selden's argument. End of footnote. It is not necessary for me, gentlemen, at this stage of the case, to state all the facts which will be proven on the part of the government. I shall leave that to be shown by the evidence and by the witnesses, and if any question of law shall arise, His Honor will undoubtedly give you instructions as he shall deem proper. The witnesses for the United States. Beverly W. Jones resided in Rochester and was an inspector of elections on November 5, 1872, of the 1st District. The other inspectors were Edward T. Marsh and William B. Hall. Saw Miss Anthony vote the state, assembly, congressional, and presidential election tickets. I received the ballots from her and put them in the separate boxes provided. Nobody challenged her vote at that time. To Mr. Selden. The voters had been previously registered by myself and the other members of the Board of Registry. Miss Anthony appeared before us and asked to be registered, but it was objected that as she was not a male citizen, she could not register. But we decided in her favor and registered her name. One of the United States Supervisors of Elections agreed with us. The other did not. To Mr. Crowley. When Miss Anthony was challenged before the Board of Registry, she took the oath that she was a legal voter. She said she did not claim her right under the laws of New York, but under the 14th Amendment to the United States Constitution. The poll list, which I have in my hand, shows that she voted the electoral, state, congressional, and assembly tickets. Mr. Selden. Gentlemen of the jury, this is a case of no ordinary magnitude, although many might regard it as one of little importance. The question whether my client here has done anything to justify her being consigned to a felon's prison or not is one that interests her very essentially, and that interests the people also essentially. I claim and shall endeavor to establish before you that when she offered to have her name registered as a voter, and when she offered her vote for member of Congress, she was as much entitled to vote as any man that voted at that election, according to the Constitution and laws of the government under which she lives. If I maintain that proposition as a matter of course, she has committed no offense, and is entitled to be discharged at your hands. But beyond that, whether she was a legal voter or not, whether she was entitled to vote or not, if she sincerely believed that she had a right to vote, and offered her ballot in good faith, under that belief, whether right or wrong, by the laws of this country she is guilty of no crime. I apprehend that that proposition, when it is discussed, will be maintained with the clearness and force that shall leave no doubt upon the mind of the court, or upon your minds as the gentlemen of the jury. If I maintain that proposition here, then the further question, and the only question which in my judgment can come before you to be passed upon by you, as a question of fact, is whether or not she did vote in good faith, believing that she had a right to vote. The public prosecutor assumes that, however honestly she may have offered her vote, however sincerely she may have believed that she had a right to vote, if she was mistaken in that judgment, her offering her vote and its being received makes a criminal offense, a proposition to me most abhorrent, as I believe it will be equally abhorrent to your judgment. Before the registration, and before this election, Miss Anthony called upon me for advice upon the question whether, under the 14th Amendment of the Constitution of the United States, she had a right to vote. I had not examined the question. I told her I would examine and give her my opinion upon the question of her legal right. She went away and came again after I had made the examination. I advised her that she was as lawful a voter as I am, or as any other man is, and advised her to go and offer her vote. I may have been mistaken in that, and if I was mistaken, I believe she acted in good faith. I believe she acted according to her right as the law and Constitution gave it to her. But whether she did or not, she acted in the most perfect good faith, and if she made a mistake, or if I made one, that is not reason for committing her into a felon's cell. For the second time in my life, in my professional practice, I am under the necessity of offering myself as a witness for my client. Henry R. Selden. Before the last election, Miss Anthony called upon me for advice upon the question whether she was or was not a legal voter. I examined the question and gave her my opinion, unhesitatingly, that the laws and Constitution of the United States authorized her to vote, as well as they authorize any man to vote, advised her to have her name placed upon the registry and to vote at the election, if the inspector should receive her vote. I gave the advice in good faith, believing it to be accurate, and I believe it to be accurate still. Mr. Selden, I propose to call Miss Anthony as to the fact of her voting, on the question of the intention or belief under which she voted. Mr. Crowley, she is not competent as a witness in her own behalf. The court held the evidence incompetent. John E. Pound, called by the United States. During November and December 1872 and January 1873, I was Assistant United States District Attorney for the Northern District of New York, attended an examination before United States District Attorney Stores in Rochester, where Miss Anthony was examined as a witness in her own behalf. Mr. Crowley, did she, upon that occasion, state that she consulted or talked with Judge Henry R. Selden of Rochester in relation to her right to vote? Mr. Selden, I object to that upon the ground that it is incompetent, that if they refuse to allow her to be sworn here, they should be excluded from producing any evidence that she gave elsewhere, especially when they want to give the version which the United States officer took of her evidence. The court, go on. Mr. Crowley, did she state on that examination, under oath, that she had talked or consulted with Judge Henry R. Selden in relation to her right to vote? Was she asked upon that examination if the advice given her by Judge Henry R. Selden would or did make any difference in her action in voting, or in substance that? She stated on the cross-examination, I should have made the same endeavor to vote that I did, had I not consulted Judge Selden. I didn't consult anyone before I registered. I was not influenced by his advice in the matter at all. Have been resolved to vote the first time I was at home 30 days for a number of years. Mr. Van Voorhis, was she asked there if she had any doubt about her right to vote, and did she answer, not a particle? She stated, had no doubt as to my right to vote on the direct examination. There was a stenographic reporter there, was there not? A reporter was there taking notes. Was not this question put to her? Did you have any doubt yourself of your right to vote? And did she not answer, not a particle? The court, well, he says so, that she had no doubt of her right to vote. Mr. Selden, I beg leave to state in regard to my own testimony, Miss Anthony informs me that I was mistaken in the fact that my advice was before her registry. It was my recollection that was on her way to the registry, but she states to me now that she was registered and came immediately to my office. In that respect, I was under a mistake. End of section 1. Section 2 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Susan B. Anthony for voting at a congressional election. New York, 1873, Part 2. Mr. Selden. The defendant is indicted under the 19th section of the Act of Congress of May 31, 1870, for voting without having a lawful right to vote. The words of the statute, so far as they are material in this case, are as follows. If at any election for representative or delegate in the Congress of the United States, any person shall knowingly vote without having a lawful right to vote, every such person shall be deemed guilty of a crime, and on conviction thereof shall be punished by a fine not exceeding $500, or by imprisonment for a term not exceeding 3 years, or by both, in the discretion of the court, and shall pay the costs of prosecution. The only alleged ground of illegality of the defendant's vote is that she is a woman. If the same act had been done by her brother under the same circumstances, the act would have been not only innocent, but honorable and laudable. But having been done by a woman, it is said to be a crime. The crime therefore consists not in the act done, but in the simple fact that the person doing it was a woman and not a man. I believe this is the first instance in which a woman has been arraigned in a criminal court, merely on account of her sex. If the advocates of female suffrage had been allowed to choose the point of attack to be made upon their position, they could not have chosen it more favorably for themselves. And I am disposed to thank those who have been instrumental in this proceeding for presenting it in the form of a criminal prosecution. Women have the same interest that men have in the establishment and maintenance of good government. They are to the same extent as men bound to obey the laws. They suffer to the same extent by bad laws, and profit to the same extent by good laws, and upon principles of equal justice, as it would seem, should be allowed equally with men to express their preference in the choice of lawmakers and rulers. But however that may be, no greater absurdity, to use no harsher term, could be presented than that of rewarding men and punishing women for the same act, without giving to women any voice in the question which could be rewarded and which punished. I am aware, however, that we are here to be governed by the Constitution and laws as they are, and that if the defendant has been guilty of violating the law, she must submit to the penalty, however unjust or absurd the law may be. But courts are not required to so interpret laws or constitutions as to produce either absurdity or injustice, so long as they are open to a more reasonable interpretation. This must be my excuse for what I designed to say in regard to the propriety of female suffrage, because with that propriety established, there is very little difficulty in finding sufficient warrant in the Constitution for its exercise. This case, in its legal aspects, presents three questions which I propose to discuss. 1. Was the defendant legally entitled to vote at the election in question? 2. If she was not entitled to vote, but believed that she was, and voted in good faith in that belief, did such voting constitute a crime under the statute before referred to? 3. Did the defendant vote in good faith in that belief? If the first question be decided in accordance with my views, the other questions become immaterial. If the second be decided adversely to my views, the first and third become immaterial. The two first are questions of law to be decided by the court. The other is a question for the jury. The court. I suggest that the argument be confined to the legal questions, and the argument on the other questions suspended, until my opinion on those questions shall be made known. Mr. Selden, my first position is that the defendant had the same right to vote as any other citizen who voted at that election. Before proceeding to the discussion of the purely legal question, I desire, as already intimated, to pay some attention to the propriety and justice of the rule which I claim to have been established by the Constitution. Miss Anthony, and those united with her in demanding the right of suffrage, claim, and with a strong appearance of justice, that upon the principles upon which our government is founded, and which lie at the basis of all just government, every citizen has a right to take part, upon equal terms with every other citizen, in the formation and administration of government. This claim on the part of the female sex presents a question, the magnitude of which is not well appreciated by the writers and speakers who treat it with ridicule. Those engaged in the movement are able, sincere, and earnest women, and they will not be silenced by such ridicule, nor even by the villainous caricatures of Nast. Footnote: Nast Thomas, born 1840 in Bavaria, but began his career as a caricaturist very early in his life in New York, and his cartoons in Harper's Weekly made him famous for many years all over the land. End of footnote. On the contrary, they justly place all those things to the account of the wrongs which they think their sex has suffered, They believe with an intensity of feeling which men who have not associated with them have not yet learned, that their sex has not had and has not got its just and true position in the organization of government and society. They may be wrong in their position, but they will not be content until the arguments are fairly, truthfully, and candidly answered. In the most celebrated document which has been put forth on this side of the Atlantic, our ancestors declared that governments derive their just powers from the consent of the governed. Blackstone says the lawfulness of punishing such criminals, i.e., persons offending merely against the laws of society, is founded upon this principle, that the law by which they suffer was made by their own consent. It is a part of the original contract into which they entered when first they engaged in society. It was calculated for and has long contributed to their own security. Quotations, to an unlimited extent, containing similar doctrines from eminent writers, both English and American, on government, from the time of John Locke to the present day, might be made, without adopting this doctrine which bases the rightfulness of government upon the consent of the governed. I claim that there is implied in it the narrower and unassailable principle that all citizens of a state, who are bound by its laws, are entitled to an equal voice in the making and execution of such laws. The doctrine is well stated by Godwin in his treatise on political justice. He says, the first and most important principle that can be imagined, relative to the form and structure of government, seems to be this, that as government is a transaction in the name and for the benefit of the whole, every member of the community ought to have some share in its administration. Again, government is a contrivance instituted for the security of individuals, and it seems both reasonable that each man should have a share in providing for his own security, and probably that partiality and cabal should by this means be most effectually excluded. And again, to give each man a voice in the public concerns comes nearest to that admirable idea, of which we should never lose sight, the uncontrolled exercise of private judgment. Each man would thus be inspired with the consciousness of his own importance, and the slavish feelings that shrink up the soul in the presence of an imagined superior would be unknown. The mastery which this doctrine, whether right or wrong, has acquired over the public mind, has produced as its natural fruit the extension of the right of suffrage to all the adult male population in nearly all the states of the Union, a result which was well epitomized by President Lincoln in the expression, government by the people, for the people. This extension of the suffrage is regarded by many as a source of danger to the stability of free government. I believe it furnishes the greatest security for free government, as it deprives the mass of the people of all motive for revolution, and that government so based is most safe, not because the whole people are less liable to make mistakes in government than a select few, but because they have no interest which can lead them to such mistakes, or to prevent their correction when made. On the contrary, the world has never seen an aristocracy, whether composed of few or many, powerful enough to control a government, who did not honestly believe that their interest was identical with the public interest, and who did not act persistently in accordance with such belief. And unfortunately, an aristocracy of sex has not proved an exception to the rule. The only method yet discovered of overcoming this tendency to the selfish use of power, whether consciously or unconsciously, by those possessing it, is the distribution of the power among all who are its subjects. Short of this, the name free government is a misnomer. This principle, after long strife, not yet entirely ended, has been, practically at least, very generally recognized on this side of the Atlantic, as far as relates to men. But when the attempt is made to extend it to women, political philosophers and practical politicians, those inside of politics, two classes not often found acting in concert, join in denouncing it. It remains to be determined whether the reasons which have produced the extension of the franchise to all adult men do not equally demand its extension to all adult women. If it be necessary for men that each should have a share in the administration of government for his security, and to exclude partiality, as alleged by Godwin, it would seem to be equally, if not more, necessary for women on account of their inferior physical power. And if, as is persistently alleged by those who sneer at their claims, they are also inferior in mental power, that fact only gives additional weight to the argument in their behalf, as one of the primary objects of government, as acknowledged on all hands, is the protection of the weak against the power of the strong. I can discover no ground consistent with the principle on which the franchise has been given to all men, upon which it can be denied to women. The principal argument against such extension, so far as argument upon that side of the question has fallen, under my observation, is based upon the position that women are represented in the government by men, and that their rights and interests are better protected through that indirect representation than they would be by giving them a direct voice in the government. The teachings of history in regard to the condition of women under the care of these self-constituted protectors, to which I can only briefly allude, show the value of this argument as applied to past ages, and in demonstration of its value as applied to more recent times, even at the risk of being tedious, I will give some examples from my own professional experience. I do this because nothing adds more to the efficacy of truth than the translation of the abstract into the concrete. Withholding names, I will state the facts with fullness and accuracy. An educated and refined woman, who had been for many years before deserted by her drunken husband, was living in a small village of western New York, securing by great economy and intense labor in fine needlework the means of living and of supporting her two daughters at an academy, the object of her life being to give them such an education as would enable them to become teachers, and thus secure to them some degree of independence which she could no longer provide for them. The daughters were good scholars and favorites in the school, so long as the mother was able to maintain them there. A young man, the nephew and clerk of a wealthy but miserly merchant, became acquainted with the daughters and was specially attentive to the older one. The uncle disapproved of the conduct of his nephew, and failing to control it by honorable means, resorted to the circulation of the vilest slanders against mother and daughters. He was a man of wealth and influence. They were almost unknown. The mother had but recently come to the village, her object having been to secure to her daughters the educational advantages which the academy afforded. Poverty, as well as perhaps an excusable if not laudable pride, compelled her to live in obscurity, and consequently the assault upon their characters fell upon her and her daughters with crushing force. Her employment mainly ceased, her daughters were of necessity withdrawn from school, and all were deprived of the means from their own exertions of sustaining life. Had they been in fact the harlots which the miserly scoundrel represented them to be, they would not have been so utterly powerless to resist his assault. The mother, in her despair, naturally sought legal redress, but how was it to be obtained? By the law, the wife's rights were merged in those of the husband. She had in law no individual existence, and consequently no action could be brought by her to redress the grievous wrong. Indeed, according to the law, she had suffered no wrong, but the husband had suffered all, and was entitled to all the redress. Where he was, the lady did not know. She had not heard from him for many years. Her counsel, however, ventured to bring an action in her behalf, joining the husband's name with hers, as the law required. When the cause came to trial, the defendant made no attempt to sustain the charges which he had made, well knowing they were as groundless as they were cruel. But he introduced and proved a release of the cause of action, signed by the husband, reciting a consideration of $50 paid to him. The defendant's counsel had some difficulty in proving the execution of the release, and was compelled to introduce as a witness the constable who had been employed to find the vagabond husband and obtain his signature. His testimony disclosed the facts that he found the husband in the forest in one of our northeastern counties, engaged in making shingles, presumably stealing timber from the public lands and adverting it into the means of indulging his habits of drunkenness. And only $5 of the 50 mentioned in the release had in fact been paid. The court was compelled to hold, that the party injured in view of the law had received full compensation for the wrong, and the mother and daughters with no means of redress were left to starve. This was the act of the representative of the wife and daughters to whom we are referred, as a better protector of their rights than they themselves could be. It may properly be added that if the action had proceeded to judgment without interference from the husband, and such amount of damages had been recovered as a jury might have thought it proper to award, the money would have belonged to the husband, and the wife could not have lawfully touched a cent of it. Her attorney might, and doubtless would have paid it to her, but he could only have done so at the peril of being compelled to pay it again to the drunken husband if he had demanded it. In another case, 2 ladies, mother and daughter, sometime prior to 1860, came from an eastern county of New York to Rochester, where a habeas corpus was obtained for a child of the daughter, less than 2 years of age. It appeared on the return of the writ that the mother of the child had been previously abandoned by her husband, who had gone to a western state to reside, and his wife had returned with the child to her mother's house, and had resided there after her desertion. The husband had recently returned from the West, had succeeded in getting the child into his custody, and was stopping overnight with it in Rochester on the way to his western home. No misconduct on the part of the wife was pretended, and none on the part of the husband, excepting that he had gone to the West leaving his wife and child behind. No cause appearing, and had returned, and somewhat clandestinely obtained possession of the child. The judge, following Blackstone's view of husband's rights, remanded the infant to the custody of the father. He thought the law required it. Perhaps it did. But if mothers had had a voice, either in making or administering the law, I think the result would have been different. The distress of the mother on being thus separated from her child can be better imagined than described. The separation proved a final one, as in less than a year neither father nor mother had any child on earth to love or care for. Whether the loss to the little one of a mother's love and watchfulness had any effect upon the result cannot, of course, be known. The state of the law a short time since, in other respects in regard to the rights of married women, shows what kind of security had been provided for them by their assumed representatives. Prior to 1848, all the personal property of every woman on marriage became the absolute property of the husband. The use of all her real estate became his during coverture, and on the birth of a living child, it became his during his life. He could squander it in dissipation or bestow upon it harlots, and the wife could not touch or interfere with it. Prior to 1860, the husband could, by will, take the custody of his infant children away from the surviving mother and give it to whom he pleased, and he could in like manner dispose of the control of the children's property after his death, during their minority, without the mother's consent. In most of these respects, the state of the law has undergone great changes within the last 25 years. The property, real and personal, which a woman possesses before marriage, and such as may be given to her during coverture, remains her own, and is free from the control of the husband. If a married woman is slandered, she can prosecute in her own name the slanderer, and recover to her own use damages for the injury. The mother now has an equal claim with the father to the custody of their minor children, and in case of controversy on the subject, courts may award the custody to either in their discretion. The husband cannot now, by will, effectually appoint a guardian for his infant children without the consent of the mother, if living. These are certainly great ameliorations of the law, but how have they been produced? Mainly as the result of the exertions of a few heroic women, one of the foremost of whom is her who stands arraigned as a criminal before this court today. For 1,000 years, the absurdities and cruelties to which I have alluded have been embedded in the common law and in the statute books, and men have not touched them, and would not until the end of time, had they not been goaded to it by the persistent efforts of the noble women to whom I have alluded. Much has been done, but much more remains to be done by women. If they had possessed the elective franchise, the reforms which have cost them a quarter of a century of labor would have been accomplished in a year. They are still subject to taxation upon their property, without any voice as to the levying or destination of the tax, and are still subject to laws made by men, which subject them to fine and imprisonment for the same acts which men do with honor and reward. And when brought to trial, no woman is allowed a place on the bench or in the jury box, or a voice in her behalf at the bar. They are bound to suffer the penalty of such laws, made and administered solely by men, and to be silent under the infliction. Give them the ballot, and although I do not suppose that any great revolution will be produced, or that all political evils will be removed, I am not a believer in political panaceas. But if I mistake not, valuable reforms will be introduced which are not now thought of. Schools, almshouses, hospitals, drinking saloons, and those worse dens which are destroying the morals and the constitutions of so many of the young of both sexes, will feel their influence to an extent now little dreamed of. At all events, women will not be taxed without an opportunity to be heard, and will not be subject to fine and imprisonment by laws made exclusively by men for doing what it is lawful and honorable for men to do. It may be said in answer to the argument in favor of female suffrage, derived from the cases to which I have referred, that men, not individually but collectively, are the natural and appropriate representatives of women, and that, notwithstanding cases of individual wrong, the rights of women are, on the whole, best protected by being left to their care. It must be observed, however, that the cases which I have stated, and which are only types of thousands like them, in their cruelty and injustice, are the result of ages of legislation by these assumed protectors of women. The wrongs were less in the men than in the laws which sustained them, and which contained nothing for the protection of the women. End of section 2. Section 3 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Susan B. Anthony for voting at a congressional election. New York, 1873, Part 3. But passing this view, let us look at the matter historically and on the broader field. If Chinese women were allowed an equal share with the men in shaping the laws of that great empire, would they subject their female children to torture with bandaged feet through the whole period of childhood and growth, in order that they might be cripples for the residue of their lives? If Hindu women could have shaped the laws of India, would widows for ages have been burned on the funeral pyres of their deceased husbands? If Jewish women had had a voice in framing Jewish laws, would the husband, at his own pleasure, have been allowed to write his wife a bill of divorcement and give it in her hand, and send her out of his house? Would women in Turkey or Persia have made it a heinous, if not capital offense, for a wife to be seen abroad with her face not covered by an impenetrable veil? Would women in England, however learned, have been for ages subjected to execution for offenses for which men, who could read, were only subjected to burning in the hand and a few months' imprisonment? The principle which governs in these cases, or which has done so hitherto, has been at all times and everywhere the same. Those who succeed in obtaining power, no matter by what means, will, with rare exceptions, use it for their own exclusive benefit. Often, perhaps generally, this is done in the honest belief that such use is for the best good of all who are affected by it. A wrong, however, to those upon whom it is inflicted, is none the less a wrong by reason of the good motives of the party by whom it is inflicted. The condition of subjection in which women have been held is the result of this principle, the result of superior strength, not of superior rights on the part of men. Superior strength combined with ignorance and selfishness, but not with malice. It is a relic of the barbarism in the shadow of which nations have grown up. Precisely as nations have receded from barbarism, the severity of that subjection has been relaxed. So long as merely physical power governed in the affairs of the world, the wrongs done to women were without the possibility of redress or relief. But since nations have come to be governed by laws, there is room to hope, though the process may still be a slow one, that injustice in all its forms, or at least political injustice, may be extinguished. No injustice can be greater than to deny to any class of citizens not guilty of crime all share in the political power of a state, that is, all share in the choice of rulers, and in the making and administration of the laws. Persons to which such share is denied are essentially slaves, because they hold their rights, if they can be said to have any, subject to the will of those who hold the political power. For this reason it has been found necessary to give the ballot to the emancipated slaves. Until this was done, their emancipation was far from complete. Without a share in the political powers of the state, no class of citizens has any security for its rights, and the history of nations, to which I briefly alluded, shows that women constitute no exception to the universality of this rule. Great errors, I think, exist in the minds of both the advocates and the opponents of this measure, in their anticipation of the immediate effects to be produced by its adoption. On the one hand, it is supposed by some that the character of women would be radically changed, that they would be unsexed, as it were, by clothing them with political rights, and that instead of modest, amiable, and graceful beings, we should have bold, noisy, and disgusting political demagogues, or something worse, if anything worse can be imagined. I think those who entertain such opinions are in error. The innate character of women is the result of God's law, not of man's, nor can the laws of man affect that character beyond a very slight degree. Whatever rights may be given to them, and whatever duties may be charged upon them by human laws, their general character will remain unchanged. Their modesty, their delicacy, and intuitive sense of propriety will never desert them into whatever new positions their added rights or duties may carry them. So far as women, without change of character as women, are qualified to discharge the duties of citizenship, they will discharge them if called upon to do so, and beyond that will not go. Nature has put barriers in the way of any excessive devotion of women to public affairs, and it is not necessary that nature's work in that respect should be supplemented by additional barriers invented by men. Such offices as women are qualified to fill will be sought by those who do not find other employment, and others they will not seek, or if they do, will seek in vain. To aid in removing as far as possible the disheartening difficulties which women dependent upon their own exertions encounter, it is, I think, desirable that such official positions as they can fill should be thrown open to them, and that they should be given the same power that men have to aid each other by their votes. I would say, remove all legal barriers that stand in the way of their finding employment, official or unofficial, and leave them as men are left, to depend for success upon their character and abilities. As long as men are allowed to act as milliners, With what propriety can they exclude women from the post of school commissioners when chosen to such positions by their neighbors? To deny them such rights is to leave them in a condition of political servitude as absolute as that of the African slaves before their emancipation. This conclusion is readily to be deduced from the opinion of Chief Justice Jay in the case of Chisholm versus Georgia. Although the learned Chief Justice had, of course, no idea of any such application as I make of his opinion, the action was assumes it by a citizen of the state of South Carolina, and the question was whether the United States court had jurisdiction, the state of Georgia declining to appear. The Chief Justice, in the course of his opinion, after alluding to the futile idea of the character of the sovereign in England, and giving some of the reasons why he was not subject to suit before the courts of the kingdom, says, the same futile ideas run through all their jurisprudence, and constantly remind us of the distinction between the prince and the subject. No such ideas obtain here. At the Revolution, the sovereignty devolved on the people, and they are truly the sovereigns of the country, but they are sovereigns without subjects, unless the African slaves among us may be so called, and have none to govern but themselves. The citizens of America are equal as fellow citizens, and as joint tenants in the sovereignty. Now I beg leave to ask, in case this charge against Miss Anthony can be sustained, what equality and what sovereignty is enjoyed by the half of the citizens of these United States to which she belongs? Do they not, in that event, occupy politically exactly the position which the learned Chief Justice assigns to the African slaves? Are they not shown to be subjects of the other half, who are the sovereigns? And is not their political subjection as absolute as was that of the African slaves? If that charge has any basis to rest upon, the learned Chief Justice was wrong. The sovereigns of this country, according to the theory of this prosecution, are not sovereigns without subjects. Though 2 or 3 millions of their subjects have lately ceased to be such, and have become freemen, they still hold 20 millions of subjects in absolute political bondage. If it be said that my language is stronger than the facts warrant, I appeal to the record in this case for its justification. As deductions from what has been said, I respectfully insist first that upon the principles upon which our government is based, the privilege of the elective franchise cannot justly be denied to women. Second, that women need it for their protection. Third, that the welfare of both sexes will be promoted by granting it to them. Having occupied much more time than I intended in showing the justness and propriety of the claim made by my client to the privileges of a voter, I proceed to the consideration of the present state of the law on that subject. It would not become me, however clear of my own convictions may be on the subject, to assert the right of women, under our Constitution and laws as they now are, to vote at presidential and congressional elections is free from doubt, because very able men have expressed contrary opinions on that question. And so far as I am informed, there has been no authoritative adjudication upon it, or at all events, none upon which the public mind has been content to rest as conclusive. I proceed, therefore, to offer such suggestions as occur to me, and to refer to such authorities bearing upon the question as have fallen under my observation, hoping to satisfy your honor, not only that my client has committed no criminal offense, but that she has done nothing which she had not a legal and constitutional right to do. It is not claimed that, under our state constitution and the laws made in pursuance of it, women are authorized to vote at elections other than those of private corporations, and consequently, the right of Miss Anthony to vote at the election in question can only be established by reference to an authority superior to and sufficient to overcome the provisions of our state constitution. Such authority can only be found, and I claim that it is found, in the Constitution of the United States. I refer to the article requiring each state to appoint its senators and representatives, to the provision that the citizens of each state are entitled to the privileges and immunity of citizens of the several states, and to the 13th, 14th, and 15th Amendments. Article 1, Section 2. The House of Representatives shall be composed of members chosen every second year by the people of the several states, and the electors in each state shall have the qualification for electors of the most numerous branch of the state legislature. The same article, Section 3. The Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature thereof for 6 years, and each senator shall have 1 vote. Article 2, Section 1. Each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress. Article 4, Section 2. The citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states. The 13th Amendment says that neither slavery nor involuntary servitude, except as a punishment for crime, whereof the party shall have been duly convicted, shall exist within the United States, or any place subject to their jurisdiction, that all persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws, and that the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. By reference to the provisions of the original Constitution here recited, it appears that prior to the 13th, if not until the 14th Amendment, the whole power over the elective franchise, even in the choice of federal officers, rested with the states. The Constitution contains no definition of the term citizen, either of the United States or of the several states, but contents itself with the provision that the citizens of each state shall be entitled to all the privileges and immunities of citizens of the several states. The states were thus left free to place such restrictions and limitations upon the privileges and immunities of citizens as they saw fit, so far as is consistent with the Republican form of government, subject only to the condition that no state could place restrictions upon the privileges or immunities of the citizens of any other state, which would not be applicable to its own citizens under like circumstances. It will be seen, therefore, that the whole subject as to what should constitute the privileges and immunities of the citizen, being left to the states, no question such as we now present could have arisen under the original Constitution of the United States. But now, by the 14th Amendment, the United States have not only declared what constitutes citizenship, both in the United States and the several states, securing the rights of citizens to all persons born or naturalized in the United States, but have absolutely prohibited the states from making or enforcing any law which shall abridge the privileges or immunities of citizens of the United States. By virtue of this provision, I insist that the act of Miss Anthony in voting was lawful. It has never, since the adoption of the 14th Amendment, been questioned, and cannot be questioned, that women as well as men are included in the terms of its first section, nor that the same privileges and immunities of citizens are equally secured to both. What, then, are the privileges and immunities of citizens of the United States, which are secured against such abridgment by this section? I claim that these terms not only include the right of voting for public officers, but that they include that right as preeminently the most important of all the privileges and immunities to which the section refers. Among these privileges and immunities may doubtless be classed the right of life and liberty, to the acquisition and enjoyment of property, and to the free pursuit of one's own welfare, so far as such pursuit does not interfere with the rights and welfare of others. But what security has anyone for the enjoyment of these rights when denied any voice in the making of the laws, or in the choice of those who make and those who administer them? The possession of this voice in the making and administration of the laws, this political right, is what gives security and value to the other rights, which are merely personal, not political. A person deprived of political rights is essentially a slave, because he holds his personal rights subject to the will of those who possess the political power. This principle constitutes the very cornerstone of our government, indeed of all Republican government. Upon that basis, our separation from Great Britain was justified. Taxation without representation is tyranny. This famous aphorism of James Otis, although sufficient for the occasion when it was brought forth, expresses but a fragment of the principle, because government can be oppressive through means of many appliances besides that of taxation. The true principle is that all government over persons deprived of any voice in such government is tyranny. That is the principle of the Declaration of Independence. We were slow in allowing its application to the African race, and have been slower still in allowing its application to women. But it has been done by the 14th Amendment, rightly construed by a definition of citizenship, which includes women as well as men, and in the declaration that the privileges and immunities of citizens shall not be abridged. If there is any privilege of the citizen which is paramount to all others, it is the right of suffrage, and in a constitutional provision designed to secure the most valuable rights of the citizen, the declaration that the privileges and immunities of the citizen shall not be abridged must, as I conceive, be held to secure that right before all others. It is obvious, when the entire language of the section is examined, not only that this declaration was designed to secure the citizen this political right, but that such was its principle, if not its sole object. Those provisions of the section which follow it being devoted to securing the personal rights of life, liberty, property, and the equal protection of the laws. The clause on which we rely, to wit, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, might be stricken out of the section, and the residue would secure to the citizen every right which is now secured, excepting the political rights of voting and holding office. If the clause in question does not secure those political rights, it is entirely nugatory, and might as well have been omitted. If we go to the lexicographers and to the writers upon law to learn what are the privileges and immunities of the citizen in a republican government, we shall find that the leading feature of citizenship is the enjoyment of the right of suffrage. The definition of the term citizen by Bouvier is one who, under the Constitution and laws of the United States, has a right to vote for representatives in Congress and other public officers, and who is qualified to fill offices in the gift of the people. By Worcester, an inhabitant of a republic who enjoys the rights of a freeman and has a right to vote for public officers. By Webster, in the United States, a person native or naturalized who has the privileges of exercising the elective franchise, or the qualifications which enable him to vote for rulers and to purchase and hold real estate. The meaning of the word citizen is directly and plainly recognized by the latest amendment of the Constitution, the 15th. The right of the citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. This clause assumes that the right of citizens as such to vote is an existing right. Mr. Richard Grant White, in his late work on words and their uses, says of the word citizen, a citizen is a person who has certain political rights, and the word is properly used only to imply or suggest the possession of these rights. Footnote: Mr. Selden cited also Cofield or Coriel for Washington CC 380. Amy V. Smith, 1 Lap, Kentucky, 326. End of footnote. Beyond question, the first section of the 14th Amendment, by placing the citizenship of women upon a par with that of men, and declaring that the privileges and immunities of the citizen shall not be abridged, has secured to women equally with men the right of suffrage, unless, then, conclusion is overthrown by some other provision of the Constitution. It is not necessary for the purposes of this argument to claim that this amendment prohibits the state from making or enforcing any law whatever, regulating the elective franchise, or prescribing the conditions upon which it may be exercised. But we do claim that in every republic the right of suffrage, in some form and to some extent, is not only one of the privileges of its citizens, but is the first, most obvious, and most important of all the privileges they enjoy. That in this respect, all citizens are equal, and that the effect of this amendment is to prohibit the states from enforcing any law which denies this right to any of its citizens, or which imposes any restrictions upon it, which are inconsistent with the Republican form of government. Within this limit, it is unnecessary for us to deny that the states may still regulate and control the exercise of the right. End of section 3. Section 4 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Susan B. Anthony for voting at a congressional election. New York, 1873. Part 4. The only provisions of the Constitution which can be contended conflict with the construction which has here been put upon the first section of the 14th Amendment are the 15th Amendment and the second section of the 14th. In regard to the 15th Amendment, I shall only say that if my interpretation of the 14th Amendment is correct, there was still an object to be accomplished, and which was accomplished by the 15th. The prohibition of any action abridging the privileges and immunities of citizens contained in the 14th Amendment applies only to the states, and leaves the United States government free to abridge the political privileges and immunities of citizens of the United States, as such, at its pleasure. By the 15th Amendment, both the United States and the state governments are prohibited from exercising this power on account of race, color, or previous condition of servitude of the citizen. The first remark to be made upon the second section of the 14th Amendment is that it does not give, and was not designed to give, to the states any power to deny or abridge the right of any citizen to exercise the elective franchise. So far as it touches that subject, it was designed to be restrictive upon the states. It gives to them no power whatever. It takes away no power, but it gives none. And if the states possess the power to deny or abridge the right of citizens to vote, it must be derived from some other provision of the Constitution. I believe none such can be found, which was necessarily abrogated by the first section of this amendment. It may be conceded that the persons who prepared this section supposed that, by other parts of the Constitution or in some other way, the states would still be authorized, notwithstanding the provisions of the first section, to deny to the citizens the privilege of voting, as mentioned in the second section, but their mistake cannot be held to add to or to take from the other provisions of the Constitution. It is very clear that they did not intend by this section to give to the states any such power, but, believing that the states possessed it, they designed to hold the prospect of reduction of the representation in Congress in terrorem over them to prevent them from exercising it. They seem not to have been able to emancipate themselves from the influence of the original Constitution, which conceded this power to the states, or to have realized the fact that the first section of the amendment, when adopted, would wholly deprive the states of that power. But those who prepare constitutions are never those who adopt them, and consequently the views of those who frame them have little or no bearing upon their interpretation. The question for consideration here is what the people, who through their representatives in the legislatures adopted the amendments, understood or must be presumed to have understood from their language. They must be presumed to have known that the privileges and immunities of citizens, which were secured to them by the first section beyond the power of abridgment by the states, gave them the right to exercise the elective franchise, and they certainly cannot be presumed to have understood that the second section, which was also designed to be restrictive upon the states, would be held to confer by implication a power upon them, which the first section in the most express terms prohibited. It has been, and may be again asserted, that the position which I have taken in regard to the second section is inadmissible, because it renders the section nugatory. That is, as I hold, an entire mistake. The leading object of the second section was the readjustment of the representation of the states in Congress, rendered necessary by the abolition of chattel slavery, not a political slavery, affected by the 13th Amendment. This object the section accomplishes, and in this respect it remains wholly untouched by my construction of it. Neither do I think the position tenable which has been taken by one tribunal, to which the consideration of this subject was presented, that the constitutional provision does not execute itself. The provisions on which we rely were negative merely, and were designed to nullify existing as well as any future state legislation interfering with our rights. This result was accomplished by the Constitution itself. Undoubtedly, before we could exercise our right, it was necessary that should be a time and place appointed for holding the election, and proper officers to hold it, with suitable arrangements for receiving and counting the votes. All this was properly done by existing laws, and our right being made complete by the Constitution, no further legislation was required in our behalf. When the state officers attempted to interpose between us and the ballot box, the state constitution or state law, whether ancient or recent, abridging or denying our equal right to vote with other citizens, we had but to refer to the United States Constitution, prohibiting the states from enforcing any such constitutional provision or law, and our rights were complete. We needed neither congressional nor state legislation in aid of them. The opinion of Mr. Justice Bradley, in a case in the United States Supreme Court in New Orleans, would seem to be decisive of this question, although the right involved in that case was not that of the elective franchise. The learned justice says, it was very ably contended on the part of the defendants that the 14th Amendment was intended only to secure to all citizens equal capacities before the law. That was at first our view of it, but it does not so read. The language is, no state shall abridge the privileges or immunities of citizens of the United States. What are the privileges and immunities of citizens? Are they capacities merely? Are they not also rights? Senator Carpenter, who took part in the discussion of the 14th Amendment in the Senate, and aided in its passage, says, the 14th Amendment executes itself in every state of the Union. It is thus the will of the United States in every state, and silences every state constitution. usage, or law which conflicts with it. And if this provision does protect the colored citizen, then it protects every citizen, black or white, male or female, and all the privileges and immunities which I vindicate to a colored citizen, I vindicate to our mothers, our sisters, and our daughters. It has been said, with how much or how little truth I do not know, that the subject of securing to women the elective franchise was not considered in the preparation or in the adoption of these amendments. It is wholly immaterial whether that was so or not. It is never possible to arrive at the intention of the people in adopting constitutions, except by referring to the language used. As is said by Mr. Cooley, the intent is to be found in the instrument itself, and to that I have confined my remarks. It is not a new thing for constitutional and legislative acts to have an effect beyond the anticipation of those who formed them. It is undoubtedly true that in exacting Magna Carta from King John, the barons of England provided better securities for the rights of the common people that they were aware of at the time, although the rights of the common people were neither forgotten nor neglected by them. It has also been said, perhaps with some truth, that the framers of the original Constitution of the United States builded better than they knew, and it is quite possible that in framing the amendments under consideration, those engaged in doing it have accomplished a much greater work than they were at the time aware of. I am quite sure that it will be fortunate for the country if this great question of female suffrage, than which few greater were ever presented for the consideration of any people, shall be found most unexpectedly to have been put at rest. The opinion of Mr. Justice Bradley in regard to this amendment in the case before referred to, if I understand it, corresponds very nearly with what I have here said. The learned judge in one part of his opinion says, "It is possible that those who framed the article were not themselves aware of the far-reaching character of its terms. They may have had in mind but one particular phase of social and political wrong, which they desired to redress. Yet if the amendment as framed and expressed does, in fact, bear a broader meaning, and does extend its protecting shield over those who were never thought of when it was conceived and put in form, and does reach social evils which were never before prohibited by constitutional amendment, it is to be presumed that the American people, in giving it their imprimatur, understood what they were doing and meant to decree what has, in fact, been decreed. It embraces much more. The privileges and immunities secured by the original Constitution were only such as each state gave its own citizens. Each was prohibited from discriminating in favor of its own citizens and against the citizens of other states. But the 14th Amendment prohibits any state from abridging the privileges or immunities of the citizens of the United States, whether its own citizens or any others. It not merely requires equality of privileges, but it demands that the privileges and immunities of all citizens shall be absolutely unabridged, unimpaired. It will doubtless be urged as an objection to my position that citizenship carries with it the right to vote, that it would, in that case, follow that infants and lunatics who, as well as adults and persons of sound mind, are citizens, would also have that right. This objection, which appears to have great weight with certain classes of persons, is entirely without force. It takes no note of the familiar fact that every legislative provision, whether constitutional or statutory, which confers any discretionary power, is always confined in its operation to persons who are compos mentis. It is wholly unnecessary to accept idiots and lunatics out of any such statute. They are excluded from the very nature of the case. The contrary supposition would be simply absurd, and in respect to every such law, infants, during their minority, are in the same class. But are women, who are not infants, ever included in this category? Does any such principle of exclusion apply to them? Not at all. On the contrary, they stand in this respect upon the same footing as men, with the sole exception of the right to vote and the right to hold office. In every other respect, whatever rights and powers are conferred upon persons by law may be exercised by women as well as by men. They may transact any kind of business for themselves, or as agents or trustees for others, may be executors or administrators with the same powers and responsibilities as men. And it ought not to be a matter of surprise or regret that they are now placed by the 14th Amendment in other respects upon a footing of perfect equality. Although not directly connected with the argument as to the right secured by women by the Constitution, I deem it not improper to allude briefly to some of the popular objections against the propriety of allowing females the privilege of voting. I do this because I know from past experience that these popular objections, having no logical bearing upon the subject, are yet, practically, among the most potent arguments against the interpretation of the 14th Amendment, which I consider the only one that its language fairly admits of. It is said that women do not desire to vote. Certainly many women do not, but that furnishes no reason for denying the right to those who do desire to vote. Many men decline to vote. Is that a reason for denying the right to those who would vote? I believe, however, that the public mind is greatly in error in regard to the proportion of female citizens who would vote if their right to do so were recognized. In England, there has been to some extent a test to that question, with the following result, as given in the newspapers, the correctness of which, in this respect, I think there is reason to doubt. Woman suffrage is, to a certain extent, established in England, with the result is detailed in the London Examiner, that in 66 municipal elections, out of every 1,000 women who enjoy equal rights with men on the register, 516 went to the poll, which is by 48 less than the proportionate number of men. And out of 27,949 women registered, where a contest occurred, 14,416 voted. Of men, there were 166,781 on the register, and 90,080 at the poll. The examiner thereupon draws this conclusion: making allowance for the reluctance of old spinsters to change their habits and the more frequent illness of the sex, it is manifest that women, if they had opportunity, would exercise the franchise as freely as men. There is an end, therefore, of the argument that women would not vote if they had the power. Our law books furnish, perhaps, more satisfactory evidence of the earnestness with which women in England are claiming the right to vote under the Reform Act of 1867, aided by Lord Brougham's Act of 1850. The case of Chorlton v. Lings came before the Court of Common Pleas in England in 1869. It was an appeal from the decision of the revising barrister for the borough of Manchester to the effect that Mary Abbott, being a woman, was not entitled to be placed on the register. Her right was perfect in all respects excepting that of sex. The court, after a very full and able discussion of the subject, sustained the decision of the revising barrister, denying to women the right to be placed on the register, and consequently denying their right to vote. The decision rested upon the peculiar phraseology of several acts of Parliament, and the point decided has no applicability here. My object in referring to the case has been to call attention to the fact, stated by the reporter, that appeals of 5,436 other women were consolidated and decided with this. No better evidence could be furnished of the extent and earnestness of the claim of women in England to exercise the elective franchise. I infer, without being able to say how the fact is, that the votes given by women, as mentioned in the newspapers, were given at municipal elections merely, and that the cases decided by the Court of Common Pleas relate to elections for members of Parliament. End of section 4. Section 5 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Susan B. Anthony for voting at a congressional election. New York, 1873, Part 5. Another objection is that the right to hold office must attend the right to vote, and that women are not qualified to discharge the duties of responsible offices. I beg leave to answer this objection by asking one or more questions. How many of the male bipeds who do our voting are qualified to hold high offices? How many of the large class to whom the right of voting is supposed to have been secured by the 15th Amendment are qualified to hold office? Whenever the qualification of persons to discharge the duties of responsible offices is made the test of their right to vote, and we are to have a competitive examination on that subject open to all claimants, my client would be content to enter the list and take her chances among the candidates for such honors. But the practice of the world and our own practice gives the lie to this objection. Compare the administration of female sovereigns of great kingdoms, from Semiramis to Victoria, with the average administration of male sovereigns, and which will suffer by the comparison. How often have mothers governed large kingdoms as regents during the minority of their sons, and governed them well? Such offices as the sovereigns who rule them in this country have allowed women to hold, they having no voice on the subject. They have discharged the duties of with ever-increasing satisfaction to the public, and Congress has lately passed an act making the official bonds of married women valid, so that they could be appointed to the office of postmaster. The case of Olive V. Ingram was an action brought to try the title of two in office on the death of the sexton of the parish of St. Botolph. The place was to be filled by election, the voters being the housekeepers who paid Scott and Locke in the parish. The widow of the deceased sexton, Sarah Bly, entered the lists against all but the plaintiff in the suit, and received 169 indisputable votes, and 40 votes given by women who were housekeepers and paid to church and poor. The plaintiff had 174 indisputable votes, and 20 votes given by such women as voted for Mrs. Bly. Mrs. Bly was declared elected. The action was brought to test two questions. One, whether women were legal voters, and two, whether a woman was capable of holding the office. The case was 4 times argued in the King's Bench, and all the judges delivered opinions, holding that the women were competent voters, that the widow was properly elected and could hold the office. In the course of the discussion, it was shown that women had held many offices, those of constable, church warden, overseer of the poor, keeper of the gatehouse, a public prison, governess of a house of correction, keeper of castles, sheriffs of counties, and high constable of England. If women are legally competent to hold minor offices, I would be glad to have the rule of law, or of propriety, shown which should exclude them from higher offices, and which marks the line between those which they may and those which they may not hold. Another objection is that women cannot serve as soldiers. To this I answer that capacity for military service has never been made a test of the right to vote. If it were, young men from 16 to 21 would be entitled to vote, and old men from 60 and upwards would not. If that were the test, some women would present much stronger claims than many of the male sex. Another objection is that engaging in political controversies is not consistent with the feminine character. Upon that subject, women themselves are the best judges, and if political duty should be found inconsistent with female delicacy, we may rest assured that women will either effect a change in the character of political contests or decline to engage in them. This subject may be safely left to their sense of delicacy and propriety. If any difficulty on this account should occur, it may not be impossible to receive the votes of women at their places of residence. This method of voting was practiced in ancient Rome under the Republic, and it will be remembered that when the votes of the soldiers who were fighting our battles in the southern states were needed to sustain their friends at home, no difficulty was found in the way of taking their vote at their respective camps. I humbly submit to your honor, therefore, that on the constitutional grounds to which I have referred, Miss Anthony had a lawful right to vote, that her vote was properly received and counted, that the first section of the 14th Amendment secured to her that right, and did not need the aid of any further legislation. But conceding that I may be in error in supposing that Miss Anthony had a right to vote, she has been guilty of no crime, if she voted in good faith, believing that she had such right. The proposition appears to me so obvious that were it not for the severity to my client of the consequences which may follow a conviction, I should not deem it necessary to discuss it. To make out the offense, it is incumbent on the prosecution to show affirmatively not only that the defendant knowingly voted, but that she so voted knowing that she had no right to vote. That is, the term knowingly applies, not to the fact of voting, but to the fact of want of right. Any other interpretation of the language would be absurd. We cannot conceive of a case where a party could vote without knowledge of the fact of voting, and to apply the term knowingly to the mere act of voting would make nonsense of the statute. This word was inserted as defining the essence of the offense, and it limits the criminality to cases where the voting is not only without right, but where it is done willfully, with the knowledge that it is without right. Short of that, there is no offense within the statute. This would be so upon well-established principles, even if the word knowingly had been omitted. But that word was inserted to prevent the possibility of doubt on the subject, and to furnish security against the inability of stupid or prejudiced judges or jurors to distinguish between willful wrong and innocent mistake. If the statute had been merely that if at any election for representative in Congress any person shall vote without having a lawful right to vote, such person shall be deemed guilty of a crime. There could have been justly no conviction under it, without proof that the party voted knowing that he had not a right to vote. If he voted innocently, supposing he had the right to vote but had not, it would not be an offense within the statute. An innocent mistake is not a crime, and no amount of judicial decisions can make it such. Footnote. Then Mr. Selden cited numerous legal authorities to show that wrongful intent was essential to crime. Bishop on Criminal Law, Hawkins' Pleas of the Crown, and others. End of footnote. I concede that if Miss Anthony voted knowing that as a woman she had no right to vote, she may properly be convicted, and that if she had dressed herself in men's apparel and assumed a man's name, or resorted to any artifice to deceive the Board of Inspectors, the jury might properly regard her claim of right to be merely colorable, and might, in their judgment, pronounce her guilty of the offense charged, in case the Constitution had not secured to her the right she claimed. All I claim is that if she voted in perfect good faith, believing that it was her right, she has committed no crime. An innocent mistake, whether of law or fact, though a wrongful act may be done in pursuance of it, cannot constitute a crime. There are some cases which I concede cannot be reconciled with the position which I have endeavored to maintain, and I am sorry to say that one of them is found in the reports of this state, as the other cases are referred to in that, and the principle, if they can be said to stand on any principle, is in all of them the same. It will only be incumbent on me to notice that one. That case is not only irreconcilable with the numerous authorities and the fundamental principles of criminal law, to which I have referred, but the enormity of its injustice is sufficient alone to condemn it. I refer to the case of Hamilton v. the People. In that case, Hamilton had been convicted of a misdemeanor in having voted at a general election after having been previously convicted of a felony and sentenced to 2 years imprisonment in the state prison, and not having been pardoned, the conviction having by law deprived him of citizenship and right to vote, unless pardoned and restored to citizenship. The case came up before the general term of the Supreme Court on writ of error. It appeared that on the trial evidence was offered that before the prisoner was discharged from the state prison, he and his father applied to the governor for a pardon, and that the governor replied in writing that on the ground of the prisoner's being a minor at the time of his discharge from prison, a pardon would not be necessary, and that he would be entitled to all the rights of a citizen on his coming of age. They also applied to 2 respectable counselors of the Supreme Court, and they confirmed the governor's opinion. All this evidence was rejected. It appeared that the prisoner was 17 years old when convicted of the felony, and was 19 when discharged from prison. The rejection of the evidence was approved by the Supreme Court on the ground that the prisoner was bound to know the law, and was presumed to do so, and his conviction was accordingly confirmed. Here is a young man, innocent so far as his conduct in this case was involved, was condemned for acting in good faith upon the advice, mistaken advice it may be conceded, of the governor and 2 lawyers to whom he applied for information as to his rights. And this condemnation has proceeded upon the assumed ground, conceded to be false in fact, that he knew the advice given him was wrong. On this judicial fiction, the young man, in the name of justice, is sent to prison, punished for a mere mistake, and a mistake made in pursuance of such advice. It cannot be, consistently with the radical principles of criminal law to which I have referred, and the numerous authorities which I have quoted, that this man was guilty of a crime, that his mistake was a crime, and I think the judges who pronounced his condemnation upon their own principles, better than their victim, deserved the punishment which they inflicted. The condemnation of Miss Anthony, her good faith being conceded, would do no less violence to any fair administration of justice. One other matter will close what I have to say. Miss Anthony believed and was advised that she had a right to vote. She might also have been advised, as was clearly the fact, that the question as to her right could not be brought before the courts for trial without her voting or offering to vote, and if either was criminal, the one was as much so as the other. Therefore she stands now arraigned as a criminal, but taking the only steps to which it was possible to bring the great constitutional question as to her right before the tribunals of the country for adjudication, if for thus acting in the most perfect good faith, with motives as pure and impulses as noble as any which can find place in your honor's breast in the administration of justice. She is, by the laws of her country, to be condemned as a criminal. She must abide the consequences. Her condemnation, however, under such circumstances, would only add another most weighty reason to which I have already advanced, to show that women need the aid of the ballot for their protection. Upon the remaining question of the good faith of the defendant, it is not necessary for me to speak. That she acted in the most perfect good faith stands conceded. Thanking your honor for the great patience with which you have listened to my 2 extended remarks, I submit the legal questions which the case involves for your honor's consideration. Mr. Justice Hunt, gentlemen of the jury, I have given this case such consideration as I have been able to, and that there might be no misapprehension about my views, I have made a brief statement in writing. The defendant is indicted under the Act of Congress of 1870 for having voted for representatives in Congress in November 1872. Among other things, that act makes it an offense for any person knowingly to vote for such representatives without having a right to vote. It is charged that the defendant thus voted, she not having a right to vote because she is a woman. The defendant insists that she has a right to vote, that the provisions of the Constitution of this state limiting the right to vote to persons of the male sex is in violation of the 14th Amendment of the Constitution of the United States and is void. The 13th, 14th, and 15th Amendments were designed mainly for the protection of the newly emancipated Negroes, but full effect must nevertheless be given to the language employed. The 13th Amendment provided that neither slavery nor involuntary servitude should longer exist in the United States. If honestly received and fairly applied, this provision would have been enough to guard the rights of the colored race. In some states, it was attempted to be evaded by enactments cruel and oppressive in their nature, as that colored persons were forbidden to appear in the towns except in a menial capacity, that they should reside on and cultivate the soil without being allowed to own it, that they were not permitted to give testimony in cases where a white man was a party. They were excluded from performing particular kinds of business, profitable and reputable, and they were denied the right of suffrage. To meet the difficulties arising from this state of things, the 14th and 15th Amendments were enacted. The 14th Amendment created and defined citizenship of the United States. It had long been contended and had been held by many learned authorities, and had never been judicially decided to the contrary, that there was no such thing as a citizen of the United States, except as that condition arose from citizenship of some state. No mode existed, it was said, of obtaining a citizenship of the United States, except by first becoming a citizen of some state. This question is now at rest. The 14th Amendment defines and declares who should be citizens of the United States, to wit, all persons born or naturalized in the United States and subject to the jurisdiction thereof. The latter qualification was intended to exclude the children of foreign representatives and the like. With this qualification, every person born in the United States or naturalized is declared to be a citizen of the United States and of the state wherein he resides. After creating and defining citizenship of the United States, the amendment provides that no state shall make or enforce any law which shall abridge the privileges or immunities of a citizen of the United States. This clause is intended to be a protection, not to all our rights, but to our right as citizens of the United States only. That is, the rights existing or belonging to that condition or capacity. The words "or citizens of a state" used in the previous paragraph are carefully omitted here. In Article 4, Paragraph 2 of the Constitution of the United States, it had already provided in this language, viz., the citizens of each state shall be entitled to all the privileges and immunities of the citizens in the several states. The rights of citizens of the states and of citizens of the United States are each guarded by these different provisions. That these rights were separate and distinct was held in the slaughterhouse cases recently decided by the United States Supreme Court at Washington. The rights of citizens of the state, as such, are not under consideration in the 14th Amendment. They stand as they did before the adoption of the 14th Amendment, and are fully guaranteed by other provisions. The rights of citizens of the states have been the subject of judicial decision on more than one occasion. These are the fundamental privileges and immunities belonging of right to the citizens of all free governments, such as the right of life and liberty, the right to acquire and possess property, to transact business, to pursue happiness in his own manner, subject to such restraint as the government may adjudge, to be necessary for the general good. In Cromwell v. Nevada is found a statement of some of the rights of a citizen of the United States, viz., to come to the seat of government to assert any claim he may have upon the government, to transact any business he may have with it, to seek its protection, to share its offices, to engage in administering its functions. He has a right of free access to its seaports, through which all operations of foreign commerce are conducted, to the sub-treasuries, land offices, and courts of justice in the several states. Another privilege of a citizen of the United States, says Miller, justice in the slaughterhouse cases, is to demand the care and protection of the federal government over his life, liberty, and property when on the high seas or within the jurisdiction of a foreign government. The right to assemble and petition for a redress of grievances, the privileges of the writ of habeas corpus, he says, are rights of the citizen guaranteed by the federal Constitution. End of Section 5. Section 6 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Susan B. Anthony for voting at congressional election. New York, 1873, Part 6. The right of voting or the privilege of voting is a right or privilege arising under the Constitution of the state and not of the United States. The qualifications are different in the different states. Citizenship, age, sex, residence are variously required in the different states or may be so. If the right belongs to any particular person, it is because such person is entitled to it by the laws of the state where he offers to exercise it, and not because of citizenship of the United States. If the state of New York should provide that no person should vote until he had reached the age of 31 years, or after he had reached the age of 50, or that no person having gray hair, or who had not the use of all his limbs should be entitled to vote, I do not see how it could be held to be a violation of any right derived or held under the Constitution of the United States. We might say that such regulations were unjust, tyrannical, unfit for the regulation of an intelligent state. But if rights of a citizen are thereby violated, they are of that fundamental class derived from his position as a citizen of the state, and not those limited rights belonging to him as a citizen of the United States, and such was the decision in Corfield v. Correal. The United States rights appertaining to this subject are those first under Article 1, Paragraph 2 of the United States Constitution, which provides that electors of representatives in Congress shall have the qualifications requisite for electors of the most numerous branch of the state legislature, and second, under the 15th Amendment, which provides that the right of a citizen of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. If the legislature of the state of New York should require a higher qualification in a voter for a representative in Congress than is required for a voter for a member of Assembly, this would, I conceive, be a violation of the right belonging to one as a citizen of the United States. That right is in relation to a federal subject or interest, and is guaranteed by the federal Constitution. The inability of a state to abridge the right of voting on account of race, color, or previous condition of servitude arises from a federal guarantee. Its violation would be the denial of a federal right, that is, a right belonging to the claimant as a citizen of the United States. The right, however, exists by virtue of the 15th Amendment. If the 15th Amendment had contained the word sex, The argument of the defendant would have been potent. She would have said an attempt by a state to deny the right to vote because one is of a particular sex is expressly prohibited by that amendment. The amendment, however, does not contain that word. It is limited to race, color, or previous condition of servitude. The legislature of the state of New York has seen fit to say that the franchise of voting shall be limited to the male sex. In saying this, there is, in my judgment, no violation of the letter or of the spirit of the 14th or of the 15th Amendment. This view is assumed in the second section of the 14th Amendment, which enacts that if the right to vote for federal officers is denied by any state to any of the male inhabitants of such state, except for crime, the basis of representation of such state shall be reduced in proportions specified. Not only does this section assume that the right of male inhabitants to vote was the especial object of its protection, but it assumes and admits the right of a state, notwithstanding the existence of that clause under which the defendant claims to the contrary, to deny to classes or portions of the male inhabitants the right to vote which is allowed to other male inhabitants. The regulation of the suffrage is thereby conceded to the states as a state's right. The case of Myra Bradwell, decided at a recent term of the Supreme Court of the United States, sustains both the positions above put forth, viz., first, that the rights referred to in the 14th Amendment are those belonging to a person as a citizen of the United States, and not as a citizen of a state, and second, that a right of the character here involved is not one connected with citizenship of the United States. Mrs. Bradwell made application to be admitted to practice as an attorney and counselor at law in the courts of Illinois. Her application was denied, and upon appeal to the Supreme Court of the United States, it was there held that to give jurisdiction under the 14th Amendment, the claim must be of a right pertaining to citizenship of the United States, and that the claim made by her did not come within that class of cases. Mr. Justice Bradley and Mr. Justice Field held that a woman was not entitled to a license to practice law. It does not appear that the other judges passed upon that question. The 14th Amendment gives no right to a woman to vote, and the voting by Miss Anthony was in violation of the law. If she believed she had a right to vote and voted in reliance upon that belief, does that relieve her from the penalty? It is argued that the knowledge referred to in the Act relates to her knowledge of the illegality of the Act, and not to the act of voting, for it is said that she must know that she voted. Two principles apply here. First, ignorance of the law excuses no one. Second, every person is presumed to understand and to intend the necessary effects of his own acts. Miss Anthony knew that she was a woman, and that the Constitution of this state prohibits her from voting. She intended to violate that provision, intended to test it, perhaps, but certainly intended to violate it. The necessary effect of her act was to violate it, and this she is presumed to have intended. There was no ignorance of any fact, but all the facts being known, she undertook to settle a principle in her own person. She takes the risk, and she cannot escape the consequences. It is said, and authorities have cited to sustain the position, that there can be no crime unless there is a culpable intent. To render one criminally responsible, a vicious will must be present. A commits a trespass on the land of B, and B, thinking and believing that he has a right to shoot an intruder on his premises, kills A on the spot. Does B's misapprehension of his rights justify this act? Would a judge be justified in charging the jury that if satisfied that B supposed he had a right to shoot A, he was justified, and they should find a verdict of not guilty? No judge would make such a charge. To constitute a crime, it is true that there must be a criminal intent, but it is equally true that knowledge of the facts of the case is always held to supply this intent. An intentional killing bears with it evidence of malice in law. Whoever, without justifiable cause, intentionally kills his neighbor is guilty of a crime. The principle is the same in the case before us, and in all criminal cases. The precise question now before me has been several times decided, viz., that one illegally voting was bound and was assumed to know the law, and that a belief that he had a right to vote gave no defense if there was no mistake of fact. No system of criminal jurisprudence can be sustained upon any other principle. Assuming that Miss Anthony believed she had a right to vote, that fact constitutes no defense if in truth she had not the right. She voluntarily gave a vote which was illegal, and thus is subject to the penalty of the law. Upon this evidence, I suppose there is no question for the jury, and that the jury should be directed to find a verdict of guilty. Mr. Selden, I submit on the view which your Honor has taken, that the right to vote and the regulation of it is solely of state matter, that this whole law is out of the jurisdiction of the United States courts and of Congress. The whole law upon that basis, as I understand it, is not within the constitutional power of the general government, but is one which applies to the states. I suppose that it is for the jury to determine whether the defendant is guilty of a crime or not, and I therefore ask your Honor to submit to the jury these propositions. First, if the defendant, at the time of voting, believed that she had a right to vote and voted in good faith in that belief, she is not guilty of the offense charged. Second, in determining the question whether she did or did not believe that she had a right to vote, the jury may take into consideration, as bearing upon that question, the advice which she received from the counsel to whom she applied. Third, that they may also take into consideration, as bearing upon the same question, the fact that the inspectors considered the question and came to the conclusion that she had a right to vote. Fourth, that the jury have a right to find a general verdict of guilty or not guilty, as they shall believe that she has or has not committed the offense described in the statute. A professional friend sitting by has made this suggestion, which I take leave to avail myself of, as bearing upon this question. The court has listened for many hours to an argument in order to decide whether the defendant has a right to vote. The argument showed the same question has engaged the best minds of the country as an open question. Can it be possible that the defendant is to be convicted for acting upon such advice as she could obtain, while the question is an open and undecided one? The court: You have made a much better argument than that, sir. Mr. Selden: As long as it is an open question, I submit that she has not been guilty of an offense. At all events, it is for the jury. The court: I cannot charge these propositions, of course. This question, gentlemen of the jury, in the form it finally takes, is wholly a question or questions of law, and I have decided as a question of law, in the first place, that under the 14th Amendment, which Miss Anthony claims protects her, she was not protected in a right to vote. And I have decided also that her belief and the advice which she took does not protect her in the act which she committed. If I am right in this, the result must be a verdict on your part of guilty, and I therefore direct that you find a verdict of guilty. Mr. Selden: That is a direction no court has power to make in a criminal case. The court: Take the verdict, Mr. Clerk. The clerk: Gentlemen of the jury, hearken to your verdict as the court has recorded it. You say you find the defendant guilty of the offense whereof she stands indicted, and say so you all? Mr. Selden: I don't know whether an exception is available, but I certainly must accept to the refusal of the court to submit those propositions, and especially to the direction of the court that the jury should find a verdict of guilty. I claim that it is a power that is not given to any court in a criminal case. Will the clerk poll the jury? The court. No. Gentlemen of the jury, you are discharged. June 18th. Mr. Selden today moved for a new trial on several grounds, the main one being that the court had declined to submit the case to a jury upon any question whatever, and directed them to render a verdict of guilty against the defendant. The court, after hearing the district attorney, denied the motion. Mr. Justice Hunt, the prisoner will stand up. Has the prisoner anything to say why sentence shall not be pronounced? Miss Anthony, yes, Your Honor, I have many things to say, for in your ordered verdict of guilty, you have trampled underfoot every vital principle of our government. My natural rights, my civil rights, my political rights, my judicial rights are all alike ignored. Robbed of the fundamental privilege of citizenship, I am degraded from the status of a citizen to that of a subject, and not only myself individually, but all of my sex are, by your Honor's verdict, doomed to political subjection under this so-called form of government. Mr. Justice Hunt, the court cannot listen to a rehearsal of arguments the prisoner's counsel has already consumed 3 hours in presenting. Miss Anthony, may it please your Honor, I am not arguing the question, but simply stating the reasons why sentence cannot in justice be pronounced against me. Your denial of my citizen's right to vote is the denial of my right of consent as one of the governed, the denial of my right of representation of one of the taxed, the denial of my right to a trial by a jury of my peers as an offender against law, therefore the denial of my sacred rights to life, liberty, property, and Mr. Justice Hunt, the court cannot allow the prisoner to go on. Miss Anthony, but your Honor will not deny me this one and only poor privilege of protest against this high-handed outrage upon my citizens' rights. May it please the court to remember that since the day of my arrest last November, this is the first time that either myself or any person of my disenfranchised class has been allowed a word of defense before judge or jury. Mr. Justice Hunt, the prisoner must sit down. The court cannot allow it. Miss Anthony, all my prosecutors from the 8th Ward corner grocery politician who entered the complaint to the United States Marshal, Commissioner, District Attorney, District Judge, Your Honor on the bench. Not one is my peer, but each and all are my political sovereigns, and had Your Honor submitted my case to the jury, as was clearly your duty, even then I should have had just cause of protest, for not one of those men was my peer, but native or foreign-born, white or black, rich or poor, educated or ignorant, awake or asleep, sober or drunk, each and every man of them was my political superior, hence in no sense my peer. Even under such circumstances, a commoner of England, tried before a jury of lords, would have far less cause to complain than should I, a woman, tried before a jury of men. Even my counsel, the Honorable Henry B. Selden, who has argued my case so ably, so earnestly, so unanswerably before your Honor, is my political sovereign, precisely as no disenfranchised person is entitled to sit upon a jury, and no woman is entitled to the franchise. So, none but a regularly admitted lawyer is allowed to practice in the courts, and no woman can gain admission to the bar. Hence, jury, judge, counsel must all be of the superior class. Mr. Justice Hunt, the court must insist the prisoner has been tried according to the established forms of law. Miss Anthony, yes, Your Honor, but by forms of law all made by men, interpreted by men, administered by men, in favor of men and against women, and hence your Honor's ordered verdict of guilty against a United States citizen for the exercise of that citizen's right to vote, simply because that citizen was a woman and not a man. But yesterday, the same man made forms of law, declared it a crime punishable with $1,000 fine and 6 months imprisonment for you or me or any of us to give a cup of cold water, a crust of bread, or a night's shelter to a panting fugitive as he was tracking his way to Canada. And every man or woman in whose veins coursed a drop of human sympathy violated that wicked law, reckless of consequences, and was justified in so doing. As then, the slaves who got their freedom must take it over, or under, or through the unjust forms of law. Precisely so now must women, to get their right to a voice in this government. Take it, and I have taken mine, and mean to take it at every possible opportunity. Mr. Justice Hunt, the court orders the prisoner to sit down. It will not allow another word. Miss Anthony, when I was brought before your honor for trial, I hoped for a broad and liberal interpretation of the Constitution and its recent amendments that should declare all United States citizens under its protecting aegis. It should declare equality of rights the national guarantee to all persons born or naturalized in the United States. But failing to get this justice, failing even to get a trial by a jury not of my peers, I ask not leniency at your hands, but rather the full rigors of the law. Mr. Justice Hunt, the court must insist. Here Miss Anthony sat down. Mr. Justice Hunt, the prisoner will stand up. Here Miss Anthony arose again. The sentence of the court is that you pay a fine of $100 and the cost of the prosecution. Miss Anthony, may it please your honor, I shall never pay $1 of your unjust penalty. All the stock and trade I possess is a $10,000 debt incurred by publishing my paper, The Revolution, 4 years ago, the sole object of which was to educate all women to do precisely as I have done. Rebel against your man-made, unjust, unconstitutional forms of law that tax, fine, imprison, and hang women while they deny them the right of representation in the government. And I shall work on with might and main to pay every dollar of that honest debt. But not a penny shall go to this unjust claim, and I shall earnestly and persistently continue to urge all women to the practical recognition of the old revolutionary maxim that resistance to tyranny is obedience to God. Mr. Justice Hunt, Madam, the court will not order you committed until the fine is paid. End of section 6.
Section 7 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. American State Trials, Volume 3 by John D. Lawson. Trial of Beverly W. Jones, Edwin P. Marsh, and William B. Hall for permitting women to vote, New York, 1873, Part 1. The narrative. On the same day that Miss Anthony was sentenced, the 3 inspectors of election, Jones, Marsh, and Hall, were put on their trial for registering and receiving illegal votes. All of them were convicted, the court holding, as it did in Miss Anthony's case, that good faith in receiving the votes of the women was no protection. The trial. In the United States Circuit Court for the Northern District of New York, Canandaigua, New York, June 1873. Honorable Ward Hunt, Judge. June 18. The defendants had been at the previous January term of this court indicted for misdemeanors in the office of inspectors of elections for one of the election districts of the city of Rochester. On being arraigned today, Jones and Marsh pleaded not guilty. Hall did not appear or plead. Richard Crowley, District Attorney for the United States. John Van Voorhees for the defendants. The case being opened by Mr. Crowley, Mr. Van Voorhees raised some objection to the indictment, viz. That the act of Congress under which it is framed is invalid so far as it relates to this offense because not authorized by the Constitution of the United States, and that there is no sufficient statement of any offense in the indictment. The court overruled the objection. The witnesses for the prosecution: William F. Morrison, live in Rochester, was city clerk in November 1872, have the registration and poll list of the 1st election district, know the defendants. The lists were left in my office by Beverly W. Jones, the chairman of the Board of Inspectors, and they are signed and subscribed to by him and William B. Hall and Edwin T. Marsh. On November 5th, there was an election held in that district for member of Congress. The poll and registration lists were put in evidence. Sylvester Lewis, live in Rochester, know the defendants. They acted as a board of registry in November last. Saw them registering votes. Saw the following women at the office: Susan B. Anthony, Sarah Truesdale, Mary Pulver, Mary Anthony, Ellen S. Baker, Margaret Layden, Ann S. Mosier, Nancy M. Chapman, Lottie B. Anthony, Susan M. Hogue, Hannah Chatfield, Mary S. Hibbard, Rhonda DeGarmo, and Jane Cogswell. Knew most of them by sight. Saw Rhoda DeGarmo, Miss Mary Anthony, Sarah C. Truesdale, Susan M. Hogue. Think I saw Nancy M. Chatfield, Mrs. Margaret Layden, and Mrs. M. E. Pulver. Those I recollect was better acquainted with those than with the others. The inspectors were there all the time. Sometimes all 3, but always 1 or 2. On the day of the election, saw the following ladies vote: Susan B. Anthony, Mrs. McLean, Rhoda DeGarmo, Mary Anthony, Ellen S. Baker, Sarah C. Truesdale, Mrs. Hogue, Mrs. Mosier, Mrs. Layden, Mrs. Pulver. Recollect seeing those ladies. In fact, think I saw the whole of them vote with the exception of 2, but will not be positive on that point. Think they voted 4 tickets. Was not near enough to see the endorsement, but noticed which boxes they went into. The defendants were present and acting as inspectors of election. All the ladies voted early in the morning. Cross-examined. Made a list at the time of the women that voted. My business at the polls that day was checking parties that I supposed had a right to vote. Had canvassed the ward for some of the candidates. Mr. Jones took Miss Anthony's vote, but the other inspectors were present. Some of the votes were taken by the other inspectors. There were 6 ballot boxes and 6 tickets voted. Understood that the women voted all the tickets except the constitutional amendments. Heard Jones say the ladies voted the congressional ticket. Mr. Van Voorhees, did you say anything there about getting 20 women to vote? Mr. Crowley objected. Mr. Van Voorhees, I propose to show that this witness said to parties that he would go and get 20 Irish women to vote to offset these votes. The court sustained the objection. William F. Morrison, recalled. On the registration list, I find the following names: Susan B. Anthony, Sarah C. Truesdale, Mary Pulver, Mary Anthony, Ellen S. Baker, Margaret L. Layden, Hannah L. Mosier, Nancy M. Chapman, Lottie B. Anthony, Susan M. Hogue, Hannah Chatfield, Mary S. Hibbard, Jane Cogswell. Do not find Rhoda DeGarmo. On the list of voters on Election Day, I find the following: Susan B. Anthony, Sarah Truesdale, Mary Pulver, Mary Anthony, Mary S. Baker, Margaret Layden, Hannah L. Mosier, Nancy M. Chapman, Lottie B. Anthony, Susan M. Hogue, Hannah Chatfield, Mary S. Hibbard, Rhoda DeGarmo, and Jane Cogswell. The heading of the list shows that these people voted certain tickets. Mr. Crowley, which tickets did they vote? After the name of Susan B. Anthony in the column of electors, there is a small straight mark. Mr. Van Voorhees, I object to any marks on the books which the witness did not make as any evidence that these persons voted for members of Congress. The court, I think it is competent. Mr. Morrison, opposite each of the names that I have read, there are checks showing that they voted electoral, state, congressional, and assembly tickets. 4 tickets. Cross-examined, all I know about these tickets or that book is what appears on the face of it. Don't know who made those straight marks or why they were made. Would say that to each of these persons the preliminary oath was administered and also the general oath. Margaret Layden, reside in Rochester in the 8th Ward, registered in November as a voter before Mr. Jones and the other inspectors. Voted on November 5th for candidates for Congress. Mr. Jones took my vote. The other inspectors were present. Cross-examined, no one but my husband saw who I voted for. When I voted, the ballot was folded so no one could see it. The court, what is the object of this? Mr. Van Voorhees, the district attorney inquired if she voted a certain ticket and assumed to charge these inspectors with knowing what she voted. It is to show that the ticket being folded, the inspector could not see what was in it. Mr. Van Voorhees, in voting, did you believe that you had a right to vote and vote in good faith? Objected to, and objection sustained by the court. Margaret Layden, many of the ladies whose names have been mentioned today were present when I voted. I remember that the following voted: Miss Susan B. Anthony, Mrs. Pulver, Mrs. Mosier, Mrs. Lottie B. Anthony, the wife of Alderman Anthony, Miss Mary Anthony, Miss Baker, and Mrs. Chapman. The witnesses for the defense: Beverly W. Jones, reside in Rochester, am 25 years of age, was an inspector of election for the 8th Ward, elected by the people of the ward, was present at the Board of Registry when Miss Anthony and others appeared and demanded to be registered. Miss Anthony and 2 other ladies came into the room. Miss Anthony asked if this was the place where they registered the names of voters. I told her it was. She said she would like to have her name registered. I told her I didn't think we could register her name. It was contrary to the Constitution of the State of New York. She claimed her rights under the Constitution of the United States. Under an amendment to the Constitution, she asked me if I was conversant with the 14th Amendment. I told her I had read it and heard of it several times. William B. Hall and I were the only inspectors present at the time. Mr. Marsh was not there. Daniel J. Warner, the United States Supervisor, Republican, Silas J. Wagner, another United States Supervisor, Democrat, and a United States Marshal were also there. The court. Was your objection to registering Miss Anthony on the ground that she was a woman? I said it was contrary to the Constitution of the State of New York, and I didn't think we could register her because she was a woman. Mr. Van Voorhees, state what occurred then. Mr. Jones, Mr. Warner said, the court, I don't think that is competent what Warner said. Mr. Van Voorhees, the district attorney has gone into what occurred at that time, and I ask to be permitted to show all that occurred at the time of the registry. This offense was committed there. It is part of the res gesta, all that occurred at the moment Miss Anthony presented herself and had her name put upon the registry. The court, I don't think that is competent. Mr. Van Voorhees, I ask to show what occurred at the time of the registry. The court, I don't think it is competent to state what Warner or Wagner advised. Mr. Van Voorhees, so that the question may appear squarely in the case, I offer to show what was said and done at the time Miss Anthony and the other ladies registered by the inspectors and the federal supervisors, Wagner and Warner, in their presence in regard to that subject. The court, I exclude it. Mr. Van Voorhees, does that exclude all conversations that occurred there with any persons? The court, it excludes anything of that character on the subject of advising them. Your case is just as good without it as with it. Mr. Van Voorhees, I didn't offer it in view of the advice, but to show precisely what the operation of the minds of these inspectors was at that time and what the facts are. The court, it is not competent. Mr. Jones, I was present on the day of election and received the votes of these persons. There were 6 ballot boxes. I was chairman of the board. I stood at the window and received the votes. Most of the time, these ballots received were folded, and none of the inspectors saw or knew the contents of any of the ballots. Mr. Crowley, I submit it is entirely immaterial whether these inspectors saw the names upon the ballots. The court, I have excluded that already. It is not competent. It is proved that they put in votes, and it is proved by one of the ladies that she did vote for a candidate for Congress. Mr. Van Voorhees, I propose to show by the witness that he didn't know the contents of any ballot and didn't see it. The court, that will be assumed. He could not do it with any propriety. Mr. Jones. Mr. Hall objected to receiving the votes of the women, though while I was out for a moment he took the vote of one lady and put it in the box. All three of the inspectors had agreed to register the women, but when it came to receiving the votes, Hall objected, but he was overruled by myself and the other member. In receiving the ballots, I acted honestly in accordance with my sense of duty and my best judgment. Mr. Van Voorhees. State whether or not challenges were entered against these voters prior to the day of election? There was. Mr. Van Voorhees. On their presenting their votes, what was done? I told Miss Anthony when she offered her vote that she was challenged. She would have to swear her ballot in if she insisted on voting. She said she insisted upon voting, and I presented her the Bible and administered to her the preliminary oath, which she took. I turned to the gentleman that challenged her and asked him if he still insisted on her taking the general oath. He said he did. I told her she would have to take the general oath. I administered the general oath, and she took it. That was done in the case of each woman who voted. To Mr. Crowley. At first, all three of the inspectors were not agreed in registering the women, but before their names were put in the book, we were unanimous. When they voted, myself and Mr. Marsh were in favor of receiving the votes, and Hall was opposed. When I counted the votes at night, I compared the votes with the list, and we found it fell short several ballots. Edwin T. Marsh. Am one of the defendants and was inspector for the 8th Ward appointed by the Common Council. Am 33 years old. The evidence of Mr. Jones is substantially correct. Mr. Van Voorhees. Registering and receiving these votes, you believe that the law required you to do it, and you acted conscientiously and honestly? Objected to. The Court. Put the question as you did to the other witness, whether in receiving these votes be acted honestly and according to the best of his judgment. Mr. Van Voorhees. Answer that question, please. Mr. Marsh. I most assuredly did. William C. Storrs. Reside in Rochester. Have been United States Commissioner for 15 years. Mr. Van Voorhees. Was any application made to you by any person at any time for a warrant against them for this offense? Objected to. Mr. Van Voorhees. If the counsel objects, I will not insist upon the evidence. Susan B. Anthony. I would like to know if the testimony of a person who has been convicted of a crime can be taken. The Court. They call you as a witness, madam. Mr. Van Voorhees. Miss Anthony, I want you to state what occurred at the Board of Registry when your name was registered. That would be very tedious, for it was a full hour. Mr. Van Voorhees. State generally what was done or what occupied that hour's time. Well, the question of our right to be registered was a subject of discussion there between the supervisors, inspectors, and myself. Mr. Van Voorhees. What occurred when you presented yourself at the polls on Election Day? Mr. Crowley. I submit to the Court that unless the counsel expects to change the version given by the other witnesses, it is not necessary to take up time. The Court. As a matter of discretion, I don't see how it will be of any benefit. It was fully related by the others, and doubtless correctly. Mr. Crowley. It is not disputed. Miss Anthony. I would like to say, if I might be allowed by the Court, that the general impression that I swore I was a male citizen is an erroneous one. Mr. Van Voorhees. You took the 2 oaths there, did you? Yes, sir. The Court. You presented yourself as a female, claiming that you had a right to vote? I presented myself not as a female at all, sir. I presented myself as a citizen of the United States. I was called to the United States ballot box by the 14th Amendment, not as a female, but as a citizen, and I went there. Mr. Van Voorhees. We have a number of witnesses to prove what occurred at the time of registry, and what advice was given by these federal supervisors, but under your Honor's ruling, it is not necessary for us to call them. Inasmuch as Mr. Hall is absent, I ask permission to put in his evidence as he gave it before the commissioners. Mr. Crowley. I have not read it, but I am willing they should use so much of it as is competent under your Honor's ruling. The Court. Will it change this case at all, Mr. Van Voorhees? Mr. Van Voorhees. It only varies it a little as to Hall. He stated that he depended in consenting to the registry upon the advice of Mr. Warner, who was his friend and upon whom he looked as a political father. The Court. I think you have everything that any evidence could give you in the case. These men have sworn that they acted honestly and in accordance with their best judgment. Now, if that is a defense, you have it, and it will not make it any stronger to multiply evidence. Mr. Van Voorhees, I suppose it will be conceded that Hall stands in the same position as to his motives? Mr. Crowley, yes, we have no evidence to offer upon that question at all. Mr. Van Voorhees, may it please the court, I submit that there is no ground whatever to charge these defendants with any criminal offense. 1, because the women who voted were legal voters. 2, because they were challenged and took the oaths which the statute requires of electors, and the inspectors had no right, after such oath, to reject their votes. Construing the statute under which this indictment is found, the Court of Appeals of the State in Peoples v. Pease held that inspectors of election have no authority by statute to reject a vote except in 3 cases. 1, after a refusal to take the preliminary oath, or 2, fully to answer any questions put, or 3, on refusal to take general oath. Davies J., in his opinion, after an examination of the provisions of the statute, says, "It is seen, therefore, that the inspectors have no authority, by statute, to reject a vote except in the 3 cases, after refusal to take preliminary oath, or fully to answer any questions put, or on refusal to take the general oath. And the only judicial discretion vested in them is, to determine whether any question put to the person offering to vote has or has not been fully answered. If the questions put have been fully answered, and such answers discover the fact that the person offering to vote is not a qualified voter, yet if he persists in his claim to vote, it is imperative upon the inspectors to administer to him the general oath, and if taken, to receive the vote and deposit the same in the ballot box." And Selden J., who wrote in the same case, examines this question with great care and reaches the same conclusion. These views were concurred in by all the judges. Denio J., who wrote a dissenting opinion in the case, concurred with the other judges as to the powers and duties of inspectors. The defendants, then, have not in the least violated any law of the state of New York. They performed their duty according to the statute, and in accordance with the decision of the highest court of the state, and in accordance with the printed instructions furnished them by the Secretary of State. What further can be demanded of them? No United States statute prescribes or attempts to prescribe their duties. They cannot legally be convicted and should be discharged. 2. Because no malice is shown. Whether the women were entitled to have their names registered and to vote or not, the defendants believed they had such right and acted in good faith according to their best judgment in allowing the registry of their names and in receiving their votes, and whether they decided right or wrong in point of law, they were not guilty of any criminal offense. The substance of the statute is as to registration. If any such officer shall knowingly and willfully register as a voter any person not entitled to be registered, or refuse to register any person entitled to be registered, every such person shall be deemed guilty of a crime. And as to voting, if any person shall knowingly and willingly receive the vote of any person not entitled to vote, or refuse to receive the vote of any person entitled to vote, every such person shall be deemed guilty of a crime. To bring an inspector within either of these sections, he must know as a matter of fact that the person offering to vote or to be registered is not entitled to be registered or to vote. The inspectors were compelled to decide the question, and to decide instantly with no chance for examination or even consultation, and if they decided in good faith according to the best of their ability, they are excused whether they decided correctly or not in point of law. This is too well settled to admit of dispute, settled by authority as well as by the plainest principles of justice and common sense. The law never yet placed a public officer in a position where he would be compelled to decide a doubtful legal question, and to act upon his decision subject to the penalty of fine or imprisonment if he chanced to err in his decision. All that is ever required of an officer so placed, whether a judicial or ministerial office, so far as is necessary to escape any imputation of crime, is good faith. Ministerial officers may be required, in some cases, to act at their peril as to civil responsibilities, but as to criminal responsibilities, never. Inspectors of elections, however, acting in good faith, incur neither civil nor criminal responsibilities. Besides, when the statute speaks of knowledge, aside from the expression willfully, it means knowledge as a fact, not any forced presumption of knowledge against the clear facts of the case. To this extent, and to this extent only, does the presumption that defendants were bound to know the law go vis. They were bound to know that if they, as a fact, knowingly and willfully registered as a voter any person not entitled to be registered, or knowingly and willfully received the vote of any person not entitled to vote, in either case they were liable to the penalty, and they could not be allowed to urge in their defense any ignorance that the law made those facts criminal. Here is a total absence of any pretense of malice. The defendants acted honestly and according to their best judgment. This is conceded. The most that can be said against them is that they have been erred in judgment. They are not lawyers nor skilled in the law. They had presented to them a legal question which, to say the least, has puzzled some of the ablest legal minds of the nation. The penalty is the same on whichever side they err. If they can be convicted of a crime, a test must be imposed upon them, which no judge in the land could stand. The defendants should be discharged by the court. Mr. Crowley rose. End of section 7. Section 8 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. American State Trials, Volume 3 by John D. Lawson. Trial of Beverly W. Jones, Edwin P. Marsh, and William B. Hall for permitting women to vote. New York, 1873, Part 2. The Court. I don't think it is necessary for you to spend time in argument, Mr. Crowley. I think upon the last authority cited by the counsel there is no defense in this case. It is entirely clear that where there is a distinct judicial set, the party performing the judicial act is not responsible, civilly or criminally, unless corruption is proven, and in many cases not when corruption is proven. But where the act is not judicial in its character, where there is no discretion, then there is no legal protection. That is the law as laid down in the authority last quoted, and the authority quoted by Judge Selden in his opinion. It is undoubtedly good law. They hold expressly in that case that the inspectors are administrative officers and not judicial officers. Now this is the point in the case, in my view of it. If there was any case in which a female was entitled to vote, then it would be a subject of examination. If a female over the age of 21 was entitled to vote, then it would be within the judicial authority of the inspectors to examine and determine whether in the given case the female came within that provision. If a married woman was entitled to vote, or if a married woman was not entitled to vote, and a single woman was entitled to vote, I think the inspectors would have a right in a case before them to judge upon the evidence whether the person before them was married or single. If they decided erroneously, their judicial character would protect them. But under the law of this state, as it stands, under no circumstances is a woman entitled to vote. When Miss Anthony, Mrs. Layden, and the other ladies came there and presented themselves for registry, and presented themselves to offer their votes, when it appeared that they were women, that they were of the female sex, the power and authority of the inspectors was at an end. When they act upon a subject upon which they have no discretion, I think there is no judicial authority. There is a large reign of discretion in regard to the votes offered by the male sex. If a man offers his vote, there is a question whether he is a minor, whether he is 21 years of age. The subject is within their jurisdiction. If they decide correctly, it is well. If they decide erroneously, they act judicially and are not liable. If the question is whether the person presenting his vote is a foreigner or naturalized, or whether he has been a resident of the state or district for a sufficient length of time, the subject is all within their jurisdiction, and they have a right to decide, and are protected if they decide wrong. But upon the view which has been taken of this question of the right of females to vote, by the United States Court at Washington, and by the adjudication which was made this morning, upon this subject there is no discretion, and therefore I must hold that it affords no protection. In that view of the case, is there anything to go to the jury? Mr. Van Voorhees: Yes, Your Honor. The Court: What? Mr. Van Voorhees: The jury must pass upon the whole case, and particularly as to whether any ballots were received for representative in Congress or candidates for representative in Congress, and whether the defendants acted willfully and maliciously. The Court: It is too plain to argue that. Mr. Van Voorhees, there is nothing but circumstantial evidence. The Court, your own witness testified to it. Mr. Van Voorhees, but knowingly, Your Honor, implies knowing that it is a vote for representative in Congress. The Court, that comes within the decision of the question of law. I don't see that there is anything to go to the jury. Mr. Van Voorhees, I cannot take Your Honor's view of the case, but of course must submit to it. We ask to go to the jury upon this whole case and claim that in this case, as in all criminal cases, the right of trial by jury is made inviolate by the Constitution, that the court has no power to take it from the jury. The Court, I am going to submit it to the jury. Gentlemen of the jury, this case is now before you upon the evidence as it stands, and I shall leave the case with you to decide. Mr. Van Voorhees, I claim the right to address the jury. The Court, I don't think there is anything upon which you can legitimately address the jury. Gentlemen, the defendants are charged with knowingly, willfully, and wrongfully receiving the votes of the ladies whose names are mentioned in November last in the city of Rochester. They are charged in the same indictment with willfully and improperly registering these ladies. I decided in the case this morning, which many of you heard probably, that under the law as it stands, the ladies who offered their votes had no right to vote whatever. I repeat that decision, and I charge you that they had not a right to offer their votes. They having no right to offer their votes, the inspectors of election ought not to receive them. The additional question exists in this case whether the fact that they acted as inspectors will relieve them from the charge in this case. You have heard the views which I have given upon that. I think they are administrative officers. I charge you that they are administrative and ministerial officers in this respect, that they are not judicial officers whose action protects them, and that therefore they are liable in this case. But instead of doing as I did in the case this morning, directing a verdict, I submit the case to you with these instructions, and you can decide it here or you may go out. Mr. Van Voorhees, I ask Your Honor to instruct the jury that if they find these inspectors acted honestly in accordance with their best judgment, they should be acquitted. The Court, I have expressly ruled to the contrary of that, gentlemen. That makes no difference. Mr. Van Voorhees, and that in this country, under the laws of this country. The Court, that is enough. You need not argue it, Mr. Van Voorhees. Mr. Van Voorhees, then I ask Your Honor to charge the jury that they must find the fact that these inspectors received the votes of these persons knowingly, and that such votes were votes for some person for member of Congress, there being in the case no evidence that any man was voted for member of Congress, and there being no evidence except that secret ballots were received, that the jury have a right to find for the defendants if they choose. The Court, I charge the jury that there is sufficient evidence to sustain the indictment upon this point. Mr. Van Voorhees, I ask Your Honor also to charge the jury that there is sufficient evidence to sustain a verdict of not guilty. The Court, I cannot charge that. Mr. Van Voorhees, then why should it go to jury? The Court, as a matter of form. Mr. Van Voorhees, if the jury should find a verdict of not guilty, could Your Honor set it aside? The Court, I will debate that with you when the occasion arises. Gentlemen, you may deliberate here or retire as you choose. The jury retired for consultation, and the court took a recess until 7 p.m. The court reconvened at 7 o'clock, when the clerk called the jury and asked them if they had agreed upon their verdict. The foreman replied in the negative. The Court, is there anything upon which I can give you any advice, gentlemen, or any information? A juror, we stand 11 for conviction and 1 opposed. The Court, if that gentleman desires to ask any questions in respect to the questions of law or the facts in the case, I will give him any information he desires. No response from the jury. It is quite proper, if any gentleman has any doubt about anything, either as to the law or the facts, that he should state it to the court. Counsel are both present, and I can give such information as is correct. A juror, I don't wish to ask any questions. The Court, then you may retire again, gentlemen. The court will adjourn until tomorrow morning. The jury retired, and after an absence of about 10 minutes returned into court. The clerk, gentlemen, have you agreed upon your verdict? The foreman, we have. The clerk, how say you, do you find the prisoners at the bar guilty of the offense whereof they stand indicted, or not guilty? The foreman, guilty. The clerk, hearken to your verdict as it stands recorded by the court. You say you find the prisoners at the bar guilty of the offense whereof they stand indicted, and so say you all. Mr. Van Voorhees, I ask that the jury be polled. The clerk polled the jury, each juror answering in the affirmative to the question, is this your verdict? June 19. A motion for a new trial having been made and overruled, the court asked the defendants if they had anything to say why sentence should not be pronounced. Beverly W. Jones. Your Honor has pronounced me guilty of crime. The jury had but little to do with it. In the performance of my duties as an inspector of election, which position I have held for the last 4 years, I acted conscientiously, faithfully, and according to the best of my judgment and ability. I did not believe that I had a right to reject the ballot of a citizen who offered to vote and who took the preliminary and general oaths, and answered all questions prescribed by the law. The instructions furnished me by the state authorities declared that I had no such right. As far as the registry of the names is concerned, they would never have been placed upon the registry if it had not been for Daniel Warner, the Democratic Federal Supervisor of Elections, appointed by this court, who not only advised the registry but addressed us, saying, Young men, do you know the penalty of the law if you refuse to register these names? And after discharging my duties faithfully and honestly and to the best of my ability, if it is to vindicate the law that I am to be imprisoned, I willingly submit to the penalty. Edwin T. Marsh. In October last, just previous to the time fixed for the sitting of the Board of Registrars in the 1st District of the 8th Ward of Rochester, a vacancy occurred. I was solicited to act, and consenting was duly appointed by the Common Council. I had never given the matter a thought until called to the position, and as a consequence knew nothing of the law. On the morning of the first day of the last session of the board, Miss Anthony and other women presented themselves and claimed the right to be registered. So far as I knew, the question of woman suffrage had never come up in that shape before. We were in a position where we could take no middle course. Decide which we might, we were liable to prosecution. We devoted all the time to acquiring information on the subject that our duties as registrars would allow. We were expected, it seems, to make an infallible decision, inside of 2 days, of a question in regard to which some of the best minds of the country are divided. The influences by which we were surrounded were nearly all in unison with the course we took. I believed then and believe now that we acted lawfully. I faithfully discharged the duties of my office according to the best of my ability in strict compliances with the oath administered to me. I consider the argument of our counsel unanswered and unanswerable. The verdict is not the verdict of the jury. I am not guilty of the charge. The court sentenced the defendants to pay a fine of $25 each and the costs of the prosecution. End of Section 8.
Section 9 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Matthews F. Ward for the murder of William H. G. Butler, Kentucky, 1854, Part 1. The narrative. William Ward, a boy of 15 and a pupil in the Louisville High School, returned home one evening and informed his elder brother, Matthews, who was 24 years of age and married, but living at his father's house, that he had been severely and unjustly whipped by Mr. Butler, the principal. Although I could have borne that, I cannot bear to be called a liar before the whole school, he added. The parents were away from home, but next morning, the 2nd of November, 1853, they returned, and after the father had heard the story and consented to his going, Matthew set out to the school to demand an explanation, accompanied by William and another brother, Robert. Matthews was armed with a loaded revolver, and Robert carried a bowie knife, as was his custom. Arrived at the school, they went into a room filled with boys and inquired for Professor Butler. One of the boys went for him. When he came in, Matthews bade him a good morning and said, "I have called around, Mr. Butler, to have a little conversation with you." Butler replied, "Walk into my private room." Matthews declined, saying, "No, the matter about which I wish to speak with you occurred here, and this is the proper place to speak of it. Mr. Butler, what are your ideas of justice? Which do you think the worse, the little boy who begs chestnuts and scatters the hulls on the floor, or my brother William, who gives them to him?" Butler replied, "I will not be interrogated, sir." Matthews continued, "I have asked a civil question and have a right to a civil answer. Which is worse, the contemptible little puppy who begs chestnuts and then lies about it, or my brother William, who gave them to him?" Butler answered, "There is no such boy here." "Then," said Matthews, "that matter is settled. I have another question to ask. You called my brother a liar, and I must have an apology." "I have no apology to make." "Is your mind fully made up about that?" "It is. I have no apology whatever to make." "Then," says Matthews, "you must hear my opinion of you. You are a damned scoundrel and a coward." What occurred then and for the next few minutes is not very clear. Several of the boys who were in the room testified that Matthews struck Butler, whereupon the latter took hold of him, and then Matthews drew his pistol and shot Butler, and that the latter did not strike Matthews first. And this was the dying statement of Professor Butler. But Robert Ward testified at the word coward. Butler struck Matthews and pushed him against the door and to the ground, and an individual named Barlow appeared as a witness for the defense and told the story of being present at the Harney house and of his having heard Butler state the same thing. But his story was thoroughly discredited and shown to be false. The affray caused great excitement among the boys in the room, most of whom, in a panic, jumped out of the windows, accompanied by the second master, who seemed as frightened as they were. Butler fell to the ground on being shot, exclaiming, "I am killed. May God forgive me, my poor wife and child." A number of the pupils carried him to the house of Colonel Harney, nearby, where he died at midnight. The Ward family was very prominent in Louisville, and the tragedy caused so much discussion in that city that the venue was removed to Elizabethtown, where the hearing began on the 18th of April, 1854. Both Matthews and Robert had been indicted by the grand jury, but the former only was put on trial. He was represented by no less than 9 lawyers, among them John J. Crittenden, at that time a great figure in national politics, John J. Helm, governor of Kentucky, and Thomas F. Marshall, the Tom Marshall of the Silver Tongue, and the foremost orator of the state. The plea was self-defense. The whole controversy centered on the question, did Butler strike Matthews first? For it seemed to be taken for granted that a blow must be presented by a gentleman with a shot or a stab, and from the evidence of several of the witnesses, it would appear that in those days every man in Kentucky went armed. The jury were evidently persuaded by the eloquence of the prisoner's counsel that the story of Robert Ward was true, and after a trial lasting 14 days, they returned the verdict of not guilty. The trial. Footnote. Bibliography. Full and authentic report of the testimony on the trial of Matt F. Ward, certified to be correct by Thomas D. Brown, Clerk of Hardin Circuit Court, William Alexander, former Commonwealth Attorney for the Hardin District, and Judge Alex Walker of New Orleans, with the speeches of Governor Crittenden, Governor Helm, T.F. Marshall, Esquire, and Nathaniel Wolfe, Esquire, and the reply of Alfred Allen, Esquire, Attorney for the Commonwealth, reported by A.D. Richardson, New York, D. Appleton and Company, 346 and 348 Broadway, 1854. Trial of Matt F. Ward for the murder of Professor W. H. G. Butler before the Hardin Criminal Court, April term, 1854. Reported for the Louisville Courier and Louisville Democrat by George Cole, Louisville. Martin and Griswold, Stereotypers and Printers, 1854. The two reports seem to represent the different sides of the controversy, though the Richardson is probably a correct one as far as it goes. Yet it gives the speeches of the counsel for the defense with great fullness, while it omits all the speeches for the prosecution, except that of Mr. Allen, page 284. The Cole report, on the other hand, omits the speech of Governor Helm, page 147, and Mr. Harris's speech is not reported by either. End of footnote. In the Circuit Court of Hardin County, Elizabethtown, Kentucky, April 1854. Honorable J.W. Kinchlow, Judge, April 18th. The indictment, brought by a change of venue, from Jefferson County, charged Matthews F. Ward with murder in the first degree, committed on William H. G. Butler on the 2nd of November, 1853, by shooting him with the pistol, the ball of which took effect in his left breast, and caused his death on the 3rd of November. Footnote. On December 15, 1853, a motion was made before Judge Bullock of the Jefferson Circuit Court by the counsel of Matt F. and Robert J. Ward, Jr., for a change of venue. This motion was heard on the 19th, at which time affidavits were introduced to show that the excitement against the prisoners in Louisville and Jefferson County was such as would be likely to prevent a fair and impartial trial. The attorney for the Commonwealth, E. S. Craig, resisted the motion, but the judge decided that the change asked for should be granted, and as affidavits by citizens of Oldham and Shelby counties were introduced by the defendant's counsel to show that a fair and impartial trial could not be had in either of them, Judge Bullock decided that the case should go to Hardin. In accordance with this decision, the prisoners were removed to Elizabethtown on the 1st of February and committed to the jail in that town. End of footnote. Robert J. Ward, Jr. was charged with aiding and abetting in the second count and as a principal in the first count of the indictment. Alfred Allen, Commonwealth Attorney Sylvester Harris, T.W. Gibson, and R.B. Carpenter for the state. Footnote. Allen Alfred, Representative, Breckinridge County, Kentucky Legislature, 1838 to 1839. Commonwealth Attorney, 1840 to 1856. Whig candidate for Lieutenant Governor, 1859. Re-elected to Legislature, 1861, and continued in that capacity until 1866. State Treasurer, 1867. Consul at Fuzhou, China, 1867. Harris Sylvester, Member Kentucky Senate, 1853 to 1857. End of footnote. John J. Crittenden, Thomas F. Marshall, John L. Helm, George A. Caldwell, Nathaniel Wolfe, Thomas W. Riley, Charles G. Wintersmith, James W. Hayes, and R. B. Hayes for the defense. Footnote. Crittenden, John J., 1787 to 1863. Born in Kentucky, graduated William and Mary College, 1807. Attorney General of Illinois, 1809. United States Senator, Kentucky, 1817 to 1819. 1835 to 1841. 1842 to 1848. 1855 to 1861. United States District Attorney, 1827 to 1829. Attorney General, United States, 1835-1850. Governor of Kentucky, 1848. Marshal, Thomas Francis, 1801 to 1864. born Frankfort, Kentucky, nephew of Chief Justice Marshall, member of Kentucky Legislature, 1832 to 1851, member of United States Congress, 1841 to 1843. A contemporary writer calls him the foremost Kentuckian orator of his time, and for that matter, any time since his time, including the first orators Kentucky has produced. He was popularly known as Tom Marshall of the Silver Tongue. Helm John L., 1802 to 1867, born Kentucky, practiced law, member state legislature, 1826 to 1837, speaker, 1835, state senator, 1844 to 1848, governor of Kentucky, 1850, 1867. Caldwell George A., born in Kentucky, representative in Congress, 1843 to 1845, and 1845 to 1851, died 1866. Wolfe Nathaniel, 1810 to 1865, born Richmond, Virginia, graduated University of Virginia, practiced law in Kentucky, 1839 to 1852, Commonwealth Attorney, 1852, State Senator, 1853 to 1855, Member Legislature, Louisville, 1859 to 1863, Member Union Constitutional Convention, 1861, achieved great pecuniary success at the bar and a high reputation as a lawyer and pleader, being regarded as one of the most able and eloquent lawyers in the United States. Riley Thomas W., member Louisville Bar, Mayor Louisville, 1859, Representative State Legislature, 1835 to 1849, Speaker, 1849, Presidential Elector, 1841, died 1872. Wintersmith Charles G., member House of Representatives, 1838 to 1847, and 1851 to 1855, Speaker of Kentucky House, 1854, Presidential Elector, 1841. End of footnote. The court made an order prohibiting the reporters who were furnished receipts by the court from publication of testimony during the progress of the case, deeming such publication prejudicial to the interest of justice and likely to interfere with a fair and impartial trial. The counsel on both sides were not members of the Hardin County Bar, appeared and were duly qualified by taking the prescribed oath. At 9 o'clock, the prisoners were brought into the courtroom, accompanied by their friends. The elder, Matt F. Ward, was in a very feeble and reduced condition, induced by a severe attack of neuralgia, from which he had been suffering for several months. He was unable to walk without the assistance of crutches. The counsels, both for the Commonwealth and the defense, expressed themselves in readiness to proceed to trial. Mr. Helm moved that the prisoners be tried separately. The court granted a severance, but left to the Commonwealth Attorney the privilege of deciding which of the prisoners should go first to trial. Mr. Allen decided that Matthews F. Ward, as the principal in the case, should be tried first. The prisoner entered a plea of not guilty. The impaneling of the jury was commenced. A majority of those called had formed and expressed an opinion on the case from public rumor and newspaper reports, and were therefore incompetent to try it. When the regular panel was exhausted, therefore, only 5 jurors had been selected, and the sheriff was directed to bring in bystanders until the full complement should be procured. The jury was at last declared full, after 51 had been excused from serving, being incapacitated by the cause alluded to above. There was but one peremptory challenge made by the counsel for the defense. The others were excluded by the court as disqualified or having formed an opinion. It consisted of the following gentlemen, who were duly impaneled and sworn: Green Walker, Thomas M. Yates, James Crutcher, George Stump, Raleigh McIntyre, John Young, Thomas Thurston, Isaac C. Chenoweth, Asa Buckles, William Eidson, Abraham Neighbors, Richard Pierce. The indictment was read to the jury by the clerk. Judge Kinchlow. Gentlemen, the defendant in this case has been arraigned and has entered a plea of not guilty, throwing himself upon God and his country for trial. You are to try him according to your oaths upon this indictment. If you find him guilty, you will say so. If not guilty, you will thus return him to the court. In case the killing shall be proved to have been done by the defendant under the influence of excitement and passion, you may find him guilty of manslaughter under this indictment, and will do so. Should it appear that the killing was done in self-defense, it was not an act of voluntary manslaughter, and you will find him not guilty. Mr. Wolfe asked that the court permit no witnesses for the Commonwealth to remain in the courtroom during the progress of the trial except the one under examination. Mr. Allen made a similar motion in regard to the witnesses for the accused. He desired to sail under equal colors here, and from the well-known reputation of the gentleman engaged on the other side, he had no doubt that they would concur in such a wish. Mr. Wolfe objected. He desired to have the case tried in the most fair and impartial manner, but in the course of a criminal practice of 15 years, he had heard such a motion made only 3 times, and in each instance it had been promptly overruled by the court. At the present stage of the proceedings, it would be impossible to furnish a complete list of the witnesses for the defense, and some might be called during the progress of the trial who were not yet subpoenaed. It might be necessary that some one or more witnesses for the defense should be present during the examination of the witnesses for the Commonwealth, that they might identify them for reasons thereafter to be assigned. The motion supposed the universal depravity of the whole human race. The court remarked that the question was exclusively one of practice, and left to the discretion of the court. When such orders were made, it was done to promote the ends of justice, and founded not on the hypothesis of the total depravity of the whole human race, but simply on the common sympathy universally existing, and to enable every witness to detail facts as they had been communicated to his own senses, and with no reference to any statements which might have been made by others. In this case, the court deemed the order necessary, and would make it, though it was not so stringent as to exclude testimony which might be made known during the progress of the trial, but of which the counsel were not yet aware. Mr. Crittenden said that there were many witnesses present who had been called simply to prove character, and were anxious to be in the room during the progress of the trial. The court said that the rule might be waived in regard to such witnesses. As the procuring of a full list of the witnesses would consume considerable time, the court took a noon recess. Prior to adjournment, however, the court instructed the jury thus: You have been empaneled and sworn, gentlemen, to try a case of peculiar importance, both to the Commonwealth and the defendant. The court has deemed it its duty, therefore, to make such arrangements that you will not be separated during the progress of the trial. You will not, of course, converse with anyone or listen to any conversation in regard to this case, and should any person persist in addressing you upon it, you will report their names to the court at once. Neither will you converse with anyone upon any subject whatever, unless in presence of the sheriff or by special permission of the court. On the opening of court in the afternoon, Mr. Allen said that he observed on the list of witnesses for the defense the names of Mr. and Mrs. Robert J. Ward, the parents of the accused. They must necessarily feel a deep interest in the progress of the trial, and the Commonwealth had no desire that the rule in regard to the exclusion of witnesses should apply to them. All witnesses, both for the Commonwealth and the defense, were to be procured, were brought in and sworn collectively. Witnesses for the Commonwealth: Edward W. Knight, am 16 years old, was a student in Professor Butler's schoolroom on November 2, 1853. In the morning, about 9:30, a Negro came over to the schoolroom and took home all the books of Victor and William, the two younger brothers. About 10 o'clock, saw Matt, Robert, and William come to the building. Was in Mr. Sturgis's recitation room, but went out to see what would take place. Saw Matt speak to Mr. Butler. He told him he had a little matter to settle with him. Mr. Butler said something in a low tone, which I understood to be to invite him to come into his study. Matt said no, and asked him which was the more to blame, the little contemptible puppy, who baked chestnuts and then told a lie about it, or his brother William. Mr. Butler asked him to step into his study, but he refused again, and said if he could not answer there, he did not want an answer. He then asked him why he called his brother William a liar. I then heard Matt call Butler a damned liar and a damned scoundrel. Matt appeared to be very much excited and saw that they drew nearer together, and Butler approached Ward. Do not think Butler struck him, but I observed a moment after that Butler had his hand on Matt's shoulder. Matt drew his right hand from his pocket while he and Butler were clinched, and drew out a pistol with it. He presented it immediately to Butler's left lung and fired. Butler dropped immediately. Matt then drew another pistol, and Robert drew a knife which he flourished about. And when Mr. Sturgis, one of the other teachers, came in, Robert said to him, "Come on," and approached him. Mr. Sturgis retired to his own room, but came out a moment after, when Robert chased him with the knife back into his room, and Sturgis made his absence out of the window. One or two of the other scholars and myself assisted Butler to walk away. When we had gone 1 square, he wished to lay down and could not walk. We took him into Mr. Harney's residence. Butler knocked the pistol from his breast after it was fired and went into Sturgis's recitation room. He came out a moment after and motioned to the scholars that he was done for. Think Matt Ward struck Butler first. Butler then stepped forward and laid his right hand on Matt's left shoulder. Did not hear Butler make any remark to Ward, except asking him to step into the office, and replying to his question that he did not feel like answering it, without giving an explanation. It was then Ward replied by calling him a liar and a scoundrel. When Butler fell, he exclaimed, "I am killed. May God forgive me. My poor wife and child." After he fired the pistol, Ward pointed the one he drew afterwards around the schoolroom for a few minutes, and then left. He walked away very deliberately. He left the pistol he had fired on the floor. It was a small self-cocking pistol with a walnut handle. Think this is one of the same description. Butler did not seem much agitated. He replied in a low tone to the question. He always spoke low. Ward's voice was loud. He appeared agitated after he had spoken to Butler, though not before. Noticed by the working of his right hand that he was very nervous at the time. There were only 3 of the other pupils assisted Butler to Colonel Harney's. No one else entered the house with us, I think, but I was much agitated. After we were in the house, noticed another gentleman there, whose name I did not know, before Dr. Thompson came in. We had laid Professor Butler down, and he told us to set him up. Should know the gentleman were I to see him. Do not think the whole affair occupied more than 10 minutes. Cross-examined. When Ward came, Butler was in his recitation room with several of the boys. Do not recollect who they were. I testified before the grand jury. When Ward called for Butler, a boy went for him. When Ward entered, observed his right hand was in his pocket or wrapped in his coat. He held his hat in his left hand. All the boys in Mr. Sturgis' room rushed for the door when they saw the Wards enter. He called us back. When I asked to be excused, he granted the request, and I went out while the other boys returned into the room. Those who remained there could not see the occurrence, can give the names of some of the boys who composed the class, and remained in the room. Robert Trimble and William Fagan were 2 of them. There were about 40 pupils in the school, with the exception of those in the recitation rooms. The boys were then in the schoolroom. When Ward asked the questions, heard Butler reply in a low tone, "I don't feel disposed." This was all I heard him say. All I have related about inviting him into his study, etc., has been told me since. Thought Ward struck Butler. Thought so, because I saw Ward bring down his left hand with a gesture, and Butler fall back. Butler then sprang forward and laid his hand on his shoulder. It was not done gently. Did not see Butler strike at all. No, he did not strike after he was shot. Butler had not beaten Ward down before the pistol was fired. Did not hear Ward say to Butler that he had a little matter to settle with him. Only heard him say, "I wish to see you." Could not hear the replies of Butler. He spoke so low. All that I heard from him was, "I don't feel disposed." The remark about the chestnuts alluded to the punishment of William Ward the day before. The only thing I heard Robert Ward say to Sturgis was, "Stand off." Immediately on the report of the pistol, Sturgis came out of the recitation room into the large hall. Butler was then on the floor. Sturgis had nothing in his hand when he came out of his recitation room. Did not hear Butler invite Ward into his recitation room. Now I have thought of it more fully. Did not see Sturgis in his room when Butler went in there. After he was shot. Think he had run out of the window before that time. Have said he was one of the worst frightened men I ever saw. To Mr. Carpenter. I said in my examination in chief that I saw the Wards coming in the hall. Said that I wished to be excused and left the room, and that I saw Butler come out of the room. Mr. Marshall. I must object to this line of examination. The court has already ruled that only one lawyer shall cross-examine a witness. I now request a ruling limiting the extent to which gentlemen are allowed to repeat, word for word, the questions which they ask the witness on the examination in chief. Such a course gives an advantage to the side which pursues it, and gains the last lick, and will also render this case absolutely interminable. The defense will have to cross-examine again, and the boy will not live long enough to finish his testimony. Mr. Carpenter, I have no desire to obtain any last lick. I have simply wished to save time, as I desire to recall the attention of this witness to a single point. It is my intention to seek no unfair advantage, but to conduct this case on high, professional, and honorable principles. Mr. Marshall, I suppose the gentleman, in boasting of his high, honorable, and lofty method of practice, which we have not impeached as yet, intends to cast no imputation on other gentlemen in the case, as pursuing a contrary course. Mr. Carpenter, certainly not. Mr. Marshall, then the self-advertisement of the gentleman's numerous virtues was quite unnecessary, and given in advance of any demand for it. I renew my request to the court, as proper and necessary. I am sorry to see so much excitement so early in the trial, and trust it will not be repeated. The court. The witness may be questioned only on new matter brought out in the cross-examination, and re-examined on points in regard to which he had not been so explicit as to be clearly understood. End of Section 9. Section 10 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Matthews F. Ward for the murder of William H. G. Butler, Kentucky, 1854. Part 2. Night. Ward struck Butler first. Professor Butler went into the recitation room of Sturgis. After he was shot, thought Butler made a motion as if to invite Ward into his study. William Worthington. was in the schoolroom when William Ward entered. He went to the seat he had formerly occupied, and I then looked around, saw Matt and Robert Ward standing in the hall, and Mr. Butler came out of his room, heard Matt say, "Which do you think is the more to be despised? The contemptible little puppy who begs chestnuts and then lies about it, or my brother William, who gave him the chestnuts?" Butler replied, "If you will walk into my room, I believe I can explain the matter satisfactorily." Ward refused. The next thing I heard was Ward asking, "Well, if you will not answer that question, will you tell me whether you called my brother a liar?" Butler replied, "I cannot answer this unless I am allowed to explain." Did not hear all the conversation, as Professor Butler had often requested us not to look around when people came in, and my back was towards the door. Next thing I heard was a slight stamping. Turned around again, just as the pistol was fired and Butler was falling. Ran out at the nearest door, and when I returned, Ward had gone, and the boys were just assisting Butler away. Am 18 years old. Cross-examined. There was no other boy of my name in school. Suppose it is about 10 feet from the door of Mr. Sturgis's recitation room, to the point where Professor Butler fell. Butler spoke in a very low voice. Heard his replies distinctly, however. Did not hear the expression, "damned scoundrel" or "damned liar" at all. Only a few of the boys in the schoolroom could see into Butler's recitation room. Did not see Butler after I went out. The boys scattered in every direction after the firing. My seat was between 30 and 40 feet from the parties. Mr. Marshall. Did you not hear the boys there, one and all, inform Mr. Allen that Butler struck Ward first? Mr. Carpenter. We object to this method of examination. Mr. Marshall. I do not ask the question that the answer may be admitted as proof that Butler did actually strike the first blow, but I am conducting a cross-examination and propounded to test the memory and veracity of this witness. The testimony that he has given is of considerable magnitude. If I can show, therefore, that an important event then and there occurred, which either does not recollect or denies here, it will show he was in such a state of mind at the time that no reliance can be placed on his account of the circumstances. The court. I understand the rule to be that questions may be asked in regard to any matter outside the one at issue, to test the recollection of the witness, but there is no rule of law by which illegal testimony can be introduced or collateral issues proved in testing the credibility of a witness. Worthington. Have no recollection of seeing Mr. Allen on that day. Attend church sometimes. Have been in the Sabbath school a few times. Mr. Marshall. Does the gentleman desire to prove that his witness is an infidel and that his religious education has been entirely neglected? If so, we readily admit it. The court. Such questions seem to be unnecessary, and I trust will be omitted in the examination. Mr. Carpenter. Certainly, if they are deemed improper, and this seems to be hardly the place for theatrical performances we have just witnessed. Mr. Marshall. There is a great variety of theaters in this world, and you have performed characters in some of them that are by no means enviable. Mr. Carpenter. So have you, sir. The court. I must insist that the gentleman refrain from remarks of this character. Mr. Marshall. I desire to treat the court with all due respect, but, sir, the gentleman has addressed a personal charge at me, and I felt bound to retort. He has accused me of assuming theatrical airs, which I must certainly repel. Why, sir, my manners are the most natural in the world, and have been too long worn to be thrown off at this late day. And when a personal and insulting remark is made, commenting upon them, I need not say that it is offensive. Mr. Carpenter. I intend no insult to Captain Marshall. It was merely a sidebar remark. The court. Let the case proceed without further interruption. James S. Pirtle, in 13 years of age, was in school on 2nd November, saw Mr. Ward come and inquire for Mr. Butler, heard him ask which was the worst, a contemptible puppy who begged the chestnuts and told a lie, or the one who gave them to him. Butler said he would explain if Ward desired it. He replied he wanted his question answered, and the next thing I heard was the expression, "Whoever calls my brother a liar," then heard the pistol discharged, and saw Butler fall. When I ran out, as I went in again, saw Robert Ward come back and pick up a pistol laying on the floor, and carry it away. The first words I heard from Ward were something about ideas of justice and chestnuts. During the conversation, Ward had his hat in his left hand. Cross-examined. Could not hear what Mr. Butler said during the conversation. Saw that he had his arms extended. Did not see Butler strike Ward. My back was towards them. Did not tell anyone that Butler struck Ward the first blow. Minor Pope, in 17 years of age, was in Professor Butler's school on the 2nd November. Matt, Robert, and William Ward came to the schoolhouse, and while William went into the schoolroom, Matt inquired for Butler. Went for Butler, told him 2 gentlemen wished to see him. He came out and bade Matt good morning. He returned the salutation and said, "I have a matter to settle with you." Butler replied, "Step into my room." Ward said, "No, sir. Answer my question. Why did you call my brother William a liar?" Butler declined answering. Some other words passed between them while I continued an exercise I was writing. When I looked up again, Ward had a pistol and discharged it. Think he took it from his pantaloons pocket. Noticed his right hand in his pocket when he entered. After Butler was shot, he exclaimed, "My poor wife and child." They were very close together when the pistol was fired. Noticed that Butler raised his hand just as the pistol was fired. Observed Ward make 1 or 2 gesticulations with his left hand during their conversation. Butler was between Ward and myself. Cross-examined. Could not see the parties without turning. Did not pay it particular attention to the conversation. Ward appeared to be somewhat excited. Am sure his hand was in his pantaloons pocket. When Butler raised his arms, he sprang towards Ward. Mr. Caldwell. Did not Butler strike Ward when he sprang upon him before the pistol was fired? Pope, and unable to state, as the change in his position prevented me from seeing. Saw no blow struck between the two. The distance between the parties when the pistol was fired was 3 or 4 feet. April 19th. John A. Campbell, in 20 years of age, was present in the schoolroom. When the Wards came, William entered the schoolroom and Matt inquired for Butler. When he came, they bade each good morning. Matt said something about a little matter to settle. Heard Ward ask, "Which is the more to blame, my brother or the contemptible little puppy who begs the chestnuts of him?" Did not hear Butler's reply. Then heard Ward say, "If you will not answer that question, I have another for you. Did you call my brother a liar?" The only portion of Butler's answer that I heard was, "Well, Mr. Ward." Butler spoke very low. Robert Ward was standing near, and as I feared he might use some unfair weapons or something of the kind, I turned around to pick up a pair of tongs and prevent it. While I was turned, heard Ward call Butler a damned liar. Shortly after, heard the pistol fired. Not more than 6 seconds passed between this expression and the firing of the pistol. The boys all ran out then. Saw Robert flourishing a knife. Did not observe the position of Ward's hands when he entered. He seemed excited. Spoke a little above his ordinary tone. Did not see Butler strike Ward. Do not think he struck. But he made some motion towards Ward. Butler's back was to me. I turned around to look just as I heard the expression, damned liar. Knew there would be a fight then. It was just after that Butler made a movement towards Ward, assisted in taking Butler to Colonel Harney's, and remained there until 10 o'clock that night. The only person with me, whom I recollect, was Knight. Saw no one but the schoolboy's assistant taking him there. When Butler fell, the boys all ran out immediately, followed them and told them to come back, but only a few of them did so. Cross-examined. Saw Butler stagger across the entry and go into Sturgis's room. The only part of Butler's conversation I heard was, "Well, Mr. Ward." I was about 4 feet from the spot where Ward and Butler conversed. Did not hear the reply to which Ward said, "Well, if you had not answered that question, I have another for you." As soon as the lie passed, Ward made a motion to Butler. Could not see Ward make the motion, but I heard him move. Cannot tell whether he moved forward or backward. Butler's back was towards me, and between us, so that I could not see Ward distinctly. As soon as I heard the lie given, I turned around to pick up the tongs, and thus I only know that Ward made the motion by the sound on the floor. Butler then made a little quick movement. It was not as if moving away from Ward. I thought if Butler were going to whip Matt, that Robert might interfere with a knife or something. Mr. Marshall. Well, sir, was it not your impression from what you saw then that Butler was about to whip Ward? Mr. Carpenter. We object to the question as improper. Mr. Marshall. It will be remembered that the Commonwealth had proved by the witness that he thought there was to be a difficulty. I wish to show more particularly what he thought the nature of the trouble was to be. Mr. Gibson. If his testimony on that point was improper, the gentleman should have objected to it at the time. Mr. Marshall. If the gentleman introduced incompetent evidence and obtained the benefit of it, I suppose they will not make us responsible for it, because we did not object. Mr. Gibson. We have no desire to introduce incompetent testimony at any point. Mr. Marshall. I presume not, and once for all, to prevent future misunderstandings, I wish to state that in commenting upon the course of any gentleman present, I shall not assail his attentions, unless I do it plainly and explicitly. The court permitted the question, in view of the previous testimony given by the witness on that point during his examination in chief. Campbell. It was my intention when I picked up the tongs to keep Robert off while Butler whipped Matt. Knew, of course, that he would not stand the damned lie. Butler was a courageous man. He would not stand an insult. There was something about Butler's movement, I don't know exactly what, that induced me to believe he was going to resent the insult he had received. Butler could not have whipped Ward. It was my impression from the appearance of Matt Ward when he came in that he was in good health. He had no such wan, pale, feeble look as he wears now. Never saw Butler fight, or knew him to have a quarrel. Mr. Marshall objected to going into the general character of Butler. The defense were ready to admit at once that he was a peaceful, quiet, decorous gentleman, and that no one could possibly regret his death more deeply than the parties now on trial. His question not only elicited the fact that the deceased, to his honor be it spoken, was a brave man who would not bear an insult, not that he was a quarrelsome one. Mr. Carpenter said that as the fact was admitted, the question would not be pressed. George W. Crawford, am 17 years of age, was in the schoolroom when the boards came. Matt asked Butler which was the worst, a contemptible little puppy who begged the chestnuts, and then lied about it, or his brother who gave them to him. Butler replied, "Walk into the next room and I will explain it to you." Ward said, "I want an answer here, and if you will not reply to this question, I have another for you. Did you call my brother a liar?" Did not hear the answer, and Ward said something more which I did not hear. Ward advanced towards Butler, noticed that Butler's right hand was on Ward's left shoulder, and Butler's left hand was catching at Ward's right arm. Just then the pistol fired. My back was towards the parties. Ward held his hat in his left hand and gesticulated with it, held the pistol in his right hand when he fired it. Did not see the pistol until the very moment he fired. Saw no striking. Butler staggered towards the door of Sturgis's room and fell. Afterwards got up and started to enter the room. Cross-examined. First heard Ward say something about settling a little affair or something of that kind. I was 8 or 10 feet from them when they conversed. Heard Butler distinctly ask Ward to walk into the next room. Butler spoke in his ordinary tone. He said, "This is no place to answer such a question." Did not hear the latter part of the conversation. Anticipated no difficulty. Did not hear the lie given at all. Ward moved about 3 steps towards Butler. Butler did not approach him. Expected a difficulty then. Judged that Ward had a knife. From the tone of voice in which he spoke, there was a noise in the room which prevented me from hearing the damned lie given. A.B. Zanzinger. Am 17 years of age. Was present in the schoolhouse when this affair occurred. A servant came there that morning for Victor Ward and his books. About 10 o'clock was reciting in Sturgis's room. While we were there was very loud talking in the schoolroom. Sturgis and the most of the class stepped to the door and saw Matt Ward engaged in loud conversation with Butler. Sturgis called us back and the recitation went on, the door being closed. Shortly after we heard a pistol discharged. We went out immediately. Butler had then been lifted up. Matt Ward had gone and Robert was flourishing a knife about the room. Cross-examined. Did not notice whether Butler was on the floor or not. When I went into the schoolroom the second time, jumped right out of the window and saw the boys taking Butler up toward Colonel Harney's house. Butler was not brought into Sturgis's recitation room while I was there. Did not see Sturgis after I went back into his room the second time. Do not know what became of him. William H. Fagan. Am 18. Was in Sturgis's recitation room. Heard one of the boys say, "Mr. Ward's are there." Went to the door for a moment and then returned. Just then heard a pistol discharged. Went to the door again. Matt Ward had gone. Butler was on the floor and Robert was flourishing a knife. Jumped out of the recitation room window and went around to the steps. In about 3 minutes, Butler came down the steps assisted by Knight, and we assisted him to Colonel Harney's. Believe no one else took hold of him except Johnson. There were men walking along with us. Cross-examined. It is 1 square from the schoolhouse to Colonel Harney's. Butler fell into my arms while we were on the way, and we then carried him in our arms. Davis M. Buckner. Am 13. Was in Butler's recitation room when a boy came in and told him Mr. Ward desired to see him. He went out, and shortly after, hearing loud voices, I went to the door. Ward just then shot Butler, and he fell next the door of Sturgis's room. Heard none of the conversation, went back and jumped out of the window. Cross-examined. Butler and Ward stood very near together when the pistol was fired. Think Butler was standing still. Did not notice any scuffling. Was a good deal scared. After Butler had left the house, I saw Sturgis going after Dr. Gaspari. Henry C. Johnson. Am 15. Was in Butler's recitation room when Minor Pope came in and said 2 gentlemen wanted to see Professor Butler. He went out. Could hear Butler and Ward in earnest conversation, but could not hear what they said. Saw the pistol fired and Butler fell towards Sturgis's room. Jumped out the window. Cross-examined. We supported Butler to the corner of 2nd Street. He then wanted to lay down and said he was dying. We carried him from there to Colonel Harney's. Stood about 10 feet from Butler and Ward. Did not hear a word that was said. Could not distinguish the voices apart. Joseph Benedict. Am 14. was present at Professor Butler's schoolhouse when the defendant came, was standing in the main schoolroom. When called for, Butler came out and spoke to Ward politely. Ward asked which was the most contemptible, the little boy who baked chestnuts and then lied, or his brother William. Did not hear Butler's reply. He always spoke very low. There was more conversation, but I could not hear the words. Saw Butler step forward and lay his right hand on Ward's shoulder. Nearly at the same instant saw the pistol flash. Did not see Butler strike. Cross-examined. Had risen from my seat and was still standing at it to go into the recitation room and ask Professor Butler something about my French lesson. When he came out to speak with Ward, did not hear a word that Butler said. Expected a difficulty when I saw Butler lay his hand on Ward's shoulder. I knew he would not do it for nothing. Believed Butler pushed Ward back when his hand was on his shoulder. Saw that Ward was bent over as he was pushed back before the pistol was fired. Do not recollect whether the two gentlemen came there and spoke with us or not. Was so excited that I could hardly think or see anything. Did not tell anyone there that Butler had struck first and Ward had then fired. Edward Quigley, M17, was present in the schoolhouse, sitting about 20 steps from the door, when the Wards came in and inquired for Professor Butler. He came out and spoke to them, and they then conversed in a very rapid manner. Was about 20 feet from them, but could hear none of the conversation. When I looked at them again, Butler had his hand on Ward's shoulder. Ward gave way a little and was pressed back against the door. He then fired, and Butler fell. Did not see Butler strike Ward. Cross-examined. When Butler put his hand on Ward's shoulder, they were about 8 feet from the door. He did not crush him to the ground, only towards the door. About 5 minutes passed between the time of Butler coming out and the firing of the pistol. Went out of the window through Butler's recitation room. Did not see Sturgis after the affair took place until he came across the street with Mrs. Butler. May have seen some gentlemen come up while there. Cannot say what I may have said to them. I was much excited. Sat facing the parties in the room. William R. Redding, M16. Saw Matt and Robert Ward come in and stand near the door. One of the boys went for Butler, who came out and bowed to them. Ward said, "I have come to see you about that affair." Butler asked him to step into the recitation room, but he replied, "No, I want to talk here." Other conversation ensued which I could not hear, though I caught the word liar once. I heard the report of a pistol, and as I looked around, Ward was just taking his hand away from Butler's breast, and Butler fell. The scholars then retreated, and I went with them. Was not looking at the parties at the time. During the conversation, did not see Butler strike. Cross-examined. After the occurrence, was in the front yard for about a minute. Do not recollect seeing any gentleman come while I was there. Did not tell anyone that Butler struck Ward first. J. Gilmore, am a gunsmith. On the morning of 2nd of November last, Matt F. Ward came into our store about 9 o'clock. He asked to look at a pistol. He took it, examined it, asked the price, and told me if I would load it, he would take it. Did so. He then hesitated a moment, asked the price of the pair, told him, and he said if I would load the other, he would take the pair. Loaded the other, and he took them. He inquired for small pocket pistols. The pair I sold him were small, self-cocking ones. This pistol is one of the same kind. They are good pistols. Suppose they would shoot through an inch blank, 2 feet from the muzzle. Loaded each of them with powder and ball and put caps on them. They were fully prepared for use. Did not observe whether he put them in his pocket. Do not recollect that he said he wanted pistols that were certain, or anything of the kind. Mrs. Martha A. Harney, reside in Louisville on Chestnut Street between 1st and 2nd. On the morning of the 2nd November last, between 9 and 10 o'clock, met Mr. Matt Ward on 3rd Street, near the post office. He seemed to be under excitement. There was a firmness and determination in his appearance I had never seen before. I think he had one of his hands in his pocket and the other by his side. We turned home and found Professor Butler there lying on the rug in the parlor. The house was full of people. When I entered the room, he raised his hand to me in recognition, knelt by his side and begged him to be composed. He seemed much agitated. I told him to be quiet, as much depended on it, that the physicians thought it was only a flesh wound, and we hoped he would recover. He said he could not. He said, "No, do not be deceived. I cannot live. When I am gone, will you be kind to my poor wife and baby?" He desired to see Mrs. Butler, seemed impressed with the conviction that the wound was mortal, was with him until his death, brought Mrs. Butler. He died the same night between 12 and 1 o'clock. Cross-examined. Am the wife of Mr. Harney, the editor of the Louisville Democrat. Mrs. Elizabeth Butler. When Mrs. Harney took me to my husband, he told me not to be deceived, that he was dying. Told him to be calm, that the physicians thought he would recover, but that everything depended on his being kept quiet. He said, "No, Lizzie, don't deceive yourself. I am dying." He thought until his death that the wound was fatal. The counsel for the defense declined asking Mrs. Butler any question, remarking that they had no desire to inflict suffering upon her by calling her mind to the details of the unhappy occurrence. Dr. D. Thompson. Reside in Louisville and practice my profession there. Shortly after 10 on the morning of 2nd November, was called to Colonel Harney's residence to see Professor Butler. He was deathly pale and faint. He asked me if he was not a dead man. Told him I hoped not, but could not tell until I had examined the wound. We took off his coat and tore open his shirt. The wound was on the left side, about 1.5 inches obliquely above the left nipple. It was much burned with powder around it. Attempted to probe it, but failed to do so, being unable to follow the wound. I then asked him in what position he stood when he received the ball. He replied that they was clenched, said Ward had come to see him. They had had a conversation in which Ward called him a damned liar and struck him. That he struck back and was shot, but did not see who fired the pistol. Dr. Caldwell came in and assisted, but we succeeded in tracing the direction of the ball only a short distance, as probing was very painful. We did not pursue it further, and gave him something to allay the pain. Some 15 or 20 minutes after, a noise proceeded from the wound. Dr. Flint said the ball had passed into the cavity and forced the air out through the blood, causing the noise. Butler then said he was a dead man. About 4 o'clock in the afternoon he seemed better, and we hoped a reaction would take place, but he soon commenced failing again, and continued to do so until he died. He seemed fully convinced all the time after I saw him that he was dying. We deemed it useless to punish him by probing further. Professor Butler was a man who would weigh about 135 or 140 pounds. His right hand was disabled, so that it could not be straightened after his death. There can be no doubt the wound caused his death. Cross-examined. When I arrived at Colonel Harney's, several boys and some ladies were in the room with Professor Butler. Saw Mr. Sturgis, after I had been there a while. Recollect seeing no other man there except him. 2 or 3 boys assisted me in stripping Professor Butler. Think Knight was one of them. Think Dr. Yandel came in while I was probing the wound. Dr. Caldwell came in shortly after. At his suggestion, we attempted to probe the wound while Professor Butler's arm was held up, thinking that his hand must have been raised while he was clenched with Ward, and supposing we could ascertain the direction of the ball more successfully, while his arm was in the same position. While Butler was speaking about the matter, Drs. Yandel and Caldwell were both in the room, and near enough to hear him distinctly. Mr. Wolfe. Is it customary in Louisville for young men to go armed? I do not know. Mr. Wolfe. Are you not armed now, sir? Did you not arm yourself before you left Louisville? I shall decline to answer unless I am directed to so by the court. The court. The witness is not compelled to answer the question unless he sees fit. Dr. L.P. Yandell. Am a practicing physician in Louisville. Saw Professor Butler shortly after he was shot. He seemed to be mortally wounded. Dr. Thompson was attempting to probe the wound, and when Dr. Caldwell came in, he attempted to assist. The probes did not seem to penetrate the chest, and we expressed hope that the wound might not be fatal. Shortly after, however, I heard the blood issue from it in a manner that convinced me the ball had entered the cavity. I asked him the position he was in as he received the wound. He replied that they were clenched, that Ward called him a damned liar or scoundrel, and raised his hand, that he, Butler, then struck Ward. They clenched, and he was immediately shot. Butler did not state in my hearing that Ward had struck him at all. Mr. Milgett went to see Professor Butler after he was shot, and remained until his death, was present at the post-mortem examination, was well acquainted with Professor Butler. His right hand was always disabled. He could not open or close the fingers of it. Patrick Joyce. Professor Butler could not open the fingers of his right hand. First knew from observing once in the French Assembly that when a lady asked him to point out Chivinac or Lamartine, he indicated the place where he sat with his arm, but his fingers were pointed in quite another direction, nearly at a right angle. He misled the lady who followed with her eye, the direction of his fingers instead of his arm. Cross-examined. Butler was a man of very fair strength in his arms. He was in the habit of exercising with his arms in the gymnasium. Think he was stronger than the average of young men who frequented the gymnasium. Once crossed the ocean with him and had an opportunity to notice that he had much more strength than I had. I've seen him show great alacrity in climbing ropes, hand over hand, and other feats of dexterity on shipboard. I've also seen him suspend himself by his hands upon horizontal poles in the gymnasium, and then draw up his body. Mrs. Frank Carter assisted in gloving Professor Butler's hands after he was dead. It was impossible to open his right hand, which was much contracted. Saw no gentleman there but Dr. Thompson when I entered. End of section 10. Section 11 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Matthews F. Ward for the murder of William H. G. Butler, Kentucky, 1854, Part 3. Testimony for the defense. Dr. W. B. Caldwell was called to see Professor Butler soon after he was shot. Dr. Thompson and Dr. Yandell were with him, and some other persons whom I do not recollect. Asked him his position at the time he received the shot. Butler replied he did not know which one shot him, as they were engaged at the time. The probe would not penetrate until the arm was raised, as a man's would naturally be when engaged in conflict. Did not hear Butler say that Ward struck him. A number of witnesses, 11 in all, testified here to the good character and peaceable disposition of the prisoner. Among them were Reverend E.W. Sehon, an Episcopal minister of Louisville, J. Perkins and William Presson, members of Congress from Louisiana and Kentucky, James Guthrie, Secretary of the Treasury, George D. Prentice of the Louisville Journal, Isaac H. Sturgeon, St. Louis, Missouri. Some of them spoke of him as not robust and in poor health. April 20th, Dr. J. B. Flint, called by the state. Am a physician residing in Louisville. Had known Professor Butler some 10 years. One of his hands were crippled by a burn when he was young, so that the fingers were contracted. He could not open his hand wide, nor closer so as to grasp, nor double his fist exactly like other men. Was called to see him on the day he was shot about 10 o'clock. Attended the post-mortem examination. The ball was extracted from the backbone where it was embedded. While Butler lived, Dr. Thompson remained with him during my absence, and I stayed with him while Dr. T was absent. Did not hear Butler converse with anyone I did not know while I was in the room. George D. Prentice, about 5 hours after the difficulty with Butler, saw Matt Ward a portion of the cheek and the eye were unusually red and appeared swollen. Should not have inferred that a severe blow, but some injury had been received. Mr. Wolfe, will you tell the jury whether it is the ordinary custom in Louisville to carry arms? Mr. Carpenter objected. Mr. Helm, we desire to prove the custom with a view to rebut and repel any presumption of malice on the part of the defendant. It is usual to carry arms, especially in large cities. Mr. Carpenter, an illegal custom cannot be shown to justify a wrong. There are many bad customs which it is the object of the law to break up. The custom of shooting persons is too common. If it could be shown that every man in Louisville was in the habit of bearing arms, it could be no mitigation in this case. A custom could not justify a breach of law. The court, the Commonwealth had shown defendant to have procured pistols on that day. The question now at issue was whether the killing was done in self-defense, in the heat of passion, or maliciously. Any facts tending to show the motives of the accused were legitimate. If the defense could show that it was the custom in Louisville to carry arms, it might remove imputation of malice. The carrying arms for defense was not illegal. The question is proper. Mr. Prentice, my impression is that the proportion of those citizens who bear arms habitually is small. Nevertheless, almost every young man, if he is expecting an interview, which is unpleasant and may result in collision, especially with a person of superior strength, arms himself. Have known numerous instances in which it has been done, not to commit violence, but to prevent disgrace. Major T. L. Alexander, am an officer in the U.S. Army. Saw defendant about half an hour after this difficulty. Saw in his left cheek the appearance of a blow. Have often known arms borne on the person in Louisville. Do not know that it is always done, but it is usually the case when a difficulty is anticipated. Have done it myself. It has universally been done for purpose of defense, not assault. John O. Bullock, saw a defendant within an hour after the difficulty with Professor Butler. One of his cheeks was much redder than the other. It was my belief that he had received a blow. Never heard character of defendant questioned. He has uniformly been considered of a remarkably peaceable and quiet disposition, both as boy and man. His health is very feeble, and has been delicate for years. He weighed 111 pounds. J. M. Barlow, reside in Louisville. Am a carpenter. Am a married man. Was born in Kentucky, Harrison County. On 2nd November passed Louisville High School. Met Mr. Ranson's little boy. Noticed that the boys were all out, some without their caps on, and wondered what was the cause. The little lad told me that Matt Ward had killed Mr. Butler. Asked if he was dead yet, and he replied, no. Saw the boys taking Professor Butler to Colonel Harney's. Followed them there, but did not go in. Returned to the schoolhouse, and while I stood there, Dr. Thompson came up, asked if he was going up to attend Professor Butler. He replied that he was, and I went with him. We entered and found him lying on a rug in the middle of the floor in front of the fireplace. The doctor commenced fumbling over him, and I suggested that it would be well to take off his coat. We did so. A young man there, whose name I did not know, assisted in taking off his coat. While we were doing so, I asked him, who done this? He replied, Matt Ward did it. I then asked, what for, sir? He said, I had been correcting one of the boys for disobeying the regulations of the school, and they both came to the schoolhouse. Matt said he had come to seek for an explanation, and in the conversation, he gave me the damned lie. I struck him for it, and in the fuss, he threw his right hand round against my breast and fired. The pistol stuck in my coat, and I afterwards knocked it out. When we had got the coat off, Dr. Thompson cut open his shirts with a pair of scissors. Dr. Jandel and Caldwell came in a moment after, and they attempted to probe the wound. They did not succeed, however, the probe going up towards the armpit. The wound was about 1 3/4 inches from the left nipple. Dr. Thompson remarked that the wound was not dangerous, and I then left. Called again at 1 o'clock, and Dr. Thompson told me he was very poorly, that they had found the ball had entered the cavity of the heart. Saw Butler no more after this. Dr. Thompson was in the room while I was conversing with Butler. He had not then commenced to work on Butler, as his clothes were not taken off. Butler had on a black half-sack coat and a satin vest, a black silk handkerchief on his neck. He wore a dickey. Cross-examined. Never saw Professor Butler until that day. Had known Dr. Thompson by sight for 2 years. Am 36 years of age. Have talked to Mr. Mays in regard to this matter. Told him on that day that it was a most aggravated murder, or something to that effect. Told Mr. Ward himself that I was as much against him, at first, as anyone. Went to see Mr. Robert J. Ward 6 weeks after the occurrence. Have spoken to Mays and Sullivan about the matter. Asked Mr. Ward if it would do any good to have a witness who would prove that Butler struck Ward first. He said that was the evidence they wanted. Told him I was one who could prove it. He asked me if I would meet him at Mr. Wolf's office the next morning. Told him my business was such that it kept me the whole day. He told me I should lose nothing by going. I told him I did not wish to be understood in that way, only that I was compelled to work for my living and could not lose my time. Never told Mays or Sullivan that he told me I should be 10 times repaid, or amply repaid. It was between 9 and 10 o'clock when I passed the schoolhouse that morning. It was 20 minutes of 11 that morning when I got back to the shop. Dr. Thompson had his case of instruments in his hand as we walked from the schoolhouse to Colonel Harney's. He sent out for some brandy and gave Professor Butler some. Have never bet that Matt Ward would be cleared here by this jury. Never offered to bet Mr. Sullivan $25 that this would be the case. First went to see Mr. Ward of my own accord, and because I considered it a duty, have said I expected to go to California after this trial. May have told Mays and Sullivan that I had played cards in jail with Matt Ward and Mrs. Ward for amusement. Direct examination resumed. Never bet a 5-cent piece on the result of this trial. There was an immense excitement in Louisville after the occurrence, and I participated in it. Heard numerous statements that had been testified in the police court that Ward struck Butler first, and it was after this that I went to see Mr. Ward, knowing that Professor Butler had made a contrary statement to me. Deemed it my duty to go and inform him of the fact. That was what prompted me to do it. Within half an hour after I left Professor Butler, I told Mays and Sullivan and at dinner, Mr. and Mrs. Crenshaw, all that Butler had said to me. Mr. Ward never offered me $1. I never asked 1 dime, and I never had any hope, expectation, or desire of any fee or reward for my testimony here, either from Mr. Ward or anyone else under God's heaven. Mr. Carpenter disclaimed any intimation or insinuation of anything derogatory to the character of Mr. Robert J. Ward. He had not the pleasure of his personal acquaintance, but knew him well by reputation for a high-toned and honorable gentleman. The Commonwealth, in pursuing their course of cross-examination, had by no means desired or expected to compromise him in the least. It had merely been done to show that the witness had been in the habit of making numerous unreasonable and untrue statements in regard to the whole matter, and was therefore unworthy of credence. James M. Allen, reside in Yazoo City, Mississippi, was in Louisville in November last. On the day of the accident in the morning, I was sitting in the office of a hydropathic establishment, where I was a patient, when Mr. Sturgeon entered and said, "For God's almighty sake, run for a doctor. Professor Butler has been shot and is killed." He ran out, and just then Matt and William Ward passed the door of the office. Cudgel and myself went towards the schoolhouse. In the yard in front of it there were some 10 or 15 boys. Went in and made some inquiries. One of the lads was Mr. Worthington's boy. The other I had frequently seen, having often exercised in the gymnasium with them. They were pupils there. Asked where Mr. Butler was. Shook hands with young Worthington, and addressed the question to him. He replied that Butler was gone. Asked how this happened. The boys were all collected around me and seemed anxious to communicate. Several of them answered my question, and Worthington, though he did not speak, nodded his head in assent. Mr. Crittenden: What was the answer which you received? Mr. Allen objected to the question, contending that the expressions of the schoolboys could not be evidence unless they were identified as the individual boys who had testified here. As the witness had understood Worthington to assent to the statements made by the other boys at the time, the court ruled the question to be legitimate. Mr. Allen: Several boys spoke at once and replied that Ward came there and cursed Butler, that Butler then struck him and Ward fired. Think one of the boys said, Butler took hold of Ward. The court: I have admitted this evidence only so far as it affected the testimony of Worthington, not as evidence respecting the occurrence. Mr. Helm: Most of the boys, if not all, were present at the time. Some of them remembered these gentlemen coming up. This was part of the res gestae. In the case of Lord Gordon in England, the cries of the mob were admitted. The question of identity is for the jury. The prisoner should not be deprived of this important evidence because the witness could not identify the schoolboys. The court: The evidence is admissible only as impeaching the testimony of the boys. The boys must be proven to be present. The cries of the boys was not part of the res gestae. J.T. Gutchell accompanied Mr. Allen to the schoolhouse after the unfortunate affray. Butler had gone, but there were 15 or 20 boys about there. We inquired how the matter occurred. Addressed the inquiry to the whole crowd of boys who were there. 5 or 6 answered that Ward had come to demand an apology of Butler, that Butler had refused to give an apology, and ordered him out of doors. All said that Butler had struck the first blow, and Ward had then fired. Some of them said Butler had pushed Ward back and nearly thrown him down, and that as he was getting up, he fired the pistol. Before we reached the schoolhouse, I met a boy whom I think to have been young Benedict. He was crying, and we asked the cause of it. He said that Ward had shot Butler, said he was present, and gave the same account of the matter I have stated. Heard the boy's reply to Allen's questions. Was not acquainted with the Wards at the time. Have only met them once or twice since the occurrence. J. Hirschfeld, on the day of the occurrence, saw Matt Ward, had a music box to repair for him, and he sent a servant for it, who took it away before it was done. He told me if I could get it repaired by the next Monday, he would send it again, but that he must have it then, as he was about to leave for Mississippi, or some other point in the South. It was between 9 and 10 o'clock. He was going in the direction from Gilmore's store to his own house. Did not observe anything angry or anxious or agitated in his manner. It was that of a courteous, composed gentleman. Mrs. M.A. Beatty, reside in Louisville, keep a millinery and fancy shop. Was employed in November last in furnishing articles of clothing for Mrs. Matt Ward, preparatory to their departure for the South. Late in the afternoon of the day previous to the affray, Mr. Matt Ward, accompanied by his wife and sister, came into my store and made purchases. There was a cap to be made for Mrs. Ward, which they said I must have completed very soon, as they were about to leave. Lawrence Richardson, on the evening previous to this affray, overtook defendant and his lady on the street, and he spoke of their intention to leave for the plantation in Arkansas. They were out making purchases preparatory to going. Captain Peyton A. Key and the captain of the steamer Belle Key. She descended the Ohio from Louisville on the Tuesday succeeding this affray. The day set for her departure was Monday, and defendant and his wife, who is my daughter, had previously engaged passage on her. They were going to Willoughby, his plantation in Arkansas. Robert Johnson made arrangements to descend the river with the defendant in November last on the Belle Key. Think the boat was to have started on Saturday following this affair, but did not leave until Monday or Tuesday. Mr. Ward was detained by this occurrence from going. The arrangements to go had been made some days before the affray. Saw defendant on the day of the affray. After it was over, noticed effects of an injury on his cheek. It gave the impression of a blow having been received there. Defendant's health has been very feeble for many years. He was laboring under an attack of rheumatism when this affair took place. I've often seen him when he was unable to walk at all, without the aid of crutches. Robert J. Ward, defendant is my son, was apprised of his intention to go to the school on 2nd November, and the purpose for which he went. Mr. Gibson, I object to any statements made by the accused to the witness prior to his going to the schoolhouse being detailed. The charge here was willful, deliberate murder, and the statements he made before the transaction could no more be made competent evidence than statements which he might have made afterwards. Mr. Crittenden, it is both proper and important to show for what purpose this defendant visited the schoolroom of Professor Butler. It was simply this we desired to elicit, and nothing more. Mr. Carpenter was aware of no rule of law or reason by which the conversation of a defendant could be introduced as testimony in his favor. His acts spoke for themselves, and only conversations which took place during the acts themselves, and thus formed a part of the res gesti, could be admitted. If the witness knew of his own knowledge the purpose of the defendant, there could be no objection to him stating it, but not from any statements made by the defendant to him. A prisoner cannot manufacture his evidence for himself. The court. The Commonwealth had proved defendant to have gone to the schoolroom. This circumstance was unexplained, and it was important to elicit his real motive in doing so. The court was aware of no more ready method of learning his purpose than declarations which he made at the time of going. Whether the motives there expressed were true or feigned was a question for the jury to decide. The rule in regard to admitting declarations could not be specifically limited, but must be left in a great degree to the discretion of the court. Declarations in regard to the intention of the accused are admissible, if they are confined to the time occupied in preparing for the act. Mr. Ward, my wife and myself returned from a trip to Cincinnati very unexpectedly. After we reached my residence, went into my wife's room and found her and my son Matt conversing in regard to the whipping William had received at school on the day previous. Matt remarked that he would go to the schoolhouse and ask an explanation and apology from Mr. Butler. I replied that I would go myself. He said that he would go, as he had concluded to the night before, as Butler was a young man and this had been done during my absence, that he apprehended no difficulty, for Mr. Butler was a gentleman, and would do what was right, by making in the presence of the school the apology a gentleman ought to make. Robert did not hear any of this conversation. My wife said that as he, Matt, was feeble and had one difficulty with Mr. Sturgis. He had better take someone with him. Just then Robert came in and he was sent with Matt. Matt exhibited no anger or agitation. I assented to him going. For 16 years my son has suffered from feeble health. For 2 months, after 2 weeks previous, he had been compelled to use crutches. He was very delicate at the time. When I entered the house after he returned, his wife and mother were in great distress, and I heard him say to the former, "Would you have me beaten like a dog?" Observed his eye and cheek was swollen, with apparent marks of a blow. Knew Butler well. He was once a private teacher for 20 months in my family. Was a great favorite there. Defendant was absent traveling in Europe at the time, and never met Butler until they both returned from Europe. Mr. Crittenden said he wished to prove that Mr. Ward had made a special agreement with Mr. Butler, that his children should not be whipped in school. If they did not behave with propriety, they should be sent home, and he would correct them. That this second whipping, under the circumstances, was peculiarly aggravating and would explain the cause of the excitement felt by the family. Mr. Helms said what they would prove was that one of the boys on a previous occasion had been maltreated by Sturgis, the assistant teacher, and that had led to a specific arrangement with Professor Butler, by which the condition of the boys remaining in the school was that they should not be whipped. The whipping of the boy again, and that in such a severe and unreasonable manner, by Professor Butler himself, constituted an aggravation which accounted for and explained the necessity of someone going to demand an explanation. The court. Testimony in regard to this previous whipping is incompetent and cannot be received. Our Court of Appeals has ruled that previous insults cannot be pleaded as justification for a subsequent attack. The court ruled out so much of the testimony of Mr. Ward as did not relate to the declarations of the defendant or the state of his health. Mrs. Robert J. Ward had returned home from Cincinnati on the morning of 2nd November, noticed my son William was not at school, and further that his countenance bore a distressed expression, asked him if he was sick and why he was not at school. His eyes filled with tears, and he said Brother Matt would tell me. Matt then said he intended to go around to the schoolhouse and ask an explanation of Mr. Butler, of his extraordinary and outrageous conduct. He explained that Professor Butler had whipped Willie severely and called him a liar in the presence of the school the day before. Was much surprised and exclaimed, "William Butler whip William Ward and call him a liar?" Matt said Willie, when he entered the schoolroom, had some nuts in his pocket and gave some of them to several of the boys who asked for them. They had just given all away when Professor Butler gave the signal for order and the hours for study commenced. That after a short time Professor Butler, seeing the hulls on the floor, inquired what boys had eaten the nuts. That one of the boys refused to tell when Professor B sent into the other room for his strap and said he would ascertain who had eaten them, and whipped the one who would not inform him. One of the boys said that Willie gave him the chestnuts after the recitation order was given. Willie said that he did not, but the boy persisted that he had. Another little boy spoke up and said that Willie gave him chestnuts, but that it was before the signal for order had been given. That Mr. Butler, before he whipped William, which he did very severely, had said that he was compelled to punish him, not only for giving away chestnuts, but also for lying, and that the boy who ate the chestnuts was not whipped at all. Matt said that he had not learned these facts of the case until late the previous afternoon, that Willie, when he related them to him, rolled up his pants and showed him the marks of the whipping, saying, "Brother, I wish you would go around and see Mr. Butler about it. I don't care so much about the whipping, but I would rather die than he should believe me, or the boys should call me a liar." Just before Matt started, I told him to be calm and remember that excitement made him sick. He replied, "I am perfectly calm. I know Mr. Butler is a just man and will do what is right. I am only going to ask a civil question and expect a civil answer. I suggested that he had better take someone with him. He replied that there was no necessity for it, that he expected no difficulty with Mr. Butler. I then said, "You know Mr. Sturgis is your enemy, and you had better take someone." Just then Robert came in, and I suggested to Matt to take him along. He rather impatiently told Robert to get his hat and come. In a few minutes they returned, when we knew what had transpired. His wife was very excited. He asked me to beg her to be calm and said, "Ask Anna if she would have her husband beaten like a dog. I am very feeble and have no other alternative." Then noticed that his left cheek and eye were bruised. Colonel George Hodge saw Robert Ward, the younger, in Cincinnati, I think on the day previous to this occurrence. Know that while in Cincinnati he was in the habit of carrying a bowie knife. He was visiting my family in Newport, then almost daily. Sometimes he visited it by night. It is very common for strangers in Cincinnati to go armed, and sometimes to be a necessary precaution. The part of the city which he passed to go to Newport is the darkest and most dangerous portion of it. Mrs. L.P. Crenshaw. J.M. Barlow boarded with me in Louisville last fall. On the day of Professor Butler's death, he returned home later than usual to dinner. Had heard that Butler was shot, and I asked him if he knew it, and he replied that he did. That since the occurrence he had seen Butler, who told him that Matt Ward had come to his schoolhouse and used insulting language towards him, and called him a damned liar. That he then struck Ward, and Ward shot him. Understood him to say that he heard the pistol when it was fired. L.P. Crenshaw. On the day of this conflict, Barlow told me and my wife, when he came to his dinner, that he had been to see Butler, that Butler had said to him while they were undressing him, in answer to his questions, that Matt Ward had come to the schoolhouse and used insulting language, and called him a damned liar. That he, Butler, then struck him, and then Ward shot him. It was about 3 hours after the occurrence that Barlow told me this. Lawrence B. White. Am Marshal of Louisville, and when I went to his house, Robert came to the door, asked where Matt was, and he replied quizzically that he was vamoosed. But Matt, hearing my voice and recognizing it, came out, told him he must submit to an arrest. He said certainly, and in a few minutes, as the weather was very inclement, put on his overcoat and went down to the jail with me. Have known him from a boy. He was always born a most irreproachable character. Cross-examined. If he had attempted it, he might have made his escape from town. There was time for it. I know of no attempt on the part of defendant to escape from jail. Never saw the slightest indication of such an intention, though I have watched him closely. Captain James W. Brannan, recalled. Believe it is the general custom in purchasing pistols to have them loaded when they are bought. End of section 11. Section 12 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Matthews F. Ward for the murder of William H. G. Butler, Kentucky, 1854, Part 4. April 21st. John Jute was a scholar of Professor Butler at the time of the difficulty. Pirtle was also a pupil at the time. He told me afterwards that Mr. Butler had struck Mr. Ward. Cross-examined. Do not recollect when it was, he told me. There were several boys present. Do not recollect who. Do not remember of Pirtle saying that Ward struck Butler first. My father is a preacher. It was some months after the occurrence that Pirtle told me this. Was in the schoolhouse where the difficulty occurred. did not see either of the parties strike, but heard the report of the pistol. Robert Adams. Mr. Wolfe, do you know of instances previous to this in which the defendant has purchased pistols and had them loaded? Mr. Allen objected. Mr. Wolfe, the prosecution had endeavored to leave the impression on the jury that defendant having the pistols loaded before he left the place where he purchased them was remarkable, and inferred an intention to commit violence. We now desire to prove that this was a general custom, and that defendant on former occasions had purchased pistols there, and had them loaded, not for any specific purpose, but as he lived in Louisville and the South, to defend himself in case of an unexpected emergency. The court. I have no doubt of the legitimacy of any testimony going to elicit the motives that influence the mind of the accused, but the introduction of this testimony would open an entirely foreign issue, as the motives that influence the mind of a man on one occasion might not at another. The general custom might be proved, but this testimony could not be admitted. Mr. Allen, the gentlemen have been arguing the case, and I hope the court will instruct them to omit their pleas till the proper time. I notice that when the defense wishes to get a statement before the jury, they made it into an argument to the court on some question of law. Mr. Helm, such young men as myself and Mr. Crittenden stand in need of instruction. Mr. Allen, we feel that we are mere swivels arrayed against 24-pounders, and we wish their range properly limited. Mr. Helm, some of your swivels will hardly pay the cost of transportation here. Mr. Carpenter, the presence of these swivels seems to trouble you much. The court. Gentlemen, order. There is enough to do without spending time in these remarks. Mr. Helm, I know it, but when the gentleman talks of cannon and swivels, we have a right to retort. Mr. Marshall, this seems like being shot. Mr. Crittenden, I prove by Mrs. R.J. Ward a single fact is explanatory of the necessity of this defendant arming himself. This fact is that some months prior to the occurrence of the fact we are now investigating, Mr. Sturgis, the assistant teacher of Professor Butler, had become so much embittered against this defendant that he had left with her a threatening message against him and desired her to deliver it. The court would not feel inclined to censure the accused for desiring to have every fact made known, in any way connected with or having any bearing upon a matter in which his liberty, his life, and his honor were so deeply concerned. The court held that though the fact might have an indirect bearing on the case, it was so remote that it would be incompetent testimony. Robert J. Ward, Jr. called. Mr. Gibson, I object to Mr. Ward being called as a witness as he is jointly indicted as a principal with the defendant. Mr. Crittenden, the defense are no strangers to the cases cited by Mr. Gibson, but it was admitted in them all that, if the indictments were separated, persons indicted for the same crime could be witnesses for each other. But this made no difference in principle, the fact that their names were on the same instead of different pieces of paper. But these were higher and older authorities than those the gentleman had cited, and which placed the question beyond doubt. Some crimes require more than one to commit, as a riot. In such cases, there was a community of guilt, and whether the criminals were indicted separately or jointly, they could not be witnesses for each other. But where the crime could be committed by one, this reason for excluding another impleaded for the same crime did not exist. Mr. Crittenden commented severely on the opinion of Lord Ellenborough that the jury would be imposed on by an accomplice, and vindicated the ability of the jury to discriminate between truth and error. Mr. Wintersmith cited Russell on crimes and supported the point that a witness could not be excluded because he stood in the same relation as the criminal. Mr. Gibson, this is the first time that a motion is deliberately made to throw aside all the books, all authorities, all precedents, and trust to the mere personal opinion of the judge. As the gentleman has sneered at English authorities and referred to Kentucky authorities, I will give him a Kentucky authority, one not spoiled by being put in a book. I refer to the case of the two Kellys, tried in Hart County, where the judge refused such a motion. There was also another objection to this admission. R.J. Ward, Jr. was indicted as an accessory, and his testimony might acquit the principal and, of course, acquit himself. The court. The majority of Kentucky decisions is in favor of the admission of the witness. The weight of English authorities is against it, but they had been much modified by practice, without legislative authorities, and were originally founded on technicalities. The object of a trial was to ascertain the guilt or innocence of the prisoner, and all evidence not directly inadmissible ought to be admitted. The practice was different in different states, but Kentucky decisions were in favor of the admission. The credibility of the witness must be left to the jury. He is competent as far as his admission is concerned. Robert J. Ward, Jr. I arrived home from Cincinnati early on the morning of this occurrence. Saw my brother Matt, his wife and mother, at the front door. Matt told me to get my hat and come with him. Said he was going around to ask an apology of Mr. Butler for whipping William very unjustly and severely. William was with us. On the way, Matt told me, he did not wish me to interfere either by word or action. William said to Matt, "You know, brother, that Mr. Butler is a stronger man than you are, and Mr. Sturgis has a big stick there." Matt replied, "I apprehend no difficulty. I believe Mr. Butler to be a just man, and have always found him such." He told me again not to interfere unless both Sturgis and Butler attacked him. Met Lucy Stone on the way, in bloomer costume, and we talked of that, among other matters. When we reached the schoolhouse, William went in for his books, and on being called for, Professor Butler came out of his room with a lead pencil in his hand. We bade him good morning, and he bowed in reply. Matt then said, "I have called around Mr. Butler to have a little conversation with you." He replied, "Walk into my private room." Matt said, "No, the matter about which I wish to speak with you occurred here, and this is the proper place to speak it. Mr. Butler, what are your ideas of justice? Which do you think the worse? The little boy who bakes chestnuts and scatters the hulls on the floor, or my brother, William, who gives them to him?" Butler replied, "I will not be interrogated, sir," at the same time buttoning his coat up to his throat, and putting the pencil in his pocket. Matt said, "I have asked a civil question, and have a right to a civil answer. Which is the worse, the contemptible little puppy who begs chestnuts, and then lies about it, or my brother William who gave them to him?" Butler answered, "There is no such boy here." Matt said, "Then that matter is settled. I have another question to ask. You called my brother a liar, and I must have an apology for it." Butler answered, "I have no apology to make." Matt asked, "Is your mind fully made up about that?" He replied, "It is. I have no apology whatever to make." Matt then said, "Then you must hear my opinion of you. You are a damned scoundrel and a coward." Butler sprang forward, pushed my brother back against the door, and struck him. Am not quite positive as to the number of blows, but I saw him strike twice. He then fired the pistol. I did not see the pistol until he fired. Mr. Sturgis then came out of his room and advanced a few steps. I was excited, and thought he had something in his hand with which he was going to attack brother. I drew my bowie knife, telling him to stand off. He then retreated. When he had left the schoolhouse, William said, "Mr. Carpenter, stop, sir, stop." Mr. Marshall, to witness, keep cool. Don't be offended at the manner of the counsel. We will attend to that. Mr. Carpenter, well, we will. Mr. Marshall, yes, we will. Mr. Carpenter, certainly we will. Mr. Marshall, damned if we don't. Ward, Matt said he had forgotten the pistol and I went back for it. The knife and I wore on that occasion was one I had worn for 6 months constantly. At the time the pistol was fired, my brother was crushed back against the wall, in a corner, as far as he could get and bent down. Butler then had him by the collar or cravat, and did not let go for a second after the pistol was fired. During the conversation was very close to the parties, within half a foot of each. When Butler pushed my brother back, it took them some 4 or 5 feet from me. Cross-examined. Took no part in the transaction either by word or deed until Butler had fallen. Did not go up the aisle and flourish my knife when Sturgis came in. He came 3 or 4 steps, and I stepped towards him and told him to stand back. He then retired into his room. When I returned to get the pistol, spoke with a few of the boys to inquire where it was. Did not speak with any of them before I left the schoolhouse first. Have no recollection of flourishing my knife towards the schoolboys. We all bowed to Butler when we entered. My brother's hands were then by his side. Noticed that he had his hat in his left hand and gesticulated with his right after we entered. When Butler sprang forward, think it was his left hand that he seized Matt with, and the right that he struck him with. Do not feel quite positive in regard to this, as I was considerably excited. Know that he struck him twice, may have struck him 3 times or even 4. My brother put his hat on when he told Butler he must hear his opinion of him, and when Butler seized and struck him, he then first put his hand in his pocket. Did not know that my brother had pistols until I saw him take that from his pocket. I've carried arms since I was 14 years of age, having always associated with men older than myself. I've done so, fearing that I might get into a difficulty sometimes, and need them to defend myself. Mr. Carpenter, you say your brother told Butler he must have an apology? He said so, but he did not put the peculiar emphasis on the word must that you do. Mr. Carpenter, where were your brother's hands as he entered? By his side. Mr. Carpenter, on which side of him were you? Behind him. Mr. Carpenter, was the door shut? I do not remember. Mr. Carpenter, if you were behind him, how is it that you do not know whether the door was closed or not? Because my brother William came in behind me. Another lot of witnesses, Dr. S.D. Groves, Dr. Lewis L. Rogers, Daniel McAllister, Coleman Dario, Major Davis Ernell, Robert P. Rankin, James Lithgold, John Stillwell, James Speed, Mayor of Louisville, Mrs. J. Oldman, Mrs. Gwynn, William Logan, Captain J. W. Brannan, Postmaster of Louisville, Richard Anderson, Colonel Alex P. Churchill, Alexander Walker, editor of the New Orleans Delta, and others testified to the same effect as those before called. As to the prisoner's character, disposition, and state of health. The Commonwealth in rebuttal. James S. Pirtle, recalled. Saw Mr. Gudgel when he testified here yesterday. Do not remember him as being the man who came to the schoolhouse after the occurrence. There were 2 men came, do not recognize him as one of them. Don't think I ever told Jude that Butler struck Ward. Joseph Benedict. Saw Mr. Gudgel here yesterday. I am not the boy he met on the street. Crying after the occurrence. Had seen Gudgel before I saw him here yesterday. George Sullivan. On the day of this difficulty had a conversation with J.M. Barlow. He said to Mays and me and others in the shop it was the most aggravated case he had ever heard of, that if Matt Ward was not punished for this, there was no use in trying a man in Kentucky for murder. He proposed to go down and take out Matt and hang him. Suppose he was jesting. He continued to talk in the same way about the matter. A while after, I noticed he seemed to change, after he said he had been to see Mr. Robert J. Ward. He said he asked Mr. W. if he wanted to find a man who could swear that Butler struck Ward first. That Mr. Ward jumped up and took him by the hand and said it was just what they wanted, but where was the man? That he replied, "I am the man." That he told Mr. W. he was a poor man and could not afford to lose time to attend the trial. That Mr. W. replied he should lose nothing by it, but should be well repaid. That he, Barlow, replied to this, "I don't want you to talk any more in that way." I've heard Barlow say he would bet on the defendant being cleared. Has told me that he had played cards in jail with the defendant. Said that when he had told Mr. Ward what he could testify to, Mr. W. invited him to wait until he called the family down and be introduced to them, but he declined. Cross-examined. Have talked a good deal about what I could prove. With different persons. Think I first told Mr. Carpenter that while we sat together in the Crystal Palace, Barlow said, "I'll just bet they clear him." It is very common when people in our shop wish to affirm a fact or opinion, to say they will bet on it. Was joking when I assented to the proposition to take out defendant and hang him. Regarded it as a jest. Uriah Mays. Barlow gave me an account of his visit to Mr. Ward's house. Justice Sullivan has related it. Dr. David Thompson recalled. Have no recollection of meeting Barlow on the day of the occurrence, either in the street or in Colonel Harney's house. Did not carry my case of instruments in my hand on the way there. They were in my side pocket. Never carried them in my hand. Am sure he did not suggest to me to take off his clothes. There was no conversation with Professor Butler after I entered the room until I asked him what the position of the parties was during the affray. He said they were clinched. No other person interrogated Butler at that time but myself. Do not think Barlow was in the room. Cross-examined. Sent out after some brandy soon after I reached the house. Professor Butler had a dickie and 2 shirts on. He drank some of the brandy. He had on a black cloth coat with a waist to it and pockets at the side. He wore a black silk or satin neck handkerchief. I tore open one of his shirts and started the other with my scissors before I tore it. Mr. Wolfe. You are a member of the Presbyterian Church, I believe, Dr. Thompson? I am. Have been for 10 years. Mr. Wolfe. Are you not a teacher in the Sabbath school? I am, sir. Mr. Wolfe. It is usual for members of the church to carry arms. I do not know. Am not aware of any regulation in the church in regard to it. Mr. Wolfe. What have you done with those pistols you had on your person yesterday? The court. You are at liberty to answer the question or not as you please. Dr. Thompson. I decline answering it unless I am under legal obligation to do so. Edward Knight recalled. If Barlow assisted in undressing Butler, or was there at all, I did not see him. Saw another gentleman there who I think was a Mr. Rubens. It was not Barlow, I am sure. Either the doctor or this Mr. Rubens first suggested to take off Butler's coat. Cross-examined. Do not know precisely where Mr. Rubens lives, but he lives in Louisville. There were over half a dozen persons in the room at the time. Dr. Thompson took off Butler's coat with my assistance. The defense again. James S. Speed and L.P. Crenshaw testified to the good character and reputation of Barlow for truth and veracity. Robert J. Ward recalled. When Barlow called to see me, he said he had been told it was important to the issue of the trial of my son to ascertain if there was a witness who could prove that in this unfortunate affair. Butler had struck first. Told him it was a very material point. He said he was one who could do it, and then went on to detail to me the same circumstances he has related here. Told me he was influenced simply by a sense of justice. Asked Mr. Barlow's name and business, how long he had resided in Louisville, etc. Asked him to meet me at Mr. Wolfe's office the next morning. He seemed reluctant, as his business was pressing, offered to pay him for the day's work, but he refused to receive it, never offered or intimated any inducement to him to testify, never told him he should be doubly repaid. The speeches to the jury. Mr. Carpenter, for the Commonwealth, April 22nd. Gentlemen of the jury, I approach the opening argument in this important case under embarrassing circumstances. I am a stranger in Hardin County, not an eye in the jury box, or in the multitude here assembled beams on me the light of recognition, not a face known to me, not a familiar countenance. Against me are arrayed counsel eminent for their learning, talents, and genius, known and appreciated, not only in this county, but throughout the state and the Union. The position of prosecutor is one I have never occupied before my employment, and one I do not covet, but I shrink not from it, when the cause of justice and the welfare of the community demand it. The true calling of the jurist is to mete out exact justice to all, and it is difficult to discern the justice of the proposition that an attorney may be retained to defend any man, however criminal, but must in no case prosecute one, however guilty. If we look to the practices of the most eminent members of the bar, including such names as Webster, Clay, and Wright, we find they pursued a very different course. I engaged in this cause from a high sense of duty to the public, and a desire to lend the aid of my feeble talents to bring down upon the prisoner, if guilty, the merited punishment of his great crime. And I gladly share whatever odium there may be attached to those assisting in this prosecution. I have taken no steps in this case that were not imperatively demanded by my convictions of duty. Because engaged in it, I do not feel called upon to ask for a conviction unwarranted by the law and the facts. Weak as I am, I appear before you as the advocate of 1,000,000 of the people of this Commonwealth, and ask you to hear me for my cause. Man is ephemeral. Truth is eternal. No matter who speaks it, it is truth still, ever enduring and immortal as its author. Let my remarks have no effect upon you except so far as they accord with the law and the testimony, and if consistent with these you can acquit the prisoner, it will give me unfeigned pleasure. Allusions have been made to the great and almost unparalleled excitement existing in the city of Louisville in regard to this occurrence. It has been said that certain newspapers are responsible for all this unusual agitation. I have as yet heard no one pretend to deny the truth of the facts charged, and if nothing but a simple narration of the facts as they occurred has been given, why so much complaint? On as bright a day as dawned in the year 1853, in the face of 70,000 people, without any just provocation or cause, the prisoner entered the house of the deceased, insulted and killed him. Is it remarkable that excitement followed an act of this character? Do gentlemen expect murder to stalk abroad at noonday? And a free press and a free people to be silent? Is not this a case well calculated to rouse the just indignation of an intelligent community? But however natural and proper these ebullitions of the public feeling then and there, you, gentlemen, are not to give the slightest weight to them, either as tending to show the guilt of the prisoner, or as diverting your minds from the proper issue. I beseech you, gentlemen, as you regard the solemn oath you have taken, the majesty of the law, the well-being of mankind and humanity, to lay aside all prejudice, banish from your minds every extraneous influence, forget everything seen and heard before you entered your box, and with minds as free from the stain of previous opinion as virgin paper, receive impressions from the facts alone. Justice, when she holds the balances, turns her head to avoid seeing who is on either scale. So you, gentlemen, must turn from all but facts, remembering you are in the Holy of Holies, the sanctuary of justice. You have a great and painful duty to perform, and for its performance you are responsible to the law, your country, and your God. End of section 12. Section 13 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Matthews F. Ward for the murder of William H. G. Butler. Kentucky, 1854, Part 5. This is a most extraordinary trial. You and I have never known such a one before. It is extraordinary that such a man, so formed to be loved, admired and cherished, so mild and unassuming in his manners, so averse to combat and bloodshed, so intellectually great, should have found any human being malicious enough to take his life. It is most extraordinary that such a man as the prisoner should have killed his former friend and family benefactor. It is extraordinary in the manner in which the defense has been conducted, the number and character of the counsel, the great multitude of witnesses, some being brought from the halls of Congress and the Cabinet, to testify to the former good character of the prisoner, a fact which, if true, an honest mechanic, or his father's gardener, all unknown to fame as they are, would have proved more satisfactorily, for men are best known by their treatment of inferiors. Doubts have been thrown upon everything, and you would almost believe from the skeptical manner in which the counsel have interrogated witnesses, that the lamented Butler was yet alive, and that this was some tragedy enacted for the benefit of the audience. And from the querulous and peevish tone of complaint indulged in, you would suppose that some of the counsel for the state had committed some great crime, and were on trial instead of the prisoner. All that wealth, talent, and influence could do to acquit the prisoner has been done, and it is a source of gratification that it is so. For if the facts now call, trumpet-tongued, for conviction, and you respond like honest men to that call, you will be sustained by the reflection that every facility has been afforded the prisoner to prove his innocence. In addition to what has been done by the friends of the accused, American law, always benignant and merciful, as expounded on this trial by a most kind-hearted judge, has allowed the most ample and latitudinarian range of testimony in favor of the prisoner, including statements made by him before the commission of the act, tending to rebut the proof of malice, and the evidence of his brother, who is included in the same indictment, for being present, aiding, assisting, and abetting in the murder. Not a single fact favorable to the defense, which transpired from the day before the killing to some hours after, has been hidden. Every expression, every act, has been laid before you, just as he chose they should appear. The law presumes the prisoner innocent, and you are to place yourselves upon this presumption, and recede only when driven from it by the testimony. In the early history of society, every man was his own avenger. Nature had conferred on him strength to punish wrong and defend right. As the duties and relations of men became better understood, it was found necessary for each individual to surrender some natural rights to society and receive in return adequate protection for life, liberty, and property. This is necessary not only to avoid anarchy and bloodshed, but to secure the certainty of punishment for crime, whether the offender be high or low, rich or poor. This is peculiarly the genius of American law. It protects all. It casts its broad aegis over the president in his chair, and the humble laborer upon the streets, none so high as to escape merited punishment, none so low as to be beneath its protection. It protects the innocent by punishing the guilty. Yet we find some who still shed blood for blood. And why? Because justice is sometimes bought, and juries shamefully fail to discharge their high duties. It is by such failures that reproach is cast upon our laws, and if the glorious flag of our happy country shall ever cease to wave in triumph over the fairest land of earth, and be trailed in the dust of anarchy, The cause will be found in the non-execution of the laws. Greece and Rome fell when the people became untrue to themselves and failed to execute justice, and this country can, if she will, profit by their sad but instructive example. It is not the degree, but the swiftness and certainty of retribution that causes evildoers to tremble. The law has taken the prisoner from his high position in society and placed him at this bar for trial, surrounding him with all its safeguards. Let us now inquire whether he is innocent or guilty. If innocent, acquit him. If guilty, let justice be done, though the heavens fall. The prisoner is charged with the murder of W.H.G. Butler in the city of Louisville on the second day of November 1853. That Butler was killed, there can be no doubt, and it is not denied that the killing was done by the prisoner. And the only question for your consideration is, was the killing malicious? If there exists in your mind a reasonable doubt of malicious intent, you cannot find the prisoner guilty of murder as charged in the indictment. Such is the law, but such doubt must appear in the case as shown by the whole testimony. If from the evidence, acts, looks, and appearances of the witnesses the doubt exists, the prisoner must be acquitted on that charge. What is a reasonable doubt? It is a doubt, under all the evidence, of the prisoner's guilt. To illustrate the nature of such a doubt, on taking your seat as jurors, you were sworn upon the Holy Bible to well and truly try the issue before you, and by that oath recognize the existence of the deity as revealed in the Bible. Have you never had a doubt as to the existence of such a being? Has the sky of your mind ever been unclouded, so that you could gaze with the bright eye of belief upon the unveiled throne of divinity? No, you have had doubts, but were they reasonable, founded on the evidence? Had you, in connection with your doubts, communed with the calm, still hour of night, with no companion save silence, the winds and stars, the rosy dawn, the rising of the majestic sun, the waking of a world, earth, sea, and sky all glittering on the gladdened vision of stirring and delighted mankind? Had you observed the decline of day, the lengthened shadows, the setting of the sun, the rise of the silvery moon and the sparkling stars, each ray of light as it proceeded from them to you, illumining the soul? Or had you viewed through the telescope the belts and rings of old planets and newly discovered ones, resolved the nebula into splendid systems of glorious suns with their circles of flame? Had you listened to the small, still voice of the sighing zephyr, beheld the opening flower, the tinted shell, the butterfly's wing, the majestic mountain? Had you stood upon the brink of the mighty Mississippi and watched its liquid wave roll ever on towards old ocean, no mean emblem of eternal power? Or gazed with wonder and awe upon the great falls of Niagara, gliding over the rapids, under the rainbows ever singing, God, God, God? The land and ocean, storm and tempest, all proclaim that the whole earth is full of His glory. If you look within your own minds, you find still clearer manifestations of almighty wisdom and power than elsewhere in the universe. The mind so strong and yet so weak, so intelligent, comprehensive, and grasping, with all its mysterious operations, plunging now into the bowels of earth, now exploring and analyzing its surface, then leaving it and holding converse with the heavens, listening to the music of the spheres, again descending to the abodes of men, tracing effect to cause, following all the meanderings of passion and will, exclaims in the fullness of its admiration, There is a God, for I am fearfully and wonderfully made. It cannot be denied that the evidence is full, ample, and complete, and no reasonable doubt can hover around the mind. With these general principles to govern us in our investigation, let us examine the laws applicable to this case. The authorities will show, 1. The malice necessary to constitute the crime of murder is not confined to the intention to take the life of the deceased, but includes an intent to do any unlawful act which may probably end in depriving the party of life. 2. If an action unlawful in itself be done with the intention of mischief and death ensue, it is murder. 3. When death issues from sudden passion upon reasonable provocation, it is manslaughter. If without such provocation, or if the blood has time to cool, it is murder. 4. When the provocation is sought by the prisoner, it cannot furnish any defense against the charge of murder. 5. If a prisoner uses a weapon that was likely as used to produce death, the law presumes he used it with the intention of killing. These propositions contain the law, gentlemen, as laid down by the most eminent jurists of this country and Great Britain. What are the facts? The witnesses for the prosecution, on motion of the prisoner, were separated, neither hearing the testimony of the other. The facts as to Ward's visit to the home of the deceased and the murder are proved by young men from 11 to 19 years of age, all of whom reside in Louisville and are members of the most respectable families in the city. They were all unimpeached and unimpeachable. Though separated, they have all, without exception, related the same facts, differing only as their relative position to the parties in the schoolroom enabled them to see and hear more or less of what transpired. Mr. Carpenter here exhibited the diagram of the schoolroom, showing the relative position of each witness, as detailed in the examination. The youthful mind is fresh and pure, averse to falsehood and to simulation, and always disposed to speak the truth. The pure waters of truthfulness and sincerity well up, naturally, from the untroubled fountains of their hearts. How unfortunate that men so soon forget these early impressions and pass through life in masquerade. Of all testimony, that of these young men, trained up at the feet of their deceased teacher, who loved and adored truth and hated falsehood, is the most reliable. The facts as related by them, all corroborating each, and each in turn strengthening all, are unanswerable. It is as though an angel had dipped his pencil in the beam of light issuing from the eternal throne, and cast this murder upon the canvas with such startling correctness, that while you gaze, you know the prisoner set for the picture. Efforts were made by the learned counsel to impeach, indirectly, these young men by asking them, "Did you not tell Dr. Caspari and others that Butler struck Ward first?" But when the doctor and others referred to came upon the stand, a contradiction was not even attempted. If the counsel desired to impeach the witnesses, why did they not call respectable citizens from Louisville? This would have been fair, open, manly. These young men proved that about 9:30 a.m. on the 2nd day of November, 1853, a servant of Robert J. Ward, Sr., came to the schoolroom of Professor Butler after Victor Ward, a young brother of the prisoner, and his books. They also proved that William Ward, the brother, who had been moderately chastised the day before in school for telling a falsehood, came in about half-hour later, walked up the aisle, took his accustomed seat, and turned round and walked towards the door. It is further proved that the prisoner and Robert J. Ward, Jr. then entered and inquired for Professor Butler, who was at that time absent from the main building, hearing a class in his recitation room, and that the prisoner on his entrance seemed excited, had his hand in his pocket during the entire conversation which ensued, and kept it there until he drew forth the pistol and fired. It is proved that in answer to the previous inquiry, that Minor Pope went to the recitation room and called Professor Butler, who came out, and with all his usual urbanity said pleasantly, "Good morning, Mr. Ward," and that the prisoner's reply was stiff and scornful, and that he then, in angry manner, commenced gesticulating with his left hand, and said in a loud tone, "I have a matter to settle with you." That Professor Butler then politely invited him to walk into his recitation room, and he would explain everything to his entire satisfaction. That the prisoner refused, saying that he did not come for an explanation, that was the place to settle it. that the prisoner then asked the deceased which was the worst, the contemptible little pup who begged chestnuts and then lied about them, or his brother who gave them to him. That the deceased then remarked he could not answer unless first allowed to explain, and that the prisoner again refused to hear an explanation, and asked why he called his brother a liar, and without waiting for a reply said to the deceased, "You are a damned liar and scoundrel," and followed the offensive words by a blow with his left hand. That Professor Butler then caught hold of the collar of the prisoner with his right hand and attempted to seize Ward's right with his left to prevent his using weapons, and that the prisoner drew the pistol, pressing it so closely against the breast of the deceased that it remained for some time in the orifice caused by its discharge, and was taken from thence and thrown upon the floor by the deceased himself. And Professor Butler then staggered forward towards the recitation room of Mr. Sturgis and Bell, saying, "I am killed, my poor wife and child." It was also proved that during the whole conversation the prisoner stood but a few feet from the door, between it and the deceased, which was open, enabling him to retreat at any time if he desired. But there is another witness who, from the cold grave, gives an account of the horrible transaction. That his statements were made under the full belief that he was a dying man is proved by Mrs. Butler, who, with a heroism worthy of a Spartan wife and mother, testified in regard to this subject, while it wrung blood from her young heart. Professor Butler, standing on the very verge of time, the cold waters of the river of death even then laving his feet, at that solemn hour, when the memory regains all its former losses, and the mind sky becomes clear, illumined by eternal light, declared that the prisoner insulted, cursed, and struck him before he gave him a single blow. It is thus clearly shown that the prisoner went to the schoolroom, violated all the rules of common decency, insulted and killed Professor Butler without the slightest legal provocation. Look at the cause. His brother, William Ward, had been punished for a violation, not only the rules of the school, but of morality and honesty. There was no reason why he should not be punished. On the contrary, it was the duty of his teacher to correct him, and had he failed, he would have been highly culpable. But the first cause of this murder lies far back of the punishment inflicted. It is to be found in the education of the prisoner. Belonging to a wealthy, aristocratic, and fashionable family, he had been taught that he and his brothers were formed of better clay than ordinary men, had gentle blood in their veins, were not answerable to the same laws, social or municipal. Family and wealth are to be highly prized, as conferring many advantages, chiefly the opportunity of relieving want, alleviating distress, comforting the afflicted, assisting merit, promoting paternal regard and brotherly kindness. It is for purposes like these they are desirable objects. When they become petty tyrants to inferiors, engines of gross oppression, they only serve with honest and independent people to show more conspicuously the meanness of their possessor. The prisoner had evidently taken a different view of the matter. His brother had been whipped, and as under the Mosaic law, there could be no remission of sins without the shedding of blood. So it required, in his estimation, the lifeblood of the deceased to wash away a Ward's disgrace. How many crimes are the offspring of those monster parents? Vanity and selfishness. William Ward had the day before told the prisoner of the occurrences at school, and with his breast rankling with hate, mortified vanity and revenge, he prepares himself for the fatal visit by going to the gun store of Dixon and Gilmore, half or 3/4 of a mile out of his direct road, and first buying a single self-cocking pistol, and as he was about leaving purchased another, and requiring them both to be loaded, ready for use, putting them in his pocket and starting on his mission of death. These pistols were purchased between 9 and 10 o'clock. The prisoner arrived at the schoolroom a few minutes after 10. Why did he go from his father's house down for the pistols, instead of going directly to Professor Butler's, which was but a square, unless he expected a difficulty and desired to use the pistols as he did use them. What other reason can be given for his conduct? Nothing explains intentions like acts. They reveal the secret motives of the heart. It is also proved by Mrs. Harding, whose lucid manner of delivery and readiness of perception show her quite competent to judge, that when on his way from the gun store he looked resolute, excited, and decided. The question then recurs, with what intention did the prisoner go to see Professor Butler? For an explanation? Certainly not. For he remarked while there, he did not come for explanations. If the object of his visit was pacific, why arm himself? Why send for the youngest brother and his books? Why send William back? Or why take Robert with him? He bought the pair of pistols so as to have one to intimidate the boys of the school if they should attempt to interpose, as is shown by his conduct, as proved after the shooting, in drawing out his other pistol and pointing it at the boys in a bullying, threatening manner. Perhaps if young Purtle, a lad of 11 years old, had attempted any assistance, he would have shot him. Will it be contended that the prisoner, knowing as he did that Professor Butler was unarmed, averse to quarrel, peaceable and kind in a remarkable degree, was so cowardly as to be afraid to talk for a few moments without his hand resting upon his pistol? I will not do him such gross injustice. He held his pistol firmly in his grasp, using at the time coarse and abusive language, such as he knew would be most likely to produce a blow, on purpose to bring about the difficulty, and thus have a pretext to kill, if Professor Butler refused to submit to the degradation heaped upon him in the presence of his pupils. He used language that he well knew no man in Kentucky could submit to without loss of character, and if he refused to submit, he was to be shot down like a beast. But it seems that the prisoner defends himself upon the ground that the deceased struck him. How arrogant and self-conceited! What was there about his person so immaculate as to exempt him from a blow, in return for his insulting language, to a man who, in all the aspects of human greatness and goodness, was as far above him as the heavens are above the earth? Had the deceased forcibly ejected him from his premises and punished him, it would have been the very best treatment he deserved. It was quite evident from the low, vile language employed that all the baser passions of his nature had been aroused. A man's house is his castle, and the law throws around it the mantle of its protection in a special and unusual degree, and this case illustrates the reason of this especial legal solicitude. The deceased, without ever dreaming of any difficulty, was quietly instructing his school, unarmed and unprepared. What an example for those young men! What a precedent for them! And what a damning and outrageous precedent would be a verdict of acquittal! If such a man, for such a crime, is to go unwhipped of justice, burn your constitution and statute laws, hurl down the judge from his bench, go forth forever from a profaned and corrupt jury box, and let the angel of justice proclaim from her temple, as did the angel of the holy sanctuary of Israel, I will arise and go home, to return no more, and let all traces of civilization vanish like a shadow, and Kentucky becomes what she was when the primeval forest covered her, the dark and bloody ground. If Ward had a right to kill the deceased for the injury received, most assuredly the brothers of the deceased would have the right to kill him, and where would it end? But he refused to make an apology or explanation upon the demand of the prisoner, and did right. Whatever might have been his error, he would have shown himself quite unworthy of his high position and character, had he stooped to comply with such a bullying requisition. He chose wisely to preserve his dignity and honor, and lose his life. For of what value is it without them? It is in proof that the rules of the school prescribed a recess of 5 minutes at the expiration of every hour, and at 10:30, a recess of half an hour. The prisoner went there between the 10 and 10:30 recess, so as to find the boys engaged at their desks and to enable them to do his dark work without any interruption from him. Another fact, which, if taken separately, would be far from conclusive, but standing in the relation it does to the other facts, points unerringly to malice aforethought. If it had been recess, and the large boys all at liberty to stand around their teacher, his designs might have been thwarted, or in the scuffle, some of the young men belonging to families moving in the same social circle with the wards might have been killed, and that would have been, in his estimation, a very different thing from killing a mere school teacher. But it is not necessary to constitute the crime that he should have intended to kill him when he went there, and the length of time intervening between the formation of that determination is altogether immaterial. It is enough that he went there to degrade, that he refused all explanations and demanded apologies, which he well knew would not, could not, and ought not to be given. Here, gentlemen, is a chain of evidence as unbroken as human testimony can make. Not a tie will break, not a link will start. A bulwark sufficient to resist the ingenuity of the whole phalanx of the defense. A mighty rock, against whose base the waves of the ocean of eloquence will dash, only to fall back defeated, as if in the very weakness of weeping tears. How does the defense try to extricate itself from this circle of truthful flame that surrounds it? By introducing many witnesses who are persons of distinction, and it is expected their very presence will act like a charm upon you. By introducing Robert J. Ward, Jr., who was an accomplice in this work of death, and by refusing to introduce young William Ward, who went with him, and therefore knew more of their intentions than anyone else. William Ward was sworn as a witness. Why was he not examined? He went from his father's to the schoolhouse with the prisoner, heard his conversation, knew the object and purpose of his visit better than anyone disinterested, and the true intentions of the prisoner would have been disclosed. But they did not introduce him, because they dare not, as he would doubtless have proved the guilty intention, as much is often revealed by what a party withholds as what is advanced. Half the truth is invariably a falsehood. If William's evidence would have been favorable to the prisoner, would the defense have overlooked it? They have ransacked the Union for Secretary of Treasury, members of Congress, judges, etc., to prove the unimportant point, in this case of good character, and now, when he is permitted to prove his own declarations on the way, he is afraid to do so. The inference is irresistible, when it is remembered that from what had been told William, he looked around on taking his seat to the door as though he expected a difficulty. End of section 13. Section 14 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Matthews F. Ward for the murder of William H. G. Butler. Kentucky, 1854, Part 6. The defense then introduced the man Barlow. It is always unpleasant to attack anyone when it is known he cannot defend himself, but he has voluntarily placed himself in this most unenviable position, and justice to the memory of the deceased, and the history of this case require that he should be held up to this jury and the world as an object of withering scorn. It is not necessary to charge Robert J. Ward with bribing this villain to account for his perjury, although it is highly probable that he expected to be paid for his infamy. There are men in society, or rather in the sewers of society, who reptile-like move and live in its excrescences and slime, who think they have achieved the very highest enjoyment, known to their low, groveling hearts, if they can obtain a single smile from the rich and powerful, and who only breathe freely when they inhale the air of toadyism. This witness belongs to that class. He is content to be a tool and a villain to prejudice his soul, and sell heaven itself, for the sake of saying he has been at the house of Robert J. Ward, a millionaire, been invited into the parlor and kindly treated. He is decidedly of a lower grade of animal than the ordinary villain, who receives so much money for a given amount of false swearing. He testifies that on his return from Gay Street, that the first he heard of the shooting, some small boys gave him the information, that he then passed down Chestnut Street to his carpenter's shop, left some tools and returned, overtaking Dr. Thompson, who had been called to Colonel Harney's, talked with the doctor who had his case of instruments in his left hand, and went with him to see Professor Butler, that he suggested the necessity of taking off portions of the deceased's clothes, and then asked him how the difficulty happened. And Professor Butler told him that the prisoner came to the house and insulted him, and he then struck Ward, and immediately received the shot. On the cross-examination, he was forced to admit that he related the facts to Mays and Sullivan on the day of the killing, and told them that it was the most aggravated murder he had ever heard of, that the Wards could get what they deserved, that they had been getting down for some time, and could not get much lower. And if Matt was not hung, there was no use in talking about justice in Kentucky, that he offered to be one of the party to go to the jail and take him out and hang him without a trial. It was proved that he continued in this mood until about the time he went to Ward's house. All at once he becomes suddenly changed, and thinks the prisoner persecuted, sympathizes with the afflicted parents, and proclaims the joyful tidings that he will prove him innocent. This is unaccountable upon any other supposition than his determination to commit perjury. What? This man so vindictive and malicious towards the family, so suddenly become their well-wisher and friend. Had Ward known of his previous conduct, would he not, as an honorable man, have spurned and driven him from his house? Barlow stated that he had been in the jail and played cards with Mrs. M. F. Ward against the prisoner and Robert J. Ward, Jr. Mr. Prentice testified that the prisoner was always very reserved with gentlemen, seeking almost exclusively the society of ladies, and it was very singular that he should thus cast off all his antipathies to male companionship, and introduce his young and interesting wife to a low-bred, illiterate, and unprincipled sycophant. The prisoner is proved to be a man of intelligence, and doubtless knows the villain's face and cultivated the acquaintance of this man to subserve his own purposes. Then it is proved he offered to bet on the results of this trial, and perhaps did, and that he had said Ward promised to remunerate him amply for coming down to this trial. Did you not observe, gentlemen, his conscience-stricken manner when he was asked if he had not said so? The flushed face, the striking of both hands upon his head. Guilt makes cowards of us all. He was a day laborer in a coarse garb, but the change in his opinion about the prisoner's guilt produced a corresponding change in his costume, and he is now, as you see, a second Count D'Orsay, wearing upon his person the price of his crime. His whole statement from beginning to end is a sheer fabrication. Dr. Thompson says Barlow was not there, that he saw nothing and heard nothing of it, that he neither spoke to this witness or met or walked with him, that he carried no case of instruments in his hand, and contradicts him in every essential particular. And in this he is corroborated by Mrs. Harney, Mr. Harney, and others. The defense undertake to sustain this witness by Mrs. Crenshaw, who says that a few hours after the killing the witness came to her house, where he boarded, and told her that he was present at the shooting and heard the discharge of the pistol, thus directly contradicting the statement he made here. Gentlemen, from the statements, manner, and appearance of this witness, you cannot believe a word he has uttered. Robert J. Ward, Jr. is also a witness for the defense. It is not intended to controvert the decision of the court that he is competent, but the relation he sustains to the prisoner as relative and accomplice show that he is not credible. The proof shows clearly that he was present, aiding and abetting the prisoner. He is now a witness for his brother, whose acquittal would now prevent this witness from even being tried. The inducement to add perjury to murder was very strong, and his virtue was altogether too weak to withstand it. On the one hand was truth and death, on the other perjury and liberty. His manner upon the stand was very much unlike a truthful witness. He was ready, willing, and swift, and with a swaggering aid, boasted that he had carried arms since he was 14 years of age. His whole appearance and manner indicated that he is an abandoned, profligate, and dangerous young man. Not dangerous with those who are prepared, but with boys unarmed and unsuspecting men. Can you believe that the witness told the truth when he said Professor Butler struck his brother twice? All the witnesses for the state contradict him. Butler, on his dying bed, said he was first struck, and as if to strike from him the last plank of corroboration, Barlow makes a very different statement. The prisoner could not have been twice struck, because but a single mark was found upon his person, and that so slight that none of the witnesses recognized it until it was shown them by the prisoner. If Professor Butler had struck twice before he was killed, would not some of the many young men have seen the blows? But many things he stated are most undoubtedly true, as he is sustained by others, as the statements operate against him. But he was not aware of that and showed the criminal intention with which the prisoner visited the school. He says that on the way there, the prisoner told him not to interfere unless both the teachers assailed him. This shows that he expected a fight and went there to provoke it. Then the manner of the conversation between Butler and Ward, as he gives it, shows that he was determined to provoke a quarrel, and in this he is corroborated by the school boys. This truth, developed by a witness telling an untruth, is like a ray of light. It brightens whatever was before obscure. He says Ward told Butler, "You called my brother a liar. For that I must have an apology." He demands an apology, and he knew Butler would not yield to his insolence. It is contrary to the impulses of the human heart. It was asked to make Butler commence a quarrel. Then Ward, on receiving an affirmative answer, remarked to Butler, "Is your mind made up? Then hear what I have to say of you. You are a damned scoundrel and a coward." And the state proves that he struck Butler a blow. Now, if he had chosen to willfully and deliberately murder Butler, could he have taken a more sure way to accomplish it than his witness proves was taken? Every act tends toward that result. He differs from the other witnesses in this. He says Butler came out stiffly, while the others say he was particularly polite. Is he true and every man a liar? I'm sorry to be obliged thus to characterize the witness, but duty requires it. Again, he did not observe which hand Butler struck with. Here it was convenient to forget. And then he says Ward put on his hat, just as he gave the lie to Butler, and in this he is corroborated by the other boys. One thing he does remember, that Ward gesticulated with his right hand. Of course, he would not forget so important an item. At the bedside of Butler were Doctors Thompson, Caldwell, and Yandell. Thompson was there first, and heard portions of Butler's statements before Caldwell and Yandell arrived. He asked the question, was in a better position than the others to hear the answer. Dr. Caldwell remembers Butler said that he did not see who shot him. Dr. Thompson says so. Caldwell understood they were engaged at the time. Thompson's testimony imports the same. If anything was required to confirm Thompson, it is furnished by the defense itself. Yandell says Butler raised his hand to show Ward's motion, but does not know whether he meant by that Ward did or was about to strike, but he supposes Butler did strike first. Now from the proof. If Butler had not been shot, and this was an action of trespass brought by Ward against him for an assault, could he recover damages? But Ward was the trespasser. He was the wrongdoer. The testimony of Thompson in this respect is confirmed by Caldwell and Yandell substantially. As respects the wound, there is no material difference in the testimony. From the suggestion about raising the arm, an attempt has been made to show the arm was in a striking position, but when raised in that way, the probe did not follow the ball. The position of the muscles as shown by the wound shows that Butler was grasping at the right hand of Ward, as is proved at the time. Their next witness is Mr. Allen of Mississippi, introduced to impeach these boys. There were 1,000 men in Louisville who knew these boys and could testify to their character. Yet it is a singular fact that of all the witnesses summoned by the defense from Louisville, not one question is asked them about their veracity, but an unknown man from Mississippi, confirmed by only one man, and he equally unknown, and by him only in some particulars, is called for that purpose. And now must all these young men of Louisville be swept down? Must their reputations be blasted, that this prisoner may live and flourish, and upon such testimony? But they disavow such an attempt. They have manifested the willingness, but are afraid to strike the blow. They do it by innuendo. But suppose you believe all Allen says. He does not identify a single boy as saying anything there, contradicting his testimony here. He says he saw young Worthington there, shook hands with him and asked about the matter, and several boys answered several questions, and to some of their answers Worthington nodded assent, to which the witness does not know. There is no evidence that a single boy who answered Mr. Allen has been on the stand as a witness. Mr. Gudgel is next introduced, and how do these witnesses confirm each other? Two men walking together ought to agree. Allen says the boy said that Ward cursed Butler, and Butler struck him, and Ward shot. Gudgel says that the boy said that Ward came for an apology, and Butler ordered him out of the house. Ward refused to go, and Butler undertook to put him out, and Ward shot him. They disagree with each other more than with the boys. He testifies, too, that some of the boys said Butler knocked Ward down. Allen heard no such thing. Young Robert Ward swore there was no such thing. All the boys testified the same, and there was no motive for the boys to say so, and therefore it was not said. Gudgel is contradicted by this fact and also fails in his attempt to identify Benedict, after boasting of his memory of countenances. Herschel is brought in to testify about the music box and show that Ward was engaged in making arrangements for a trip south. Admit that the witness sought the conversation, still the statements are nonetheless Ward's, and grant their truth, they only confirm his guilt. To say nothing of the discrepancy of the statements, some that he was going to Arkansas and some to Mississippi. The design might be to commit the crime, and then, because he was a Ward, go where he pleased. But it was probably true that he meant to go, that such was his plan, and that he was making preparations and had been for weeks. But do you suppose he would be stupid enough to go and tell that he expected a difficulty with Butler, and therefore was not going to Arkansas? This is simply ridiculous. It was the time of year at which he usually went south, and he would not neglect preparations on account of his anticipated difficulty with Butler. That Butler struck Ward is attempted to be proved by the red spot on Ward's face. It was so slight that George D. Prentice and others did not see it until Ward mentioned it. Was such a wound a sufficient provocation for the killing? Granted there was a spot. Could not a man that could murder produce such a spot on his face? There were no marks of blows elsewhere. If there had been, they would be proved. Now we come to the testimony of the father himself. There is no doubt of its truth. Matt made the statements, but they are the prisoner's statements still, made after his preparations were completed, and he was ready to go. Might they not all be made with the view to introduce them as evidence? If an explanation was all that was wanted, he would not have objected to his father's going. The true reason Was he expected a difficulty, was prepared for it, and sought it? His statement that Butler was a gentleman, and there would be no difficulty, was all a ruse. Why all this preparation? Why tell Bob not to interfere unless Butler and Sturgis both attacked him? Because he expected a fight, and could manage one easily. If an explanation or apology was the object of the visit, the prisoner had no right to go. Robert J. Ward was the father, had placed the boy in school, and Professor Butler was responsible to him alone, and not to the prisoner. Here, then, you have, in the fact of the refusal of the prisoner to allow his father to make the visit, and the reasons he gave why he should go, another proof of the willful, premeditated, and malicious character of this murder. Mrs. R.J. Wood's testimony is to the same effect. Her statements about what her son said of the severity of the whipping is to be taken only as his expressions, not as any proof that such was the fact. The strongest point that can be taken in his behalf is that they believed the statement. All the others say they expected no difficulty, but the watchful eye of a mother penetrated through every disguise, and she expected a difficulty, else why send Robert? She knew her son, his temper, his family pride, and therefore she sends Robert, who she knows is always armed. His mother notices his disguised excitement and says, "Be calm," and he answers, "I am calm," showing his determination to do the deed. Colonel Hodge and others are next introduced to prove the custom of having pistols loaded when purchased. One witness testifies that pistols are loaded when purchased, if the request is made. The prisoner requested his loaded, showing that he meant to use them, and he did most efficiently. The Marshal of Louisville, L.B. White, is next examined. He hears that a man has been shot, goes to arrest Ward, meets the father, tells him his object, and then goes to see how Butler is, thus giving Ward an opportunity to escape, and says that he could certainly have escaped in that time. This may be the efficiency of the Louisville police, but he knew well there was no escape from the people of Louisville. They were on the alert, and that was impossible, and if he could, he would not have attempted it. He would sooner run the risk of this trial, with all its array of counsel and witnesses and money, than be an outcast on the face of the earth, ever fleeing from the pursuit of justice with no hope of rest or refuge. One fact developed by White's testimony is in perfect keeping with the heartlessness of the whole case. Robert came to the door when White went to arrest the prisoner, and quizzically said, "Matt has vamoosed." There is a volume in that expression that shows his estimation of the value of human life. He has just heard the dying exclamation, "My poor wife, my poor child," and he is now jesting about it. He is the young man one would expect to carry a bowie knife, and use it too. But a police officer is brought here to testify that Ward never made an attempt to escape from jail. Now I have heard that when a prisoner wanted to escape, he told the police of it, and secured their cooperation, but I never believed it. If he regards it as a compliment to be thus made the depository of all their intentions, I cannot help it. But I do not think Ward would have told White, even if he did design escaping. No, he would never have told him, whatever he might have told to the turnkey, with whom he and Barlow so innocently played cards. The last proof on the part of the defense is that respecting the former good character of the prisoner, in a crime of an atrocious nature, when men are actuated by different motives from those generally governing mankind, a good character is no palliation, especially when the crime is positively proved. It is only when doubts exist in regard to the facts that character may be brought in to decide the doubt. This is not the first time that a man of good character has killed another. The law is made for such men as well as others, and he that offends in one point is guilty of a violation of the whole law, no matter what position that one has previously occupied. If guilty, he must fall. If the prisoner had killed a dozen men before, It could not be produced as testimony against him on this trial, and if guilty of this one sin alone, his former purity is no justification. Instances have occurred in this state where men charged with murder have proved by a large number of witnesses of every variety of position previous good character, and this was argued in their defense. The case of Dr. Webster, who killed Parkman, is true reason to need more than a brief notice. Webster had sustained a character above reproach, was the associate of the most intellectual and refined men of Boston, had devoted his life to scientific pursuits, had shut himself up in a great temple of science, a constant worshipper at her shrine. Yet he was found guilty, and to the everlasting credit of Massachusetts be it said, the law was magnified. If men like these were thus punished, what shall be done with the prisoner? The time was when murder did not defy public opinion by holding its revels in the blaze of day, but sought the concealment of night. Webster decoyed and murdered Parkman in secret. Others have followed and killed unsuspecting travelers, unseen by human eye. But the prisoner, on account of his position, scorns all such opportunities, walks along a public street, stalks into a public school, and shoots down the teacher, defying public opinion as well as law. And now, every doubt being swept away, the proof positive and abundant, can character avail to even reduce this offense to manslaughter? But it is said, this is an unusual case, and there must have been great provocation. So is every murder an unusual case. It has not yet taken a place among common crimes. The wonder is that any man can commit the deed. If the bare thought intrudes itself into my heart, the natural exclamation is, "Get behind me, Satan." Yet unusual as the crime is, it is not so much as it ought to be. You can hardly take up a newspaper that does not contain an account of some horrible murder, and such notices will become more frequent unless juries do their duty. But grant that this is an unusual case, is it more so than the first murder of which we have any account? What provocation had the meek and quiet shepherd offered Cain? None, save the spotless purity of his character, which by its moral light revealed to his own fierce and restless spirit its guilt. The facts proved by the witnesses as to character show the prisoner far more guilty than ordinary criminals, born to wealth and high position in society, never knowing the wants and inconveniences and temptations attendant upon poverty, with every opportunity to inform his mind, and studied the relations he sustained to the human family, that this his native land could afford, enlarging his views and stirring his mind by foreign travel, into countries where the associations that cluster around their very names teach lessons of peace on earth and goodwill to men. Knowing his victim as his father's friend and favorite, knowing his defenseless condition, how could aught but the demon of murder actuate the prisoner? Had he been poor, lone, and forsaken, enduring for long years the coldness, neglect, taunts, and scorn of the rich and the proud, till his soul, by such constant irritation, became infected with the murderous poison, charity might have found in the cruel tyranny and scorn of the world something in mitigation of the crime. But, stripped of even this poor pretext, he stands before you in all the naked deformity of a wilful murder. But you are asked for mercy. It is only the merciful who can claim the boon, and if it is to be given, it belongs to the executive department of the government, not the judicial. What is mercy but the grave? Can you tear from his heart remorse that, like a worm, makes its hourly meals from its best blood? Can you blot from his memory all traces of his horrible deed? There is no rest for him but in repentance and the grave. He is the murderer of one of the most estimable men, one of those who seem sent by heaven for models in all the relations of life, one whose conscience was clean, whose conduct was all, without fear and without reproach, whose heart, in its kindliness and childlike simplicity, was ever fresh and young, resisting alike the plow of time and the seductive vices of the world. For such a deed there can be no cessation of torment. The prisoner may again travel abroad, but a guilty conscience will be his constant companion. He may regain health and mingle in the conflict of life, but he will find there is no balm for the wounded and guilty heart. He may seek the field of battle and glory, but above the din of arms, the roaring of cannon, the shrieks of the dying and groans of the wounded, conscience shall thunder in his ears. My wife, my poor child. If he join his boon companions in seeking the foaming bowl to drown all memory of the past, he shall find the sparkling wine changed into the blood of his victim. If he leaves the land of his birth and his crime, and finds a home upon the ocean, in every white cap he shall behold a winding sheet, and in ever-breaking surge hear a death groan. Let him revisit fair, beautiful, and lovely Italy, the land of bright skies, soft music, fragrant flowers, and splendid paintings, and the blue vault above will only remind him of the domestic heaven he has destroyed, the music of the sweet voice he has hushed, the flowers of the dear little blossom he has deprived of its parent stem, and the paintings shall be but so many portraits of his guilt. Wherever he may roam, by land or sea, he shall behold 1,000 multiplied images of the corpse of the deceased, reflected from the mirror of his own guilty imagination. Conscience has bound the very corpse to the prisoner with the deathless chain of memory, and when he lies down, it shall be the last watcher hovering around his couch, seeming to hurry his spirit to its account and reward. Gentlemen, you may escape the law, you may acquit, but he cannot escape this unchanging presence. Heaven has wisely ordained that when all other punishment fails for a crime like this, conscience, with the 10,000 scorpion stings, shall lash and lacerate the offender until, in all the dreadful agony of his soul, he shall exclaim, "My punishment is greater than I can bear." Gentlemen, during this long and tedious trial, the prisoner has been attended by his wife, whose tears and sobs have been the most eloquent advocates for the defense. We have all felt and appreciated their potency. I am glad she was here, as it affords another proof of the undying love and unalterable devotion of woman. She hovers like a guardian angel around the prisoner, though he is blighted and fallen. Around the dear ruin each wish of heart will entwine itself verdantly still. She was but a fragile, weak woman, who may have been considered by the prisoner in the day of his pride and prosperity almost an encumbrance or a toy to sport with. But in this hour, peril and danger suddenly become stronger than a strong man. He is not wholly wretched, but heaven, in spite of crime, has left him still this one jewel above price. When the pitiless storm of misfortune bursts in all its fury upon man's devoted head, drenching him with grief and sorrow, she is seen through his tears as the bright bow, promising in the future green fields, sunny slopes, fragrant flowers, and clear skies. When he is blasted by the lightning of crime and becomes an object of scorn and detestation to the world, oh, then she is the only support, the only source from whence he can expect sympathy and love, his comforter, life and hope, and all attraction towards the world having ceased. By the great law of her nature she clings to him through life, and to him alone. This spectacle of woman's devotion is exemplified in the conduct of the prisoner's wife, should nerve you to protect the sex by punishing the guilty. 100,000 mothers in Kentucky stretch forth their hands and implore the protection of a just verdict for their fathers, husbands, and sons. They supplicate you to save them from the sad and melancholy fate of Mrs. Butler and her orphan child. You saw her upon the stand. You remember that pale, sweet, and despairing face. The soft, balmy air of spring again surrounds us. The birds carol in the groves and woo their mates with the sweetest music. The green grass is recarpeting the earth. The flowers are opening their delicate leaves, and all nature has been resurrected to a new and glorious life. But all is dark, dreary, lone, and wintry to her. It is the blast of November, not the warm and genial breath of May that fans her marble brow. Even as she looks into the deep heaven of the fathomless blue eyes of her darling babe, the recollection of those eyes that never had for her but the expression of kindness will rush upon the brain, thus making the dear pledge of their fidelity and love an instrument to wring her heart. These remarks are addressed to you, as tending to show more clearly the prisoner's guilt, not to influence your passions nor excite your prejudices, but to show the responsibility of your position, and the necessity, if you would avoid such scenes hereafter, of discharging your duty now. For if you fail, you not know how soon this fearful chalice may be presented to your own lips, and you compelled to drink the draught. Death, though it may be, there is hope of a tree if it be cut down that it will sprout. But if a man die, shall he live again? The prisoner may be saved if convicted, but what power shall raise the dead? It is a fearful thing to violate the law, and become subject to its penalties. Yet, if by a false sympathy and false ideas of philanthropy you neglect your duty, you violate your oaths, and not only subject yourselves to the penalty of human laws, but you fall into the hands of the living God. Life is short and vanishes away, and we shall soon be laid in the cold and quiet grave. When you approach that time, and your heart most remembers what it most wishes to forget, when the mind becomes clear as it approaches the brightness of the Creator's presence, will it not be sweet to remember that in this case, when so much has been done to thwart your judgments, you yielded not, but discarding prejudice, fear, and favor, marched boldly forward in the line of duty? My duty is now done. Yours is yet to be discharged. End of section 14. Section 15 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Matthews F. Ward for the murder of William H. G. Butler. Kentucky, 1854, Part 7. Mr. Marshall for the defense. Gentlemen of the jury, this is the 5th day since this trial commenced. During that time you have given the most ample evidence, by your patient and profound attention to the evidence and the discussions, that you at least are determined to give the prisoner a fair and impartial trial. You have shown that you at least are not under the influence of prejudice, that you have not believed the numerous partial and discolored statements that have been published and scattered through the country to create a feeling of hostility to the prisoner. You are uncommitted, unbiased, impartial. After the prepared, well-digested, well-arranged burst of eloquence to which you listened this morning from the attorney for the prosecution, consuming 8 hours of the precious time of this world and this court, I thought it best you should have a little time for reflection, whether the effect of the burst was warming or cooling. It was something like an exhortation, but never did anything of the hortatory strain fall on my soul so like an iceberg as did this burst of rhetoric. It would have been enough to have consigned the prisoner to his lot without intruding such a scene upon his feelings. It would have been enough to have left us to our fate, to have consigned us to our early and disgraceful grave, to the strings of conscience, without inflicting on us such a speech. In the latter part, he besought you to commit the prisoner to the grave out of mercy, to deliver us from the stings of conscience by consigning us to the hangman. Allusion has been made to his past journey, and he has been told to commence his travels over again, a wander on the face of the earth with guilt his eternal companion. If he cast himself on the ocean, every whitecap would remind him of the shroud, and every waking surge of the death rattle of his victim. If he visited France or Italy, every opening flower would only remind him of the flower he had left blighted behind him. In all this, he traveled out of the path of an attorney to torment the prisoner. But he failed. There was neither power in the arm, nor point in the arrow. It has fallen harmless, but the attempt was unjustifiable. It was out of taste. Whatever may be the law and the evidence, I felt there was no necessity to go to find a conviction in this case. In listening to the gentleman's speech, I was astonished. I could not imagine what he was discussing. I could not reconcile his statements with the evidence on trial. But soon I remembered. There is another case out of court which has been argued in certain newspapers for the last 6 months, a case supported by fabricated and distorted testimony. I compared his speech with that, and it fitted exactly. What is the charge in the case the gentleman has been advocating? It is that Matt F. Ward, on the 2nd of November last, without provocation, armed himself for that special purpose, went to Butler's schoolroom, asked Butler an insulting question, would not receive an explanation, then called him a damned liar, then struck him, then shot him, all without provocation, without Butler saying a single aggravating word, and resenting neither the curse nor the blow. A tolerably bad case, I confess. Yet this is the case made out in the papers. It is the case they are now discussing. The press is engaged in it with all its power, scattering its distorted and false statements all over the country by every mail. That is the case the gentleman has been arguing. But, thanks to God, it is not the case you are to try. Before we enter into an examination of the law, let us look into the facts. It is not denied that Butler was shot, and that Matt F. Ward shot him. But how? Why? Under what circumstances? That is the question. 12 boys have been introduced as witnesses who were present, and most of whom saw the transaction. In regard to their testimony, there is a good deal of conflict. I do not assail their characters. That is unnecessary. The conflict arises from the peculiar circumstances under which they saw and the attendant confusion. The first witness is Knight. In his direct examination, he testifies to Butler saying this and that. But on cross-examination, he says he only heard 3 words. I'm not disposed. But he heard all that Matt said. What is the first remark of Matt to Butler? I have come to settle a matter with you. Knight sees Butler make a motion from which he infers Butler asked Matt into the next room. Matt says, here is the place. Butler's answer is not heard. Matt then says, since you will not answer that, etc. This shows that Butler had refused to answer. Butler's answer to this last question is not heard. Then Matt says, why did you call my brother a liar? Butler says, I am not disposed. The remainder not heard. This shows that Butler refused an explanation. Worthington is next examined. He is 50 feet off, yet here's what Butler says. Butler asks Ward to go into the next room. Ward, no, here's the place where the thing happened. Ward says something. Butler refuses. Witness turns his back. He is stamping, then the shot. Next, Campbell testifies. When Ward first came in, he was calm and polite. It was not until Butler answered that Ward's blood arose. Witnesses within 4 feet didn't hear what Butler said. Hears Ward say, since you won't answer that, I will ask another. Don't hear Butler's answer to that. Ward then cursed him. Witness then knew it would be a fight, and turns to arm himself to keep off both Bob till Butler could whip Matt. Didn't see Butler strike Matt, but knew he would. Knows he would whip Matt if Bob was kept off. See something in Butler's actions that convinced him there would be a fuss. Minor Pope is next. He hears nothing till Matt says, why did you call my brother a liar? And when the lie passed, Then Butler sprang at Ward and grasped him, and then the shot was fired. Benedict says he saw Butler lay his hand so violently on Matt that he bent backwards, knew that Butler would not lay his hand on Matt for nothing. Quigley didn't see Butler strike, but saw him push him back 8 feet to the door. Now, gentlemen, argue that Butler did not strike Ward, but Dr. Thompson says Butler said, "Ward struck me first. I struck him, and then he shot." Dr. Yandell says Butler said, "Ward raised his hand, and Dr. Yandell thinks in a threatening manner, and I struck him." Dr. Caldwell says Butler said, "We were engaged in conflict at the time. The boys say Butler did not strike him, and yet Butler says he did. This proves that Butler did strike Ward, and that they were in conflict at the time. The boys were so excited they knew nothing about it. This is settled by their own witnesses." Knight says Ward gesticulated with his left hand, his right hand being under his coat. Butler settled back and thinks Matt struck him. Another says Butler was catching at Ward's right hand to prevent him shooting. Butler contradicts this, for he did not know who shot him. I take it that is a total mistake that Butler tried to get the pistol. It is evident by their own showing that these 12 boys knew nothing about the conflict. Matt made a mild demand for an explanation. Butler asked him to go into a private room. If he wanted to assassinate Butler, why did he not go into the private room and do it? The true construction is he wanted the matter explained in presence of the schoolboys, without concealment or disguise. Now, to know what the provocation is, we must look farther. He did not kill Butler for the mere pleasure of killing. There must be some other reason. What was it? How came he to go there? We have been permitted to show by his mother what he said about his motive. On her return from Cincinnati, she finds William at home, asks him the reason. He says, "Ask Matt." Matt says that on the day before, just before the class was called to order, William gave some chestnuts to another boy. The boy ate them and threw the hulls on the floor. Butler asked for his strap, a fashionable instrument, this broad strap, a vast improvement in the art of whipping Negroes. Can whip a Negro nearly to death with them, without breaking the skin, and he is left as smooth as a peeled onion. The whip is brought, and the boy called up, "Who gave you those chestnuts?" "William Ward." "Did you do it, William?" "Yes, but not in recitation time." "Yes, you did," says the other boy. The other boy's word is taken, and William is flogged, not for giving the chestnuts, but as a common liar. Publicly flogged as a common liar by an instrument used in whipping slaves. Now, do you believe that in making this statement, Matt Ward was making testimony for himself? Never. William had told his story, and told him he did not mind the whipping, but he had rather die than be called a common liar. And thus feels every boy in Louisville. Kentucky's spirit is not confined to the Ward family. The poor man's child feels as much as the rich man's. I deny that the sense of honor is confined to the Ward family. It is not peculiarly an aristocratic virtue. The statement that all this happened because a Ward had been whipped is one of the low means used to create a prejudice. Matt further says, as we proved by his mother, "I know Butler to be a gentleman. I will go and have the matter explained, looked into, and examined. Butler has acted hastily. I will go and have this stain wiped off." Was there anything wrong in all this? Wasn't it all right? And what ought Butler to have done? I would not willingly disturb the ashes of the dead. He was an honorable gentleman, and his death a public loss. But what would you have done? I have been to many schools and seen boys whipped severely and unjustly. It is not agreeable to a father, and makes an older brother feel unpleasant, especially when whipped on an infamous charge. It was Matt's duty to go, and he goes and speaks mildly, and not until an explanation is refused is his temper aroused. I know what I would have done had I been in Butler's place. I would have said, "Mr. Ward, I had occasion to whip William. I will explain it. I will summon the boys here, and you shall hear the testimony yourself. And if I have done wrong, I will make the necessary explanation. The school teacher has something of the parent's power, and ought to have a parent's love. William Wood is 15 years old. If a father had detected a son of that age in falsehood, would he have proclaimed it publicly, and whipped his boy in public like a dog? He would do it privately and with the parent's tenderness. Then if Butler had done what a father would not have done, was it not right for Matt to seek an explanation? Certainly, and he sought it where the disgrace occurred. There is nothing wrong so far. Butler says, I will give you no explanation. Why did you call the boy a liar? Butler would not explain that either. He put on the haughty to him. He then said, You are a scoundrel and a coward. You have disgraced my family. You have refused an explanation, and now you are a scoundrel and a coward yourself. What else could he have done? He either must have skulked from the presence of this puissant pedagogue, or returned the insult. He uses these words. Then he is seized, pushed back, driven back to the door, a poor, emaciated, bedridden, neuralgic, rheumatic invalid, as he is, and he must be kicked out into the street or do what he did. We next come to the testimony of R.J. Ward, Jr. He says Matt entered and took off his hat, holding his hat in his right hand at first, and then put it on his head. Knight thinks it was in his left hand, but still he was gesticulating with that hand. Where was the hat? Had he laid it on the floor, nigger fashion? Bob's statement explains it all. He held it in his right a part of the time, and then put it on. Bob and Knight agree in many things and disagree only where Bob's statement is necessary for explanation. The shooting is explained the same way. If his hand was on his pistol, he would have fired before he did. Quickly says he was pushed back as far as he could be. This coincides with Bob's statement. Bob says Matt drew his pistol and fired. Sturgis comes. Bob told him to stand off, as he says. To come on, as the boy says. I do not care which. Sturgis understood it to be off, for never was a man off quicker. And by the way, why is Sturgis not here? Talk about keeping William back. Why did they keep Sturgis back? He got a pretty figure in the police court, with Butler fainting on a settee in his room, when there was not a settee within 50 feet. Mr. Gibson, is that in evidence here? Mr. Marshall, it is in the papers where the case has been prosecuted for the last 6 months, where this man has been prosecuted, and where they are even now trying, Your Honor. The judge, I do not like to have that referred to. It might affect my impartiality. Mr. Harris, I understand the gentleman. He speaks to the jury when he addresses the judge. Mr. Marshall, if you understand yourself when you come to speak, half as well as you do me, you will do well. Mr. Gibson, the papers are not in evidence and the gentleman has no right to quote them. Mr. Marshall, I may want to quote from the Bible, and it is not in evidence. Can I not have the privilege? The judge, this matter is not properly in evidence, and the gentleman better not refer to it. Mr. Marshall, Bob is further confirmed by the testimony. He says Matt asked the chestnut question. So do the boys. Bob says. Butler puts his pencil in his pocket, buttons up his coat, and says he will not be interrogated. Campbell says. Butler appeared to make a motion, and so throughout the whole testimony. Bob is confirmed by different boys. His testimony explained what theirs leaves dark, and is confirmed by Butler's dying words. He tells a plain, straightforward story, hit or miss, for or against himself. When Sturgis came, he says he drew his knife and told him to be off, and off he was. It was presto vito, and he is off. Bob also says he did not go up the aisle. The prosecution were making out that he retreated. He says he did not. His testimony bears all the marks of truth and is confirmed in every particular. After all this, Mr. Carpenter says he is perjured, not content with building a gallows and placing him on it. For what is indeed a crime, but a gallant one which many a brave man sometimes commits. This Carpenter goes farther, and charges him with the dastardly crime of perjury. There is no marks of perjury about him. He made a bold, offhand, gallant statement of the whole offense. The Commonwealth had proved beforehand all he testified. He added but little to our case. But since a charge of perjury has been made against him, it was my duty to make this defense of his character. This trial by juries, and having witnesses face to face, is a glorious institution. The eye, the countenance, every look and gesture, all speak in confirmation or contradiction of the words. Never have I examined a witness who has been sustained by all these more completely than Bob. End of section 15. Section 16 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Matthews F. Ward for the murder of William H. G. Butler. Kentucky, 1854, Part 8. The next witness is Barlow. What a joyful note Carpenter struck when he came to this man's testimony, and I thought I heard a low chuckle run through the crowd, showing the only trace of prejudice that I have seen in the place. He would insinuate perjury. He asked exultingly, "Didn't you say this was an aggravated murder? Didn't you say it was no use trying a rich man's son in Kentucky if Ward was not punished?" The object is to prove that he lied in pretending to give Butler's dying words. He testified that he, in Hardy's house, asked Butler how it happened. That Butler said, "Ward came there, called me a liar. I struck him and he shot me." This is a lie, says Carpenter. But how was he confirmed? Dr. Caldwell says Butler said they were engaged. Another witness says they were clenched. The boys say Butler sprang forward. They all confirm Barlow, but they say he is a liar because he went and offered his testimony to Ward. Hear his explanation. In the police court, it was proved that Ward struck Butler first. This was published all over the country and was prejudicing the whole community against Ward. Barlow knew this was not true and felt it his duty to go and tell the father of the prisoner the circumstance. But the question is, had Butler told him this? 2 hours after the occurrence, he relates the same story to Mrs. Crenshaw. You remember her, with a voice clear as a bell and soft as a lute. He told Mays the same story in the carpenter shop half an hour after he heard it. But he went to the jail and played cards with the prisoner. And what if, on some cold winter evenings when the prisoner was in his lonely cell, listening to the shout of the mob seeking for his blood, like Cuban bloodhounds, this witness did help him while away a weary hour in some pleasant amusement. But Matt Ward associate with such a man? Now I had thought that a carpenter might be a gentleman, but here they begged the question and marked the ingenuity, the infernal ingenuity of the process. R.J. Ward is a rich gentleman, and his son Matt is a traveled, literary, refined man, and that low, mean, hellish hatred which some feel towards this class is played upon to influence the jury, and they are told that the very fact that a mechanic is admitted to their company is proof that he is suborned. This lawyer, Carpenter, came, I believe, from New Hampshire, but Barlow was born in Kentucky, where there are but 2 classes of people, gentlemen and slaves, and every man not a slave is a gentleman. Carpenter has brought with him notions not congenial to our soil. Poor and proud is the motto in Kentucky, and the poorer the prouder. If a man is rich, you can take some liberty with him, but if he is poor, keep clear of him, insult him with no bribe. I thought the gentleman lay in the heart itself, and that wealth was but the guinea stamp. It is by no means strange that Barlow changed his opinion of Matt Ward in forming his acquaintance. Since I have been here, I have learned that the noble, free, substantial farmers of Hardin have visited him in great numbers in his prison, and when, instead of finding the burly ruffian they imagined, they saw this pale, emaciated, neuralgic, rheumatic invalid, and in conversation have found him intelligent and refined, they have gone away in tears. There must be some powerful alchemy in his presence that thus turns all to friends. If becoming his friend is proof of subordination, it is not confined to Barlow, but half of the citizens of Hardin County have participated in the crime. But Barlow was confirmed by Allen and Gudgel. Allen heard the shot, and they immediately went and asked the boys how it happened. The boys tell them just what Barlow says Butler told him. His story is also confirmed by his own acts. Barlow stands unimpeached, surrounded with every badge of truth. There is nothing strange in the cards, nothing strange in becoming a friend of Ward, after forming his acquaintance. I think we have now got at the correct facts in the case. William Ward, 15 years of age on the 1st of last November, is severely flogged by Professor Butler, and flogged too in the public school, and called a liar. He goes home and tells his brother. His books are sent for and removed. Matt Ward, in feeble, delicate health, goes to ask for an explanation, taking William with him, and Bob at his mother's request, not anticipating the difficulty with Butler, but on account of Sturgis. He goes to the schoolhouse and politely and mildly asks an explanation. This is refused, haughtily refused. All satisfaction is denied. Then he charges Butler with the same crime Butler charged his brother with. Then Butler collared him, bent him, bore him back to the door, and then, and not till then, Matt fired. Next, as to the relative strength of these men, it has been shown that Butler's hand was contracted. This did not prevent his striking. Patrick Joyce says he was remarkable for his strength in his arms, that on shipboard he could climb a rope, hand over hand, sailor-like, that he could perform feats in a gymnasium requiring great strength in his arms. Yet they say he could not strike. But Campbell knew he would strike, and could whip Matt. Matt F. Ward, feeble and attenuated, with muscles shrunk and stiffened, a man whom even his wife could whip, and has been testified. Could such a man go there to assassinate Butler? As Kentuckians, interpreting criminal law as Kentuckians do, I ask you, is this cold-blooded, premeditated, deliberate murder? Having got a correct statement of the facts as derived from the evidence, let us apply the law to them, and see if it is not clearly a case of self-defense. I read the following quotations from Blackstone on personal security and the redress of private wrongs. The right of personal security consists in a person's legal and uninterrupted enjoyment of his life, his limbs, his body, and his reputation. Both the life and limbs of a man are of such high value in the estimation of the law of England that it pardons even homicide if committed, say, defendo, or in order to preserve them. For whatever is done by a man to save either life or member is looked upon as done upon the highest necessity and compulsion. Besides, those limbs and members that may be necessary to a man in order to defend himself or annoy his enemy, the rest of his person is also entitled by the same natural rights to security from the corporeal insults of menaces, assaults, beating, and wounding, though such insults amount not to the destruction of life or member. Next to personal security, the law of England regards, asserts, and promises the personal liberty of individuals. This personal liberty consists in the power of locomotion, of changing situation as inclination may direct, without imprisonment or restraint by due course of law. The defense of oneself, or the mutual and reciprocal defense of such as stand in the relations of husband and wife, parent and child, master and servant. In these cases, if the party himself or any of these, his relatives be forcibly attacked in his person or property, it is lawful for him to repel force by force, and the breach of the peace which follows is chargeable only upon him who began the affray. For the law in this case respects the passions of the human mind, and when external violence is offered to a man himself, or to those whom he bears a near connection, makes it lawful for him to do himself that immediate justice to which he is prompted by nature, and which no prudential motives are strong enough to restrain. He considers that the future process is by no means an adequate remedy for injuries accompanied with force, since it is impossible to say to what greater length of rapine or cruelty outrages of this sort might be carried, unless it were permitted a man immediately to oppose one violence with another. Self-defense, therefore, as it is justly called the primary law of nature, so it is not, neither can it be, in fact, taken away by the law of society. In the English law particularly, it is held an excuse for breaches of the peace, nay, even for homicide itself. But care must be taken that the resistance does not exceed the bounds of mere defense and preservation, for then the defender would himself be the aggressor. Such, then, is the law of self-defense. It is the first law of nature, and pervades all its departments, animate and inanimate. Everything seems to have its natural enemy, and is furnished with its peculiar means of defense. The bark of the tree, the rind of the fruit, and the cuticle of the vegetable are all means of defense. And so, in the animate world, every animal has its weapons for protection, even to the serpent, that cursed, blasted creature, sentenced to crawl on its belly and lick the dust. Even to that creature, God left his venom and fang when he pronounced his curse. This right of self-defense carries with it all the means necessary for its exercise. It must be used cautiously, but it gives me the right to beat, maim, or kill my opponent, not only to save my own life, but to save limb or any serious injury, whether it be actual or apparent. That life is not worth possessing that I have not the right to defend. If I had not this right, I would raise my own arm, take my own life, and hurl it back into the face of high heaven, a despised and worthless gift. As to the amount of force I have a right to use, necessity is the only measure. If Matt Ward should undertake to whip me, and I should kill him, I should be guilty of murder, for I could hold him with one hand. But there are other men that might undertake to beat me. Suppose a stout man should attack me. I strike him, and he would lick me 5 times worse. If I had a bludgeon, I might use it, but I have none. Must I stand and be beaten? Will any Kentucky man tell me to stand that? No. If I had no other weapon, I would out with my knife and cut his throat from ear to ear. The right of self-defense is nugatory, unless it carries with it all the means necessary for its exercise. Read your musty law books. This is the criminal law in Kentucky, so acknowledged and so administered. I have defended many criminals in my life, and this is the law wherever I have practiced. Now take this law and apply it to this case. The law, as I have declared it, is the law of the land. Apply this law to the facts as I have adduced them from the evidence, and see if this can be called a crime of murder. And if it is not murder, it is not anything. The difference between murder and manslaughter is very slight, as shown by the books. When a man is driven as far as he can be, and then slays his adversary, it is self-defense. In this instance, one of these men was powerful, very powerful, weighing 135 pounds. I have seen such whip men of twice their weight. The other is a feeble invalid, in no condition to fight, goes expecting to ask a civil question and receive a civil answer, is refused an explanation, resents it in words, is seized, bent, pushed back, and at last, fainting and falling, he rids himself of his adversary, fires his pistol, and most unfortunately, the shot is fatal. Had he shown himself by this act unfit to live, to hold a place among his fellow beings? Or coming down to the next grade of crime, will you, for this act, send him to the penitentiary? Will you tear him from his girl wife? Will you shave those classic locks? Will you sentence him to a confinement to which there is, to a man of high noble impulses, no equal in the category of human punishment, and only paralleled in the other world by the prison home of devils and damned spirits? No, as his friend, knowing his feelings, I ask you, rather than do this, tear away his life. In his name, I ask, give me liberty or give me death. If you call that mercy, give the mercy that Carpenter spoke of, the mercy of the grave. Death in any form is preferable. But Mr. Carpenter told you you had nothing to do with mercy, and that if you had, you could not mitigate the stings of conscience. We can bear all the stings of conscience this deed inflicts, but we do feel deep, lasting, pungent regret. We will do anything to recall the deed. We feel every sympathy for the family of the deceased, but the stings of conscience we feel not, for we are conscious of no crime. We fling ourselves on our country and our God for trial. Not guilty, we say now. Not guilty. We say living. Not guilty. We say dying. The deep and damning effects of one kind of verdict we look upon with horror. Evidence has been introduced to prove the good character of the prisoner. Senators, members of Congress and of the Cabinet, mechanics of every class, officers and preachers have all testified to the meekness and kindness of his disposition. He traveled abroad, poor fellow, for his health, and here is a book, Letters from 3 Continents, that shows how he spent his time, and what were his reflections on the various spots he visited. It is not in evidence, and I cannot read from it, but I thank him for this contribution to our literature. In imagination I have followed him in his travels, and with him passed down the Rhine, crossed the Alps, gone down the Danube, passed the Golden Horn, stood with him at Stamboul, gone up the Nile, crossed the desert, and stood with him on Sinai, where God gave the law to Moses. Could I read you his reflections there, you would see that he was of too high and pure feeling to harbor malice to a fellow being. It is a pity that he should die so young. His country has looked on him hopefully, but that he should die after the fashion sought by the prosecution is awful. I ask you not to pardon. I ask you not to relax the rigor of the law, but I do ask you to administer justice tempered with mercy. Look at the evidence and answer me if that young man should die and die a felon. It cannot be. I believe in omens, knowing the efforts made to prejudice the public mind, and finding a jury could so readily be paneled. I felt there must be an acquittal. Such a verdict will be looked for, and such a verdict will be vindicated by the whole country when the testimony is published. But I have talked till I have wearied you and exhausted myself. There are those to follow me, the latchet of whose shoes I am not worthy to unloose, and they will supply all my deficiencies. April 24th. Mr. Harris, for the prosecution, addressed the jury between 2 and 3 hours. Mr. Helm, for the defense. Gentlemen of the jury, I have often addressed you in the jury box and from the rostrum, on the stump and in the muster field. You are all aware that in the discussion of any subject in which I feel a deep interest, my manner is usually excited and earnest. But on this occasion I speak under great disadvantage, having been confined to my bed by illness almost constantly for the last 2 months, and only hoping that I may be sustained and that you may bear with me until I can discharge the solemn duty I owe to my client. I feel, perhaps, more deeply interested in this case than I ever have felt in any other in which I have been engaged. I feel thus from the nature of the ties that bind me to the family of this defendant. Many years ago, when I first entered the political field, I met his father in the councils of the state, and again have I associated with other members of the family there. And as in the beginning of my humble political career, these men took me by the hand and gave me their aid and support. I have ever felt grateful to them, and now that an event has unfortunately occurred by which I hope to be enabled to do something, so far as my poor ability goes, to cancel the debt, you cannot wonder that my deepest sympathies are enlisted. The gentleman who preceded me has alluded to outside influences, to the fact that this prisoner was driven from his own home to seek justice here. It is true that from the moment the event occurred for which he is on trial, distorted and prejudiced accounts of it were given to the public, and accompanied by articles of the most inflammatory character, were spread upon the wings of the wind by the newspaper press. Therefore, this excited feeling was caused, and therefore the prisoner asked only what the law gives, that he might be tried in an unbiased and unprejudiced community. There were other counties in that circuit much nearer Louisville than this, and no one expected this would be selected. But the judge, perhaps willing to rid himself of the perplexity of such an exciting trial, on his own motion, removed the venue here, to the great surprise alike of the prisoner and all his counsel. But now that his cause is brought before you, he only asks at your hands a fair and impartial trial. Another circumstance alluded to was the position of Mr. Ward. He has been held up to you as the possessor of great wealth, and repeatedly called a millionaire, to invoke an improper and unmanly feeling against him. Now, though there is nothing whatever in evidence on this point, I feel it my duty to correct the impression that has been left on your minds. Mr. Ward is the possessor of no such princely fortune as you have been led to believe, and the property of the family consists of one house and lot in Louisville, a partnership in a commission store in New Orleans, and, by the mother of the accused, that plantation in Arkansas owned by him, with perhaps a few slaves. The counsel for defense have been alluded to. I did not think, after importing a man from the vicinity of Cincinnati, in addition to the other counsel retained, to assist the officer of the state, and to make an 8-hour speech to this jury, we should hear any remarks on that point from the prosecution. The truth is, the accused expected, and it was currently reported, that some of the most distinguished lawyers in the land had been engaged to conduct the prosecution. It was said at different times that Rufus Choate of Massachusetts, Thomas Corwin of Ohio, John Bell of Tennessee, and other counsel of equal ability and power had been retained. It was therefore determined, and whether properly or not, you can judge that men of talent and reputation should be employed in the defense, and that Greek should be met by Greek. End of section 16. Section 17 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Matthews F. Ward for the murder of William H. G. Butler. Kentucky, 1854, Part 9. I have spoken of the excitement that existed and still exists in regard to this case. I do not wonder at it. I do not condemn it. When I read the first accounts of the transaction that appeared in the newspapers, very different accounts, gentlemen, from the facts that have been elicited before you, I was excited and exasperated, and I cannot blame the masses that their feelings were aroused, for it only shows that their hearts are bright, and naturally revolt at scenes of outrage and of wrong. But when a man is brought to the jury box for trial, those who would endeavor to excite a feeling against him, either because he is rich or because he is poor, ought to hang their heads in shame. Who of you, gentlemen, is not striving to obtain a little of this world's goods? And what can you think of those who, when a man is charged with crime because, by honorable means, he has succeeded in amassing property enough to support him in ease, would say, never mind the justice of the case, never mind whether he be guilty or not. He is rich, and let us hang him. As the first gentleman who addressed you in this case remarked, so long as we are true to ourselves, our country will be safe, and the tree of liberty will continue fresh and green. But those who would excite such prejudices and build up such distinctions as these are recreant in justice and to patriotism. Here, thank God, all men are equal, and in the exercise of their civil and constitutional rights, no one is above another. Complaints have been made that this defendant has been living in luxury and splendor in jail here, while others have suffered from having their absolute wants neglected. That others have suffered, there is no doubt. But after the accused was removed to this place, I visited him in jail and found him suffering from a severe attack of neuralgia and inflammatory rheumatism, the same disease that had recently confined me to my bed, and notwithstanding all precautions, had racked my limbs with a thrill of pain at every blast that swept over the hills. I went, hoping at least to keep this man alive until he could throw back the foul charges that had been heaped upon him, show their falsity, and vindicate his conduct, as he humbly hopes he can, in the eyes of this jury and the people of this country. I visited him, and I had a petition and a stove put up in his cell, that his disease might not be aggravated by the inclemency of the weather, and for these precautions his own money paid, so that no wrong has been done to the state. Is it a part of your wish that men should be punished to the death before they are tried? Even if this accused was provided with the simple necessities of life, if that mother wished to go and lay her tender hand on his aching head, if that wife would seek his lonely cell, and soothe and cheer him by the light of her presence and her love, was it wrong? Who, with a heart not glutted with blood, could object to it? I know that the prisoner has much to contend with outside of this prosecution. But, gentlemen, yours is a proud position. You are placed by the law, a firm shield before him, to protect him from all unjust and improper attacks, with no aim but to learn the truth and to do justice. I feel confident that you will stand like a rock in the midst of the ocean, unmoved by the fury of the wild waves that dash madly against it, only to be broken in pieces. We only ask that you will perform your duty, and that justice may be done, though the heavens fall. But the gentleman tells you you have no right to retain a single particle of mercy. This is the first time in my life I have heard such a sentiment gravely announced by a man acquainted with the books. To err is human, to forgive divine. He has alluded to the first murderer, but did not God in mercy hear even his prayer, and place a mark upon his forehead that none might slay him? And when a woman was arraigned on a high charge before the Savior of the world, when none was so guiltless that he might cast the first stone at her, then there was no mercy from on high, and he sent her away with the kind injunction to go and sin no more. In the good book, we read that we are to do justice and mercy, and shall we come to this jury box with our hearts steeled against the prisoner at the bar, as if vengeance were our purpose, and join our voices in the wild murmur, "Let him die! Let him die!" The most rash acts have been performed in the midst of such excitements. We read in ancient history of the banishment of Aristides by his own people from their borders on a charge of defalcation. But when the public mind grew calm and reason resumed its sway, they examined more carefully the evidence on which they so hastily acted. They recalled that banished man and made him their treasurer and their ruler. Even the father of your country, who bared his noble bosom to the sordid defense of your liberties, did not escape the shafts of calumny. And you remember that the Redeemer of the world was spit upon, and rebuked and buffeted, and put to death, in obedience to the wild cry, "Crucify him! Crucify him, whether he be guilty or not. But you, gentlemen, I firmly believe, will not allow yourselves to be influenced improperly. Come then, give me your ears to hear and your judgment to understand, and let us reason for a while together. I have no desire to appeal to your sympathies, but I have an abiding conviction that when you hear the law expounded and the facts of this case applied, you will have no alternative but to acquit the prisoner. But I will not follow the example of others and say that if you do not find as I believe, and as I direct, you must therefore be guilty of the vile crime of perjury. In the feeble state of my health, I shall not endeavor to do anything more than discuss the case in plain, familiar language, which you can all understand, with no attempt at rhetorical display. And I do it with but the single purpose of rescuing my client from the fate which impends over him, if it be done consistently with justice and honor. I am ready to meet the gentlemen in regard to what they have said of mercy. The law makes it your duty to hear a case fairly, and where the evidence is such as to justify the act of which a prisoner is arraigned, or to satisfy you of his innocence beyond a reasonable doubt, to return a verdict of acquittal. It is an old maxim of law that it were better for 100 guilty men to escape than for one innocent man to be punished. And I lay it down as another proposition not to be controverted, that in criminal cases, where your mind is in a state of oscillation, and you are compelled to weigh carefully and consider nicely before you come to a satisfactory conclusion, that very fact implies doubt on your part, and you are bound to acquit. The gentleman has read to you that where a man is killed, and there was no malice expressed, the law considers it implied. But if their own testimony has been such as to deny that implication, it must at least raise a doubt in your minds, and all doubts inure to the benefit of the prisoner. I contend the prosecution have brought proof to deny that presumption of malice. They have shown that the parties met politely, that the manner of the prisoner was mild, bland, and gentlemanly, and that in conversation hot words were given. A scuffle ensued, and blows were struck, even according to their witnesses, the first being struck by the deceased. Does not this effectually disprove the implication of malice? Malice is a necessary ingredient of murder, and if you doubt that it existed, you must fall back on manslaughter. If you then doubt whether the act for which the prisoner is on trial was manslaughter or justifiable homicide, you must acquit him, for to give him the benefit of every reasonable doubt is emphatically a part of the duty you are sworn to perform. It is my rule, before examining the testimony of a case, first to read the law applying to it, that I may afterwards present the facts and show the bearing of the law upon them. And on this occasion, the first point for us to ascertain is what constitutes murder. In Russell on Crimes, Volume 1, page 482, it is defined as the killing of any man under the king's peace with malice aforethought, either expressed or implied by law. Malice, you will observe, is a necessary and very important ingredient of the crime. Let us therefore look a little further, that we may fully understand of what it consists. It is very clearly defined in McNally's evidence, pages 378-379, from which I will read you an extract. Russell, 482, also speaks of it as follows. It should, however, be observed that when the law makes use of the term malice aforethought as descriptive of the crime of murder, it is not to be understood merely in the sense of a principle of malevolence to particulars, but as meaning that the fact has been attended with such circumstances as are the ordinary symptoms of a wicked, depraved, and malignant spirit, a heart regardless of social duty, and deliberately bent on mischief. The heart, you will observe, is here looked upon as the great motive power that prompts men to commit a crime and do a wrong. This is an important fact for you to bear in mind in this case. for I think we have clearly proved by the testimony as to his character and disposition from infancy, his proverbially gentle and unoffending nature, and numerous circumstances surrounding the case, that this prisoner could not have been prompted by a heart bent on mischief, and regardless of social duty, and a wicked, depraved, and malignant spirit. If you are convinced that he was not prompted thus, it is your duty to acquit him of the charge of murder. The difference between malice express and implied, and the circumstances in which it may be implied, are pointed out in Russell, page 482. It may be either expressed or implied from certain reasons, but this implication is merely an inference, only a presumption, and if I am able to meet it with facts that combat and destroy that presumption, of course it can have no effect. It must be remembered that we have no written law in Kentucky relating to these points, and that the authorities from which I have been reading are English authorities. Many of these old books, being compiled from various sources, collecting here one maxim of law and there another, contain many inconsistencies and contradictions, and moreover, the tenor is much more stringent than decisions which usually are and always have been made in the United States. As an illustration of this, when in this case we made a motion for a separate trial, His Honor remarked that according to the rules of British law, it was doubtful whether it could be granted, but the custom to grant a severance when desired has prevailed so long in Kentucky that it is the rule and the law is propounded here, and among the counsel of high character and ability who were present, not one ventured to deny or object to the proposition. And if the gentleman designed in this prosecution to rely on the rigid and stringent rules of British law, we can readily show you how much that law has been liberalized and ameliorated here. They read from the books that a man, when attacked, must retreat to the wall, and that his life must be in imminent danger before the law would justify him in killing his adversary. But I can point out to you American authorities and decisions showing that he is justified in taking the life of his opponent, not only where his own life is in danger, but where he is in danger of great bodily harm, or has reasonable grounds to apprehend that he is in such danger. This is an important fact. It is right and proper that we should come home to our own manner of modifying and administering the laws, and so His Honor decided. But, gentlemen, I think we now fully understand what is meant by malice, and let us proceed to the testimony of the case. Let us first endeavor to ascertain the motive. How do we find this defendant? How had his mind and heart been engaged when he visited the schoolroom of Professor Butler? He has been employed with his young wife in making preparation to depart in a few days for his plantation in Arkansas. He had been making purchases with that view, and their passages by steamboat were already engaged. Now, if the heart and mind seem engrossed by proper and natural subjects, it is reasonable to presume that they were engaged on nothing foreign and wrong. Two witnesses who saw him, the one on the evening previous and the other on the very morning of this transaction, tell you that he was engaged in ordinary business, and that they noticed in his appearance nothing different from his usual bland, quiet, and courteous manner. This certainly would seem to indicate a mind free from malice, and I appeal to your sense of reason whether it would naturally have been the case if he were cherishing the intention to do an act which must result in the death of a man who had resided in his father's family for 2 years, a man with whom he had never had a single word of difficulty, but whom he esteemed as a gentleman and loved as a social friend. Up to this time, there can be no presumption of malice. On the contrary, everything indicates quite another state of mind. But, while his father and mother were both away, Willie returned from school and said to him, "See how I have been whipped, but I don't so much mind the sting of the lash as being called a liar in the presence of the whole school. I would rather have died than that." Then what did the prisoner do? In all the examples the gentlemen have read here, From first to last, the stimulating cause of the homicide was brought home to the man himself. But this defendant had no grievance of his own to redress. He had not been insulted. He had not been struck. What said the little boy to him? "Brother, I wish you would go around to the schoolhouse and have this explained." And just at this point, let us stop to inquire who that brother was. The gentleman who opened the case for the prosecution has objected to our course in bringing, among others, men who hold high rank in public life, to show his disposition in previous life, and asked triumphantly why we did not produce Tom, Dick, and Harry from the city of Louisville to prove his character. But I ask you, gentlemen, if we had not established it beyond a shadow of a doubt, and that too by witnesses of all ages, circumstances, and positions in life. We have traced him from the time when he prattled, an infant in his mother's arms, through the trying days of boyhood and youth, in school, in college, amid the temptations that surround young manhood, in the social circle, and in travels on foreign shores. And under all these circumstances, we find him ever the warm, faithful, and affectionate brother and son, friend and schoolmate, and in after years, still the same kind, frank, and genial gentleman, free from the vices of youth and of manhood. Wherever he has gone, he has left behind the same impress, by the mildness and gentleness of his demeanor, the kindness and warmth of his heart. This is the man whose little brother, in the absence of his father, besought him to go and ask an explanation, and of whom you are to judge whether he was actuated by bad and malicious motives when he complied with the request. But they contend that he bought the pistol for the very purpose of shooting Professor Butler. I reply that unless the manner in which he used it afterwards was unlawful and wrong, and sufficient to prove conviction, the fact of the purchase can have no bearing upon the case. Every doubt must be in his favor. The fact of him procuring arms was not remarkable, but we have shown that he was about to leave in a few days on a long journey to his plantation in the South. Well, he bought the pistol, and what next? 3 doors above, we find him making arrangements in an interview not sought by himself, for the repair of a little musical box, to while away some of her winter hours, and afford pleasure to his young wife in her new southern home. The circumstance may seem a trivial one, but I think, as it shows how the heart and mind of the prisoner were occupied, it will give us some indication whether they were under the influence of malice and malignity or not. We have seen what took the prisoner to the schoolhouse. You have heard his declarations both on the way and before he left home, and you are able to determine his motives as far as we may judge of human motives from human actions. But, say the gentleman, he had his pistol in his pocket, and therefore he must have gone with the heart bent on mischief. Did you notice, gentlemen, the confusion of one of their own witnesses on the stand, Dr. Thompson, when asked if he had any weapons on his person? You know the only natural inference to be drawn from his manner, and his refusal to answer the question, unless compelled to do so as well as I. And even my friend who preceded me, and was so horror-struck at the idea of a weapon in the possession of this prisoner, according to the best of my recollection, was in such condition during the whole of the last political campaign, that if a little boy had chanced to approach too near his person with a lighted stick, he would have been sure to go off at once. But, asked the gentleman, why have you not proved that it was the previous habit of the accused to arm himself when about to travel? They must be afflicted with very poor memories, or they would recollect that we did attempt to prove that very fact, but were prevented by their own objection. That, said they, is not evidence, and it was ruled out by the court. Then they triumphantly turn around and ask, why didn't you show the fact? They will read you authorities to show that, because a pistol is a deadly weapon, the law will presume malice in this case. Now, I will repel that assertion by this fact. In the store where the prisoner procured it, There was a great variety of instruments of all kinds, but he chose the least weapon in the whole establishment, one that, in 9 cases out of 10, would not produce death. The law that the gentleman will read you refers to the old English pistol, not to mere pop guns such as this. The weapon has been produced here, and you can judge for yourselves of its deadliness. The circumstances under which it was used, the contiguity of the parties at the time, remember, were brought on by the deceased himself and not by the prisoner at the bar. He could not avoid it. Now, if he intended to produce death, why did he not procure a weapon that was sure to do so? If it were vengeance and death only that he sought, he knew of the event the night previous, and why did he not go, under cover of darkness at the still hour, call out Professor Butler and take his life, when he might have had an opportunity to make good his escape? But, admitting, for the sake of argument, the proposition of the state that had procured the pistol to be used on that occasion, even then, I combat the presumption of malice. I ask you again, is it probable that a man with such a disposition, possessing so many of the elements of a man of honor and a gentleman, would go with a deliberate intention to shed the blood of a man he respected and loved? He had not been insulted. He merely wished to set his little brother right. You will remember that before he left the house, his mother insisted on Robert going with him, reminding him, as a reason, of the enmity of Sturgis. He was aware of that enmity before, and it may be that he had thought of it and reasoned with himself thus: I am going to perform a sacred social duty which I owed my brother. He has been whipped and denounced as a liar, and in the presence of the school, in the presence of those very witnesses who saw his disgrace, I am going to have the matter investigated and explained, and to learn whether he was really wronged. But I am weak, feeble, utterly unable to defend myself in case of difficulty. I know there is a man there who is my enemy. The sympathies of his pupils must be with him also, and as, per possibility, in the performance of this duty, some difficulty may ensue with him. I will take this little thing along to frighten the boys and keep off Sturgis. Now, I appeal to your candor, gentlemen, if it is not more reasonable, more consistent with the character of the prisoner, than whom no man, living or dead, ever proved a better, more consistent with the circumstances and the occasion, than the inference that he procured the weapon with malicious intent to take the life of the deceased. If then you believe that he obtained the weapon but for the purpose of self-defense, and only used it when in danger of great bodily harm, according to both reason and law, his act was justifiable homicide. As I have said, they will read from authorities to convince you that the use of a deadly weapon leaves a necessary inference of malice. I contend that it does not. Russell, page 482, says, presumption of malicious intent may arise from the nature of the weapon used in the preparation of the deed. This is the phraseology of the American law. That of the British law is must. You will perceive in this another exemplification of the fact that the old English law, as administered here, is materially liberalized and modified, and even here in our own state, I contend that this necessary presumption of malice, in cases of shooting, is totally disproved. In our revived statutes, page 264, the law reads as follows: if any person shall, in a sudden affray, in sudden heat and passion, without previous malice, and not in self-defense, shoot and wound another person with a gun or other instrument loaded, etc., whereof the party doth not die, then proceeds to fix the punishment by fine and imprisonment in the county jail. Now, by the law of Kentucky, I contend that the question is settled that a shooting may take place in the absence of malice expressed or implied. But Russell, page 520, note says, no provocation, however grievous, will excuse the crime of murder, when from the weapon or the manner of the assault an intent to kill or to do some great bodily harm was manifest, and the prosecution argued that an intent to kill may be inferred here. And here I bring you back to the question whether it was the intention of this prisoner to take the life of the deceased. If you are satisfied that he bought that pistol intending to use it offensively and take away life, you are to return a verdict accordingly. But if you believe from the facts of the case that he bought it but for purposes of self-defense and only used it in the last extremity when he was absolutely forced to do so, it would be your imperative duty to acquit him. Suppose you, sir, were told that the character of your daughter has been defamed, and you determined to go and seek an explanation and retraction from the person making such statements, in the presence only of those who had heard him utter them. You might know his character and disposition from previous acquaintance, and they might be such as would lead you to believe that you had been misinformed in regard to his language, and that he would readily be able to give a satisfactory explanation. Yet in view of the remote possibility of collision and danger, the man you sought being far superior to you physically, if you armed yourself before the interview, would you not do it purely for the purpose of self-defense, and with a heart harboring no malice? That such were the motives which actuated this prisoner, there can be no reasonable doubt. The explanation he sought was proper, to relieve the feelings of his little brother. The time was proper. It was right that the explanation should be made then, in the presence of the whole school, and the place was proper. The schoolroom is not, as the gentleman would have you believe, a man's own house and therefore his castle, but it is a public place where he performs his ordinary duties and transacts his legitimate business. And I think you are fully convinced that the prisoner sought the schoolhouse only for the purpose of investigating the case and obtaining a proper explanation. End of section 17.